In other words, if it's a contact swab, maybe the first portion we took had a little more DNA than the second portion. But there was nothing from all of the retesting to date that would suggest a different sample was initially tested than the second round of testing, if that makes sense.
Did you actually figure out where the contamination came from?
It was a screening technician in the laboratory, so someone on staff, and she may have been the one who stocked the tubes, or we don't know how her DNA got into it, but because she typically would not be in the DNA lab.
So, with respect to the actual step in the SOP that the analyst, well, we think, skipped, how do you figure out whether that was done in other cases? I guess just to educate us a little bit about that.
Sure. What's interesting about this is the allegation is that he didn't process a control properly. So any retesting of evidence would not necessarily reveal any additional events of control, misuse of controls. Because every time you re-extract, you create a new set of controls through the process. So by retesting, the DA's office asked us to retest because they did not want to call him to testify. They felt like he would not be a credible witness. So my understanding is the motivation would be to remove him from the chain of custody, essentially. Not necessarily because there's concern about the results that have been issued to date from testing that he was involved in.
Can I ask a question about that? Because, so the issue, I mean, it seems to me the issue they would have with him is a honesty, integrity issue. In other words, it's not a matter of does he know how to do things correctly, but he's admitting to doing something that is a violation of policy.
Correct.
So, but sometimes when we have issues with labs, it's as far as being able to go forward with the case, it's a matter of looking to see if there's another sample that has not been handled that they've touched, because there's kind of this, there tends sometimes even be an overreaction in terms of, well, anything, they were in the room with the sample can't be used anymore. Given that, as far as the retesting goes, so everything that is being retested at the request of the DA's office, most of that stuff I'm assuming then he's had his hands on, or he's been in the room with, he's had some contact with, since the control doesn't limit his, the using the control improperly doesn't really speak to all the other work that he'd done.
Exactly.
Okay.
We re-extracted so the DNA process, it's a multi-step process, and if he was involved at the very beginning, we started the process over. If he was maybe involved with only re-injecting a sample, with permission from the DA, we would say, is it okay if we just re-inject and show that the same results would be obtained? And in most cases, they said yes. Okay. We have been asked to go back and re-extract fully, even though he wasn't involved with that initial process, I believe out of an abundance of caution.
So he's not part of the chain. Is it true then that he's not? There aren't cases where he is a part of the chain of custody where we can't talk about the evidence because he's the first one that either opened it or put hands on it or labeled it? Are there cases that fall in that category?
Yes, sir. And in those cases, we are re-extracting from the beginning. Okay. It has, in a recent court case, defense has tried to suggest that when he had access to that evidence, maybe he contaminated, so any future testing would also be compromised.
Right. Has that been litigated? You say has that been brought into court and defeated?
Yes, sir.
Or?
Yes, sir. It was brought into court. I believe, I don't know, lawyer talk. I believe it was defeated.
Okay.
It wasn't an issue ultimately,
okay.
But defense did bring that up.
In looking at this, it looks like some of the ones that you re-evaluated were at your decision, the lab's decision, some were by request. What the cases that the lab decided to reevaluate, why did you pick those cases?
Sure. Some of the cases when we discovered this issue had not been fully reported out. Okay. And so we chose, let's not issue a report, let's do the retesting. Others, it would be because we had issued a report, but we had received a request for additional testing, and we discovered his involvement, so we just initiated testing. And
if I read this correctly, he made the comment at one time, but then in subsequent interviews he denied that he said all that. That may not be your involvement, but At least that's what I read.
That is correct.
Okay. And I have one other question to ask. If you can explain to us how you can prevent an employee from going wayward, that would be great information since we all have employees. I don't know how you can put enough things in place for some of these. I mean, every lab has the same problem.
One change we did make to the protocol was that in instances of potential contamination, when we have a potential contamination event, we must explore it and try to determine, is it reproducible? Was it something, you know, where along the process did it occur? And so our policy now would have if I'm the one who I might have contaminated it, someone else will investigate it. In other words, I'm not going to be responsible for investigating my contamination event.
How do you determine when the contamination, I mean, who's there that recognizes first the contamination? Is it always a single individual, or does that have to be looked at by a second individual?
It's a really good question because it's hard to answer. We discover the contamination at the end of the process. It's not something we can know until we have the DNA results. And depending on what the contaminating profile is, it's easier to determine where it came from. If I'm the person who extracted, it's my DNA. In all likelihood, I talked over the tube. If it's another sample from that set, it might be that maybe I got DNA in my glove and I introduced it. If it's random from someone else in the laboratory who was not in the area, it really is difficult. Was it in that tube to begin with? And so it's discovered at the end of the process. And the way we explore it is we go backwards. We would first re-inject it. Is it reproducible at that point? If reproducible, we would re-amplify the sample. If, again, reproducible, we have to start over and re-extract. But if I re-inject it and it goes away, it might have been introduced in post-amplification. It's not really part of the sample, and I could use that data for interpretation.
So every lab takes samples before the process goes on from the employees. So they know the profile of the employees, so they should be able to track it back to an employee. Now, sometimes it can occur before people in lab even see the sample, and then it becomes very difficult to determine if it was deliberate or just a random contamination.
So my understanding, but correct me because I could be wrong about this, but retesting is proceeding based on request from the district attorneys who have the cases, is that right?
Some of it was a lab initiated, those cases that had not yet been finalized. But we are receiving requests, and we continue to receive requests from DAs saying, okay, I'm going to trial. Peter was involved. I need you to retest. We, in March, issued to the Harris County District Attorney's Office a list of every single case that he had either extracted, quantified, amplified, or loaded. So they have a list of those cases, and they have notified defense attorneys, when there was a defense attorney, that Peter Lentz was involved.
Do you know which other counties may have had cases besides Harris?
We had one other county, Fort Bend County,
Okay.
and that there was one case, and it has since been retested.
So those are the only counties, so it's a pretty containable situation.
Yes, ma'am.
Do you know who the DA representatives are? Is that in the case material in those emails that we have?
For each individual case?
No, not for each case, but like for Harris County, if I generally wanted to talk to somebody about what they're doing and what their thought process is and how they're doing notification, for example, is there a central, one individual like the general counsel?
Yes, I would contact Dick Bax for Harris County.
And then Fort Bend?
Fort Bend, it was an individual ADA that was involved. I believe his name was Mark Hanna.
Those emails are in.
So with that particular case in Fort Bend, was it the same contamination from an employee?
No, sir, there was no contamination event. It was because Peter had handled a DNA sample. So before trial, they asked us to retest it. We got exactly the same profile. It was a reference sample, so high level, we got the same result.
The reference sample should be single source.
Correct.
So you saw other bands you couldn't account for. So you saw other bands you couldn't account for.
Correct, yes, sir.
Yeah.
So is the retesting process then just ongoing and you'll just accept requests from the DA until there aren't any more requests?
That's been our experience, that as we receive the request, we honor the request to retest.
So out of the 210 cases that he was involved with, what are you down to in terms of retesting?
We have retested, all numbers, I believe it's about 70 cases, it would be on that spreadsheet.
Yeah, that was what, those were where the DAs or somebody called into the Harris County DA's office or Harris County Medical Examiner's office for retesting.
Correct.
Those are all that, so that still leaves approximately 140,
Yes, sir.
so that could take a while,
It could.
if that's the policy you want to follow.
But that's not, I mean, again, there's
That's
no
the worst
telling how many of those are going to need retesting or get a request for retesting.
Right. That's strictly based upon the request that they received.
Robin, how did you, just walk us through, how did you reach the conclusion that indeed this step that he said he skipped to his colleagues, how did you reach the conclusion that that likely did occur? Because it seems like a tricky thing to get to.
It is. It was initially just an allegation, you know, he said, and what I did do was, so the reagent, it's a reagent blank control, and we elute to about 40 microliters of volume of liquid. We take 2 microliters of that for the quantitation step, and then we amplify the max of controls. We just want to make sure there's no contamination. So in theory, after the first round of testing, there would have been about 28 microliters of DNA in the tube. And you lose a little bit with pipetting, so it's difficult to know exactly how much was in the tube. If he re-amplified like he said he did, as the paperwork suggests, if he took another 10 microliters, you would expect 18 microliters or less, given that loss from pipetting transfers. And so I remeasured. I found the tube. I knew where it was. I located the tube, I measured it, and it had a volume that was higher than 18, which would suggest he either did not take 10 microliters, or theoretically, if it eluted at a volume higher than 40 microliters, it is possible he still took 10 twice, and you know, it's still got I still measured the volume I measured. Ideally, I think re-amplification would also suggest if the contamination is still there or not. Because of the potential for charges being filed, we were asked not to do anything with the sample in case retesting needed to be done. The sample is secure, it's sealed, but I think re-amplification would maybe give some more evidence one way or the other if there really was contamination in that tube.
Got it. Okay, so that may still happen. I mean,
It's possible.
and of the various cases that you've had to retest so far, in how many of them will retesting consume the sample? Is that the DA's call whether to go ahead and do it, I imagine?
I believe a lot of them will require consumption. With DNA testing, we're being asked to test very small amounts of samples, so we take up to 1/2 initially. We want to maximize our chances of getting results. And so upon retesting, you only have half of the sample left. And if we did not get a strong DNA profile initially, it would be our recommendation to consume in order to increase our chances of getting the same results. We do not consume without written permission from if there's an attorney involved, it's typically in the form of a court order with both prosecution and defense. If there is no attorney, we would get something in writing from the investigator allowing us to consume the remaining sample.
So of the original 210 samples, how many of the reagent blanks did not have the appropriate amount of DNA just based on quantification?
The reagent blanks, there were no other detected events of contamination.
Okay, so only the samples that had contamination did you potentially measure?
Well, it was that one case that initially the accusation occurred in, and there was, I believe, a very extremely low quantitation value, but upon amplification, we detected that technician's DNA profile. And it's interesting because we had already re-extracted that case before the allegation came to light. And so ultimately, after the allegation, that case was extracted a third time. to remove Peter. Fortunately, in that case, it was blood samples, and so we had a lot of sample,
DNA.
and so consumption was not a need. So.
Any other questions? You know, in retesting the material, it's clear that they followed their written procedures. And the only way that they can continue to do it is if their policy will be to retest everything that an attorney or a court asks them to retest, they'll just have to do that. I don't think they're ever going to, they know what happened, pretty much. I mean, by quantifying how much of the solution was left, they realized that the solution was not taken, 10 microliters was not taken for an amplification. And that's why they would typically got more volume left than there should be if he would have retested. So clearly, he did not retest. That's what it would appear to. That was your conclusion?
Yes, sir.
So just retesting, I'm not sure will solve the problem. The problem occurred. And if that tube somehow is contaminated by another analyst, as long as there's sufficient quantity, they'll always get a result which was inappropriate. They'll see that minor contaminant. That's not going to change. So do you believe your policy will be to retest everything that is asked for by a defense attorney or a court?
Yes, any request will be honored. Yes, sir.
That's as much as they can do. They can't do any more.
Yeah. So I don't see that, at this point, there's anything that they can do.
No,
So
I don't believe so.
And you feel like the corrective action, the policy change, addresses it to the best that it can be? And with short of putting body cams on people?
Right, right. And we've spent a lot of time, shortly after this event occurred, I had a meeting with the entire section making very clear the purpose of the reagent blank and our responsibility to document things properly. And you know, our obligation to you know, the code of ethics that we are bound to. So, like you said, short of body cams, I think we've done what we can.
Without the proper controls, those samples would not be eligible for ENDIS or CODIS.
Correct, correct.
So that's one of the caveats, is that they have to have that in order to get information into the national database or state or local. And without that, they can't legitimately get it in. So they're caught between a rock and a hard place. They're at the liberty of the court and the defense. Anything where they see Peter's name on it, they're going to immediately cry foul. Whether or not anything wrong is done, they're just stuck. And other than taking up a lot of time and money, I mean, it cost all this retesting, it's probably cost you many, many thousands of dollars. And if their policy will be to continue to retest, you know, I don't think that there's anything more that they can do.
We're going to need to make a recommendation, and I don't see there's anything else that they can do.
Right. So we have a recommendation that they've done everything humanly possible other than continue to retest, and I don't think that should necessarily be the burden of them. If that's the policy that they elect to do, it's going to cost them time and money, but they want to do it.
I agree.
So we need a formal vote? Yes. So the motion would be to say that the laboratory has done everything humanly possible. Their policy is to continue to test. If the court or a defense wants the retesting done, they'll continue to do that. But that's as much as they can do.
No further action is
No further
required.
action.
Right.
So it would be to release a letter to the laboratory saying that no further action is required and that the commission understands they'll continue the retesting program.
There's a motion?
Yes.
Second?
I agree.
All in favor, say aye. Aye. Unanimous?
Can we send them a letter of condolences too?
They'll take a check, a very large check.
Thank you.
Thank you very much.
Thank you. Okay, so the next case is 14-21. a disclosure by the Department of Public Safety, DPS Regional Crime Lab in El Paso regarding 2 controlled substance reports issued with incorrect weights. So this is another very lengthy case that involves reweighing a significant amount of drug material. And it appears that everything that I've seen suggests that the major problem was that sheet that they essentially somehow forced to copy, and they didn't always copy it correctly. They didn't fill out the sheet properly. And there was minor errors that really were pasting of the wrong information into a prior worksheet. However, in doing all this, they decided to get rid of the worksheet, so they eliminated the problem.
Yeah, I think it's automatically, it's in LIMS now to where you don't have that sheet at all. It automatically downloads into it, which takes the copy-paste issue completely away.
So we have a member of the laboratory here, Alice Amelot. And Brady Mills is out of the country. Alice just got promoted to a position in the Austin laboratory.
You have our condolences.
But she did run the DPS lab, regional lab in El Paso, and managed all of the corrective work relating to this disclosure. I don't know if everybody has this, you should, but there's an updated, we got over the weekend, an updated description of the various corrective actions that have been taken, the assessment of the work product, the reweighing by the Lubbock lab, et cetera, et cetera. So, Alice, would it be okay for you to just briefly tell us, you know, what this process entailed, just go over the update, what you did, what the results are?
So essentially, we've completed the investigative process of the reanalysis. We've broken it down into 4 different phases. I believe you've already been briefed on phase 1. Phase 1 included after the customer notification. We looked at 100 cases that analyst had worked in the last year. During that year, she was working by herself due to a retirement. So instead of 2 personnel working cases, it was 1, and she was splitting her time between 2 different disciplines. She had worked approximately 300 cases during that time. We had 100 cases still in-house, so we pulled those, and the DPS Lubbock lab reweighed those cases. From that reweighing event, we issued 6 total amended reports in that phase 1. Because we wanted to investigate further, phase 2 was a case file comparison of the other approximately 200 cases she had completed during that time. The phase 2 submission form comparison result was that we had to issue another amended report due to a weighing inaccuracy. So then our department requires a quarterly reanalysis of a drug case that each drug chemist in our system has worked. So we reviewed all of the available quarterly reanalysis data on this analyst, and she had passed it all sufficiently, and she had passed all of her proficiency tests. Because we thought this was a copy-paste issue that may have originated when we put computers on the bench, we put the computers on the bench because we were going to a new laboratory information management system. We rolled those out in the El Paso lab in March 2012, so phase 4 involved pushing the investigation to a start date of March 2012. And when we did the paper file comparison of that, we identified 3 cases that appeared to be inconsistent, but because of the age of the cases, we reached out to the customer, and the customer had already destroyed the evidence. So we called those inconclusive because we aren't sure if indeed there was a weighing issue. But in that review, we did identify 1 case that required an amended report because the analyst had done arithmetic wrong, and that had not been caught during technical review. So at the completion of phase 4, we reached out to a subject matter expert in the field outside of our agency and asked, in their opinion, have we done enough? What should be the next phase? And in their opinion, they felt it was sufficient that we could stop at this point and present our results and start discussing preventative measures as a system to our accrediting body. We haven't presented those preventative measures yet. We were given a 30-day extension. Our new deadline is February 20th. So the investigative portion has ended. We're working with the Controlled Substance Advisory Board to develop preventative measures.
There were a couple of cases that it wasn't simply weight. There were some mistakes in terms of the drug that was tested.
There was never an identification issue. The instrumental analysis was accurate.
Okay.
The issue was, in some cases, we couldn't identify, it didn't appear to be copy-paste. We couldn't identify where that weight had come from.
Right.
So we weren't sure if it was her process or if it was a copy-paste.
Or arithmetic.
The arithmetic we can confirm. So we verified it wasn't arithmetic except in that one case.
So in those cases where you couldn't confirm, did it at all alter the final charges?
It did not. In those cases, in every one of these cases, the customer was contacted and the relevant district attorney's office was contacted, and none of them had an adverse effect to a defendant. A lot of them were non-arrest cases or cases which never ended up in the district attorney's office. So to our knowledge, based on customer communication, each of these amended reports, there's been no adverse effect.
Do you know offhand which DAs, obviously El Paso?
El Paso was all of them with the exception of the very first case, which was in Alpine, and in that case, the error was detected before it went to trial.
So a total of how many cases did you issue amended reports?
8.
And each of those 8 cases, it did not affect the ultimate charges against the individual.
That's correct, sir.
Do you feel as though there's anything left to do?
I don't believe so. This analyst is no longer employed with the department, and the issue was discovered after her voluntary resignation.
And is there any reason to believe that she did anything, that she just resigned because she was afraid this would come out?
I don't believe so. To my knowledge, it was due to a family relocation event.
Okay. So you believe that by February, I'm sorry, I didn't get the date,
20th?
20th, you'll have redone, retested everything that can be humanly retested?
Yes, sir. We have no plans to do any additional retesting at this phase unless that recommendation is given to us.
You'll submit corrective action, some sort of document to AskCloud Lab?
Yes,
by the
ma'am.
20th?
Yes.
And would you copy us on that?
Yes.
Based upon that, I'm not sure that there's anything else we need to do. I think they've done everything.
I think it would be worthwhile to get a copy of what they plan to do, but as far as investigation goes, I don't, I don't think there's anything else they need to do either.
So I move that no further action be taken.
Second.
Motion to not to suggest that they do anything further and give them a letter after we've seen the documentation.
Unanimous.
Unanimous. Thank you.
Thank you.
Okay. Juggling the sheets. Okay, the next complaint was 14-22, a complaint by Gregory Bowman alleging that NMS Laboratories failed to use scientifically accepted standards in its toxicology analysis, resulting in the conviction of defendant Matthew Bowman for violations of the Occupational Safety and Health Act. Dr. Bernard, you feel comfortable to?
Yeah, the subsequent NMS report that we just got, I would, not having the chance to review what their response is, I think it probably merits that. I have, after having looked at this, there's a couple of issues which to me are problematic, one of which is that the ultimate decision lies with the medical examiner in terms of interpreting. And that not knowing that that this compound can be generated post-mortem falls to the medical examiner, not to the laboratory. Whether accepting the specimen in the wrong container for analysis, that may be an issue whether the laboratory should accept it or not. They certainly ran it. The reports that I looked at, they are giving information back that are basically saying these have been reported. I did not see anything that said they concluded that this meant that person died from the hydrogen sulfide exposure. But I wanted to see their letter and then go back and compare, and I haven't had time to do that since we just got this. But my ultimate belief is that the medical examiner bears the responsibility for taking the results. I certainly have been in the same position where you need some guidance, and I think he asked for that. But you have to take the investigative circumstances, one of which was that you have kind of some disparate investigative information. One said that she was right up there and he never opened the top and then he collapsed. And he says he smells gas or whatever, but the first result was negative. It can generate postmortem. One that was evaluated like 4 months later, sent to him, I wouldn't put any weight on that whatsoever. The guy has a 470-gram heart, which he puts myocardiomegaly. That's substantially enlarged. So I think really this falls back to the medical examiner. But again, I really want to kind of compare what they're saying in their response to what the allegation is. But that's my first take on this, is that this is a medical examiner responsibility, and while you get guidance from the toxicologist, the ultimate call is the medical examiner's.
And that's
and I think the second one is very clear. He was not exposed, and they're giving a response which says these levels have been seen people exposed. Well, okay, but the investigation on the second case, the guy's got substantially bad coronary artery disease. He collapses, and I would probably not have even run that level. So I think this really is a medical examiner issue more so than the laboratory issue. My feeling.
So based upon what you said, I guess the first question is, do you think reevaluating this next meeting would be of any help to you?
Yeah, I would like to sit down and really compare the two, but that's my gut first take on this.
And for us, that's probably the most reasonable, is to let you just reread and do the comparison.
Yep.
Do we need a motion to hold this over to the next meeting? And I make that motion.
To recommend.
I recommend that we recommend to the full committee that we hold this over to the next meeting. So, Dr. Bernard,
Do we have a second?
Yep. Bob?
Can he second? Since it was sort of his motion? Or do I have to second?
You can second.
I'll second.
Okay.
So the motion is that we allow Dr. Bernard sufficient time to reevaluate and do the comparisons and then report back at the next meeting.
In favor?
Okay, unanimous. Okay, the last of our complaint was 15-01, a complaint by inmate Sharif H. Dean alleging Orchid Cellmark Laboratories DNA section failed to test certain items of evidence and requesting retesting of certain evidentiary items that were improperly analyzed in his criminal case. If I remember correctly, So in August of 2011, August 25th, Sharif H. Dean was sentenced to life in prison for the murder of his brother-in-law, Ronnie Kemp. The state obtained an enhanced conviction for Dean because he had 2 prior felony convictions. Dean pleaded not guilty. The charge went to trial. At trial, testimony revealed Dean and Kemp were both drug dealers, but Kemp had become a confidential informant for the Tyler Police Department. Several eyewitnesses testified Dean shot Kemp. Orchid, Silmark, and Dallas tested 26 items of evidence for DNA results. Several of the items were consistent with Dean's DNA. One of the results indicated a mixture of at least 2 contributors, indicating at least 1 male, and Dean cannot be excluded as a possible contributor. The complaint alleges Orchid Silmark was negligent in not testing all of the evidence collected and asserts that additional DNA testing would exonerate him. He requests retesting of items for DNA as well as the testing of additional items that were inconclusive or not tested by Orchid. The complainant does not have any specific allegation of negligence or misconduct in the DNA testing performed by the laboratory, but requires additional DNA testing or retesting of previously tested evidence. Staff recommends, so that's really the basis. And the question is there anything that the commission could do to facilitate any additional testing, or just recommended the additional request for additional testing back to the trial court? And if they want it done, let it be done.
I don't see any real, even though you're using the word to call it that, I don't see any negligence or misconduct, so I don't really think I think the proper thing is to recommend dismissal, recommend to the full committee that this complaint be dismissed.
Tracy died,
Oh, yeah.
so maybe,
Yeah, I gotta accuse myself, I guess,
Okay.
on that.
Okay.
What did I miss there?
that Swift did the autopsy.
Okay.
I think what we would recommend is referring this to the various innocence clinics to assess it and determine whether there's any grounds for requesting additional retesting, which is, I think, the crux of what he wants, is
Right.
retesting of evidence that's already been tested, as well as testing of evidence that they did not initially test.
Okay. I agree.
I agree too. So that would be the motion, that the best we could do at this particular junction is to ask the different innocence projects to take a look at this case and evaluate the case, and then if they feel it's appropriate, to then ask Orchid Silmark to do additional testing on evidence that they hadn't tested previously.
So that's your motion?
Yes.
A second.
Well,
He's out, so.
Okay, I'll second.
Okay.
So,
yeah, the
unanimous.
issue wasn't the lab. I mean, the issue wasn't my office,
No, it
but
was,
still.
but, yeah.
Okay.
Okay.
Hello, they say in Spanish. Do you want to adjourn?
Sure, unless there's anything else that we need to consider, then I make a motion that at, oops, what time is it? 8:41, that the screening committee is adjourned.
Second.
Third. All right, so we can report to the whole commission that for all of this, we have basically one major recommendation, and the other cases, we believe, when we have the documentation, have been sufficiently taken care of based upon the fact that there's really nothing left they can do.
Okay. So, break before we start.
9 o'clock. The very first item on the agenda is to introduce our new commissioner, Dr. Cherie Hughes Stam, who's here with us from Sam Houston University. Her bio is in your packet. I know you all know who she is. And did you want to say anything about your expectations, how much you look forward to being on the commission? All that?
I know I've got huge shoes to fill with replacing Dr. Kerrigan for this next term, and I really look forward to being able to contribute to, making forensics the best it can be in our state. So I really look forward to the opportunity.
And Dr. Hugh Stamm is an expert in both DNA and forensic anthropology. So we have two forensic disciplines represented by her expertise, so that's great. And the connection with Sam Houston University, which is always good. So welcome, thank you so much.
Welcome.
The next item is a review and adoption of the minutes. Has everybody reviewed that thoroughly? Any comments? Oh, I think I would like to say one thing at the beginning. Having sat on the side there and listened, I realized that if you want to be heard by your audience, you have to talk loud. Because a lot of the people was, I thought that was, so I think we have to
Yell?
shout aloud.
Okay.
Yes. Okay. You want to make any comments on the minutes?
No.
Okay.
There was a motion made?
Yeah.
Motion and seconded?
Second. Aye.
Aye.
Nay. Adopted unanimously. Now, the next is the administrative update.
Okay, so we received an explanation from Sam Houston about what happened with the commission's allocation of fringe benefits. And this explanation came from Aaron LeMay, who is the controller for the entire Sam Houston State University. And you can see the email correspondence in here. And I think what happened was that the commission, they just realized recently that the commission's benefits could be funded out of the one fund. And so they started doing that when they realized it. But it doesn't seem like prior to that the funds were being reappropriated elsewhere. It's just that this is a process that started fairly recently. And so now we don't have to allocate as much for benefits as what we used to.
Would they reimburse? Would they?
I think that ship has sailed. I don't think you get to be reimbursed for prior years. Anything that's left over that we didn't take advantage of, so to speak, it just goes back. But what they realized that we're not like CMIT and LEMIT, which are the entities that do a lot of law enforcement training across the state. We are actually a general appropriation line item that is a special item. So they're taking advantage now of the fact that the benefits can be funded by the one fund where they weren't previously. Does that make sense? Hopefully. Does anyone want, do people feel like the explanation that we received is sufficient? Do you want it in a letter? Or do you think this is okay?
I just wanted them to tell us that we can't reimburse you in writing. I would still like you to pursue that.
Okay.
As much as I agree with Dr. Perwani, I'm fairly certain that since I belong to a state entity, the money you get from the state is for a biennium, and if it's not spent, you lose it. So I'm pretty sure that's the case.
I will ask and get them to write, to
Just
state
for
it.
our records.
Okay. So in terms of data management, our database that we're going to be using to track cases is up and running, so that's great news. The big challenge is moving data currently stored on computers in files. It's all organized, but transitioning all that data into the database is a real challenge. So that's transitioning into one of the other items why we're planning to hire an administrative staffer. We've gone through the process of creating that job description. I checked on it yesterday, and they're about to post it. So once they post it, we'll interview candidates. It's for a part-time temporary position. why we have to go through all this for a part-time temporary position, I'm not sure, but those are the state rules, so that's what we'll do. And that position will expire at the end of the year unless we ask the university to repost. And so the reason it will expire is so that we can do an assessment of whether we want to continue with the individual we hire, whether we think their hours should be expanded, decreased, whether they're not necessary anymore. If it's not the right fit, then we can hire somebody else. We do have someone in mind who is a person that Lee and I worked with at the law firm we worked with in our lives prior to the commission. She set up the entire administrative system in that law firm, and it was outstanding. I mean, there was never a piece of paper that you lost. It was, you could always put your hands on everything. I'm not sure if I think she'll be available to do some of the work, and I'm just not sure exactly what, we have to go through the interview process and see what other candidates are out there, what other possibilities there are. I'm hoping that she will apply.
It's an hourly salary, right? Should be paid based on hourly.
Yes, it's an hourly rate. $20 an hour.
$20? That's a bargain.
It would be a bargain. We'll see if we
I hope
can.
she's not listening to us.
We'll see if we can get her. She really loves Lee and me because we all worked together for so long, and so I think she's going to try to help us out if she can. Well, I'm just not sure what other competing demands she has. But she is a very senior paralegal who has intellectual property was the main area that she came out of. She did large-scale complex litigation for most of her career. That really puts you in a really good mindset for being able to organize and track information, which is, as you can tell by the size of our binders, we have a lot of documents, and we always want to be able to put our hands on everything we have so that we can respond appropriately to PIA requests and everything else that is our obligation as a state entity.
Lane, one more question. Do we have to make space for her or would she work from her home?
So we would have to ask Brad Levinson from the Office of Capital Writs to take his legal assistant, who's currently in the extra space we have, and put her in new space they're getting. I haven't talked to Brad about that yet, only because, I don't want we have to get her hired first. But he told me at a holiday party that they invited us to, which was very nice, that they are getting more space. The Real Estate Commission is moving off of our floor into new space, so they're going to take over some of that space, which means it should all work out.
Okay.
We should be able to put her in the it's almost like reception area space that we have. Our space is very nice, but it's a little awkwardly designed. So, but she would have a desk to sit at, a computer, and so forth.
We already have the computers and everything in place, so we have to buy.
Did you order the?
No, but we'd like to order a computer for her.
That is in our budget.
That's in our budget, okay.
So have you been preparing yourself for this move into more electronic? So do you have that capacity?
Yes, that's why we developed that database, is to get everything into a searchable format. So if somebody asks for a complaint from 7 years ago, we just type in some search fields and it comes up with all of the associated attachments. That's already the way we store the information. I mean, Lee never throws out any originals that she receives. That all is in the file, but we also want the capacity to search for all toxicology complaints from 2008 through 2012, and the database will allow us to do that very easily instead of having to go through each folder for each complaint that we've received and figure out. We have a spreadsheet that also tracks that information, but it's a lot easier to do it using a database with designed fields and search functions and so forth. And then the annual report is up on our website. We made some design changes to the look of it. It looks very similar to this report that Pat Johnson's going to talk to us about later. We were thinking about actually moving to this as a cover for all of our reports because Lee and I at least really liked the look of it, but we wanted to get your thoughts about, you know, did you like the annual report, both in terms of content and design? Do you think this is a nice cover?
I think the cover is just fantastic. And the report was very good. Thank you.
Yeah, I think you can go.
Okay, so everyone's.
I don't think we have to vote on.
Okay, but isn't it pretty? I just. Very nice. Okay, do you have anything else, Lee?
Just the copier upgrade. Lynn and I plan to upgrade our copier. We'd like to get your approval to do that. I got to go to the copier facility and see all the new copiers that are available. And bottom line is, if we want to upgrade, really upgrade to where we're increasing our productivity level when we're printing these binders and stuff, we would have to increase that budget area by about $7,000. So it would double what we spend on copying already.
Would this be a combination copier and digital scanner?
It does everything.
Okay.
Anything you can think of, it can scan, email it to you, it can fax to email.
Does it say what you copy to a file?
Yes, it does.
So you could access that file as an electronic copy as well?
It even has the capacity to punch and bind this type of binder, which it takes a long time to make these binders that we send to y'all. It takes a lot of Lee's.
So what is Lee going to do with all the extra time?
Work on investigations.
I did look at a 3D printer, which was really cool. It printed a stiletto when I was there, but it was out of our price range.
Did you bring the stiletto with you?
Well, if the state reimburses us, we can buy it.
Yeah.
Do we need to vote on this?
I think just generally,
I would
if you're,
think so, right?
yeah, I think it's a pretty significant expense, and I think it is contained within the budget information that you have in your packet. So if you vote to approve the budget as it's currently set forth here, that will encompass the copier.
Anyone want to make a motion?
Second.
Aye.
Aye.
Nay. Unanimous. Next topic has to do with the screening committee, which is meeting today.
All right.
Dr. Eisenberg.
Yes, sir. So the screening committee was called to order at 8 o'clock almost precisely, and we had 4 complaints. Most of them carried over from the last meeting that we discussed. The first one was 14-16, disclosure by the Houston Forensic Science Center, HFSC, regarding Peter Lentz's omission of a step in the laboratory standard operating procedure related to proper handling of a reagent blank. With the help of people from Harris County, all the questions that the committee had were completely answered. Basically, the bottom line was that this was really a one-time, or at least as far as they could tell, one-time activity where he failed to properly amplify the reagent blank in each of the cases that he was involved. This ultimately meant that he was involved in over 210 cases, which the laboratory has made it available to anyone, any defense attorney, any court, to request that testing be repeated. Essentially what they were doing was they were going back and repeating the amplification of the reagent blank controls. The reason this was done is that NDIS, the National DNA Indexing System, requires that the reagent blank controls be available for uploading any data into CODIS or NDIS. Without it, the data can't be uploaded, which really defeats the purpose of the database. They spent an incredible amount of time and money, which they prefer not to look back, how much this case actually wound up costing them. And the realization is that any analyst who is intimately involved in casework, if he or she fails to do what they're assigned to do, then there's a real problem. Since the reagent blank controls are an absolute necessity, that needed to be done. So what they wound up doing is they had to repeat cases that perhaps there was no reason to repeat. Just because he was involved, there was the justification that they had to do it. And that justification so far has been asked for in about 70 cases or so that they've been able to do. And their feeling is that it will only end when all the cases have been properly repeated and all the answers to their questions be asked and answered. So the question before the screening committee was whether or not we felt as though they did everything humanly possible to answer the question about Peter Lintz's involvement in these cases, and did they do everything that needed to be done? And the answer to that question is, as far as we can tell, yes. They've done everything humanly possible they could do. Everything more that they can do, they will do, is that they would still respond to any requests from the defense or the court, any questions involving cases he handled. And essentially what was the problem was that in the reagent blank controls, the substrate controls, he failed to amplify samples that he was asked to do. Whether he readily admitted it, he finally admitted that that was the case. The laboratory had the documentation. They went back and they re-quanted the samples. So they realized that 2 microliters were used for quantification, and then every time they amplified, they took another 10 microliters. They typically eluded the reagent blank substrate controls in 40 microliters. So after the first amplification, they took 2 plus 10, so they took essentially 12 microliters, so there should have been left about 28 microliters. The next retest or reamplification that they were asked to do would have used another 10 microliters, so that after the second amplification, they would have consumed 22 microliters. And the only thing he really failed to do was adjust the volumes, and they readily were able to figure out that that was the problem, that he did not use the appropriate amount of sample as he indicated was amplified. So everything that they can do, they really did. They checked each and every sample, they measured the quantity of the sample left, and they found that the volumes didn't jive with his response that he re-amplified the controls. So the opinion of the committee was that the laboratory had performed everything possible in their powers to do, that anything else, essentially, they will do. They've admitted to doing that. They admitted to giving us a report. They got an extension on ASCLAD that till February 20th, where they'll indicate that they've done all the retesting that they've asked to do, but they'll continue to do more if that's something that comes to their laboratory. In essence, they're probably wasting money, but the wise decision is to continue what they're doing, is to continue to retest. And so the committee felt as though they made every effort.
Just as a correction, there is no February 20th. That's a different complaint.
Oh. Oh, okay.
That's DPS's.
Okay, sorry. I didn't write fast enough. But they've still agreed to retest everything that comes before the Houston laboratory. They'll continue to do that until they've exhausted all potential complaints or requests. And so the committee unanimously voted that they've made every possible testing avenue available to the court and to defense, and that they don't believe that there is any real reason to sanction them any further, that they made every effort. So the committee voted to accept their recommendation that they've completed the necessary testing, but as I said, they'll continue to do anything that comes before them, but any further obligation that the committee makes is not necessary.
2 points that I wanted to bring forward from last time is that the Harris County DA had impaneled a grand jury for this case, and the examiner was no bill.
Right.
So this already worked its way through the chains in Harris County. The other point that came out today that I think is important is that the 2 counties affected, just 2 DAs, so Harris County and Fort Bend County. And in Fort Bend, it was just 1 case. So the bulk of these are Harris County cases. So the upside to that is that notification issues are really centralized when you only have mostly one county.
Right. And so that court system really knows that everything humanly possible has been done. So whether or not they receive any more requests, that will depend upon the DA or the defense. But at least in terms of the DA, they're all aware of what they've done so far. And it's not been trivial. To do the amount of work that they've done in these cases is probably 50 to 100,000 at a minimum, not counting the labor costs. Just reagent costs themselves are significant. And they've been more than willing to put every effort into putting this behind them.
So the committee is satisfied with the internal review and the corrective action
Yes.
adopted?
And we had examples of all the retesting that had been done to date, and it seemed more than sufficient. So what they found was that really was a failure to do the reamplifications.
The corrective action, the main crux of it is that where there's a contamination event, the person who, there'll be an independent person who takes a look at it and does the reamplifications and so forth, rather than just having it handled by that one person where there might be an incentive to cut corners or shortcuts. Was that a fair way to state it?
Yes, other than having analysts wear camera systems and have a second person to monitor there's nothing they can do to prevent this. If an analyst is smart enough and chooses not to do the work, it's something almost impossible to catch. And in this situation, very difficult. They have the documentation that the additional sample had not been used, but other than an admission, and he admitted to what he did.
One of the challenges I think they've had is the question of consuming samples and retesting. And so there's been a lot of back and forth, I think, with the DA's office, defense counsel, about whether to go ahead and retest, or whether they should do it, or they have to get court orders for a lot of these, I think. So that piece of it's been a challenge, I think.
Right. But they blanketly said that if they do get any requests, they will repeat everything. And they've been doing that upon request.
Dr. Eisenberg, I didn't get a chance to go through this very large Excel spreadsheet. Could you very briefly tell us what other kinds of non-conformances they were reported?
Well, it's really hard, I looked at this. Essentially, what the non-conformances was, for every sample, they have to do essentially a reagent blank control, which is an extraction. In one of the cases, a tube was probably contaminated not by Peter Lintz, but somehow another analyst who was involved in essentially cleaning the tubes or putting the tubes aside for testing. So there was a contamination, and the contamination was traced back to another analyst. So it was nothing that he necessarily did. But what he didn't do was what he was asked to do, is once the contamination was seen in the reagent blank, he didn't reamplify. Should have gotten the same exact result, but he had to do the work. And he essentially failed to do the work. He failed to reamplify the extract, and that was the major thing. So after the sample should have been re-extracted and re-quantified and then re-amplified and run on the CE instrument, then that would have been it. He would have been found to be sort of non-compliant based upon the fact he didn't do that work. And the allegation was potentially that because he failed to do the work, he lied on documents where he attested that the work was done. So that was the major problem. It wasn't that he specifically contaminated anything. He probably had nothing to do with the contamination. But once the contamination was found, he had an obligation to go back to the reagent blank control and reamplify that. That's the part he didn't do, either because that would have given him another mark against his record, or he just didn't want to take the time to do it. So he essentially lied and said he did the work.
I was asking about the other nonconformances they discovered on review of the cases.
Well, the major nonconformance was the fact that he failed to do the retesting. All the results appeared to be, when the samples were retested, they appeared to be exactly the same.
So I think Dr. Pirwani is referring to that, you see the results not concordant in the far right, and I think what was explained to us by the section supervisor who was here this morning is that sometimes when they do the retesting, the results are not concordant simply because
It's too little sample.
it's too little sample to exactly match them, but not because of an error in identifying.
Right.
Is that?
Yes, so when you amplify something with low quantity, you can get, essentially just based upon the first amplification, you don't get the exact same results. And so, although in general the results were very similar, they could not be concordant. That is, you may get one allele, you may get another allele, you may get two alleles. That's why it's called non-concordant. But it wasn't anything that he did other than not doing his job.
Move to accept the subcommittee recommendation that the laboratory be notified that no further action is necessary other than testing as requested.
And they were going to provide us with a report to what they've completed.
I second it.
Aye.
Aye.
Nay. Unanimous.
Okay, so the next case was one that I got ahead of myself. It was 14-21 DPS El Paso controlled substance case. Essentially with this case, they had a computer that was put into the laboratory where they had the ability to copy and paste into reports. And this copy and pasting turned out to be a problem because they were copying and pasting things from different cases into new cases. And they had a lot of cases done by a particular analyst who retired during this time period. She had worked several hundred cases. They went back and they were able to tell every case that she worked. She did not have somebody who worked along with her because she had resigned from her position, and they elected to only keep one person reviewing the cases. So the biggest problem was this copying and pasting, which during the process of this they realized that was the problem. It was more of a administrative, it wasn't anything technical, it was just this improper copying and pasting. And they've gone back and they've rechecked all the cases that they could. They got an extension from Askeladd Lab till February 20th. Thank you. And they have no plans to do any further retesting. And they're going to provide us with the document that they sent to Askeladd, and just indicating that everything that could be done has already been done. There were 8 amended cases that they ultimately did not affect the charges that were filed against the particular defendant. But there was anything, it was just more of this pasting and that was amended, or they found out that wasn't proper. So there are 8 cases that the results changed, but it did not affect the charges against the defendants. So everything that could have been done has been done, and before February 20th, they're going to provide the commission with a report indicating everything that they did in this particular case. And so we felt as though, based upon this information, they should not be held to any further work.
We do have a representative from the laboratory here.
Okay.
Did everyone get this 2-pager that updates the commission on all of the reweighing that they did?
Yeah.
Alex, do you want to just give a brief rundown of this? Because I think it would be helpful for commissioners who weren't at complaint screening to hear what they've done and the thought process.
Sure. So upon notification by the customer of what the customer thought was a wrong weight reported, we initiated an investigation. We separated it into phases. The first phase was looking at approximately 1/3 of the cases that that particular forensic scientist had worked during the year where she was the lone forensic scientist in the controlled substance discipline. Of the approximately 1/3 of those cases, of the 100 cases, we had to issue 6 total amended reports. They were all reweigh issues. 3 of those we could identify for certain that they were copy-paste issues. So the next phase we went to was we reviewed the remaining 2/3 of the cases that the analyst had worked. This wasn't an actual resubmission event. We were reviewing the files and the paperwork, comparing the customer estimated weights with the reported weights. When there was a discrepancy, we asked them to resubmit the evidence. As a result of phase 2, we had 1 additional amended report, which appeared also to be a copy-paste issue from one case to another. Phase 3, we looked at all of the available quarterly reanalysis data. Our system requires that every forensic scientist working in the controlled substance discipline, each quarter has 1 of their cases reworked by another analyst independently. Of all the quarterly reanalysis data available for 2012 and 2013, her records showed consistent, satisfactory results, and all of her proficiency tests showed satisfactory results. We moved back to phase 4, starting with reviewing cases beginning in March 2012. We picked that date because that was the date we installed computers on the benches in the laboratory, thinking the source of the copy-paste started with the computers. In reviewing the files, we followed a sampling plan. Following the sampling plan, 1 of the cases of the 28 we examined required an amended report. That was not due to a copy-paste issue, that was actually an arithmetic issue. So as a result, 8 amended reports were issued. In each case, the customer and the relevant district attorney was contacted to evaluate the effect on the judicial process, and in each of those cases, there was no direct effect to the defendant. They were either caught before prosecution, or these cases were not presented to the attorney's office, or they were non-arrest cases. So at this point, we're evaluating preventative measures for the rest of the system, not just to implement in the El Paso laboratory, but to apply those preventative measures to all 13 of our controlled substance laboratories.
But you're absolutely sure that anything that could be done has been done, and you're simply awaiting an issuance of what you just described as a report that was summarized, and all the corrective actions that you were able to make have been done. And then further, the computers have been removed, so the potential for other copy-paste errors has been minimized and nullified.
It's been minimized. We still use computers in the laboratory, but we've implemented a new software system, so this worksheet is no longer in use primarily.
Okay.
I have a question. How do you know that this is only with 1 analyst? And was it only 1 analyst that was doing this, cutting and pasting, or could be the other ones, they do the same thing too?
Of course, it's always a possibility. This is the only complaint that we've received in the system from a customer. So to our knowledge, this is the only one. And the quarterly reanalysis that we do for every controlled substance analyst in the system hasn't revealed a similar issue.
And this analyst subsequently retired from the DPS?
She resigned voluntarily
Right.
before this was even detected.
So the Complaint Screen Committee, in this particular case, agreed that everything humanly possible has been done. We're willing to essentially provide a letter upon the receipt from the DPS lab of everything that you just heard about, and that we don't believe that there's any requirement for retesting should continue. It's all been done. So essentially, we moved that there's no need to repeat anything further at this particular point in time.
And they'll share the copy of what they submit to ASCLD Lab.
Right. The recommendation is that they've fulfilled their obligation to to investigate, and there should be no further investigation of this particular complaint.
I second.
All those in favor?
Sorry, I'm daydreaming. Okay, anyone want to second it?
Yep,
It was
seconded,
It was
yeah.
seconded.
Second,
Take a vote.
good, then let's vote.
Aye.
Aye. Nay? Okay.
The third complaint
Yeah, third complaint.
that we evaluated was complaint 14-22. The complaint was from Gregory Bowman alleging NMS Laboratories failed to use scientifically accepted standards in its toxicology analysis, resulting in the conviction of defendant Matthew Bowman for violations of the Occupational Safety and Health Act, OSHA. So in this particular case, we just received a printed copy this morning. So Dr. Bernard has asked that he take the lead in this particular case, but since we just received the complaint, he needs sufficient time to go through the complaint and further evaluate all the potential suggestions or comments that have been made, and he believes that this can be done by the next commission meeting. So the committee voted and agreed to give him sufficient time to evaluate this case, comparing all the things that the different groups brought forward against NMS Laboratories. So that was the motion that we voted on and agreed to.
So just to be clear, we actually received the complaint in October. We received the laboratory's response on the 19th of January, and they have a fairly detailed response outlining what it was that they did, what the rationale was for the analysis, and so forth. So I think the thought was that Dr. Bernard would go through and compare the extensive documentation that was provided with the initial complaint and the laboratory's description of the rationale for their results and come back with a recommendation or discussion points for the next meeting. Did anyone want to talk about?
Besides the laboratory, they had actually the medical examiner's deposition and all of the information.
So-
It's a lengthy deposition.
Right. So one of the questions is, should this actually come before the complaint screening committee? Because ultimately, it's the medical examiner's choice that the material was used by him or her, and that our commission should not be dealing with decisions made by a medical examiner. So,
It's an interesting question.
right. So Dr. Bernard is willing to take the time to go step by step and look at both opinions and then come to some type of recommendation that will present at the next committee meeting.
I think under the rule, we are only obligated to investigate the lab.
Yep.
The lab made any errors or mistakes, so then we are obligated to investigate that. But what the medical examiner chooses to use as forming his opinion is totally outside our.
Well, that's really what I want
Responsibility.
to take a look at. How much is laboratory versus decision-making by someone that we don't address at the current time in the commission?
That communication was handed out to everybody, if the other people don't realize it. It is a little extensive.
It's front and back, probably at least 100 pages. There were some scientific articles where they were addressing whether or not it was the appropriate sample, when was that sample provided, and it really needs to be looked at.
There's also some scientific articles in
Right.
there, and some report of some studies that they had done internally. So,
Okay.
So the committee voted to,
make a motion to.
Table it?
yeah.
Continue this to the
Right.
next meeting.
To the next meeting. That was the motion. We give Dr. Bernard sufficient time to compare the material that was presented more recently, that we got a hard copy of, and essentially go step by step and evaluate the responses that involves some scientific data.
And you'll second it.
I'll second.
Somebody needs to make the motion that's not Dr. DeMaio.
Right.
So
So move to table.
Oh,
to the
okay, I
next
thought,
Mm-hmm.
okay.
I'll move the table item to the next meeting.
I second that.
Okay, aye?
Aye.
Nay?
All right, the last complaint that we evaluated was 15-01, was a complaint by inmate Sharif H. Dean alleging Orchid Solmark Laboratories DNA section failed to test certain items of evidence, and they had requested retesting of certain evidentiary items that were improperly analyzed in his criminal case. So Orchid Solmark was hired to test the evidence, and the claim is nothing specific. There was a claim that they failed to test certain items of evidence. It seems like they tested a lot, but they're claiming that there were certain key pieces that they felt were not tested and improperly analyzed. So there was no formal complaint of negligence or misconduct on behalf of Orchid Solmark. They just wanted more additional pieces of evidence tested. And in essence, we felt as though this is not a formal complaint where they were alleging any type of negligence or misconduct, that they really needed to go to the court and make the request of the court to test any further information. It's not clear what they were looking for, but if that's their request, we believe that they should have done that rather than bringing it to the Forensic Science Commission to specifically ask that certain pieces of evidence be retested. More than likely, there's nothing else that they would find, but that's up to the court to make that decision, not to the commission.
So do I understand that the complaint is that not all the samples were tested? Is that
Yes.
what it is all about?
Yes, that's what it's all about.
Which really doesn't involve us.
Right.
So someone want to make a motion to,
Dismiss.
okay? Second?
Second.
Aye?
Aye.
Nay?
So that concludes the work this morning. We adjourned at about 8:45, and we reviewed each of the cases that came before the screening committee at this particular time.
Good work, Dr. Eisenberg. Thank you.
You're welcome.
So next section is, well, is the update on the arson.
Good morning, Commissioners. Nick Goebbels with the Innocence Project of Texas. Not a whole lot to update since the last meeting. We have no new cases that we have submitted to the State Fire Marshal's Office for review. We have one transcript we're reviewing right now, but we've not found any new cases that need to be looked at. As for the 5 cases that the State Fire Marshal's Office was unable to support the investigation on, one of those cases was getting ready for retrial at the time of the last meeting. That's the Ed Graff case. Since then, he pled guilty and was up for mandatory parole, so he is now out at a halfway house. One of the other cases, the Sonia Casey case, we're currently awaiting the findings from the trial court on that case. The 3 other ones were in early stages of preparing those for litigation. Out of the 2 cases where there were inconclusive findings, one of the attorneys for one of those individuals provided us further information. It has been forwarded on to the State Fire Marshal's Office. I'm not sure if it's going to make a difference in whether or not they're going to be able to reach a conclusion about the original investigation, but we have passed that information on. Otherwise, it is still status quo, or any case that comes along that needs to be reviewed, we're reviewing it, and if we find issues, we'll submit it to the Fire Marshal's Office for review. Otherwise, that's it.
How many total cases did you review in the end?
We ended up, I think so far with transcript review, we've read around 36 transcripts. So it's still, though, at the 9 cases that were submitted to the Science Advisory Work Group.
But the original group was over 1,000.
Yeah, we surveyed roughly 1,100 people in TDC. And then we sent out around 300 questionnaires.
So that's a real small percentage.
It is, and we're still, we still get questionnaires back from those original questionnaires we sent out. Some of them still trickle in to this day. That's why I say it's still ongoing in the sense that if we find new cases, we'll review them. But we don't think there's any big scary case lurking out there in the shadows that we haven't found yet.
That's what you had predicted way back.
Exactly. So it's always possible. It's a big state, so it's always possible that there's a case or 2 that have fallen through the cracks. So we're going to keep looking for those. But there's not going to be, another huge batch of arson cases come along that need reviewing.
So you're talking about 1% of those?
It's a small number.
Yeah, which is really small.
You didn't mention about the lively debate we had about negative corpus.
Yes, and that's, if you don't have a fire, and that's the thing with the Ed Graff case. We had an opportunity to present the science to the court. The state did not present any expert arson science whatsoever. The attorney representing Ed Graff did. He still felt, at the time that the jury was out for deliberations, that it was in his best interest to take the plea because he was up for mandatory parole. So you do have there is a distinct challenge when there was not, if you didn't set the fire to begin with, and you don't have the evidence going back, you're in a hard place to prove it. So there are distinct hurdles for these cases, so we're doing the best we can.
I should
Any
say
question?
that the fire marshal just won a big award, Public Official of the Year, which sounds, I mean, that's saying something in the whole country. And it was from an organization that's sort of a trade association for public officials. So it was, people continue to
Yes.
recognize the good
Chris
work
is an
of the fire
amazing
marshal.
person.
We're going to be co-presenting again in June at another fire investigation conference about the joint effort. We've been receiving information here and there, or requests from other Innocence Projects about how did you actually do the review, trying to share that information. So hopefully it will be followed by other states. The Fire Marshal's Office has definitely set a fantastic example to follow, so we're happy to be working with them.
That's great.
I think both of your groups deserve the acclamation you've received. It was a tremendous amount of work you both undertook.
Well, thank you. That's what we're here for.
Well, you succeeded.
Thank you.
Thank you.
Thanks.
Thanks.
Okay, I guess another question. We'll move on to the Collin County Fire and Arson, okay, Investigation Association.
Hello, my name is Steve Setting. I'm the Wiley Fire Marshal. Just a little background on my experience. I've been in Wiley for 20 years. When I started in Wiley, it was 8,000 people. There's 50,000 now. In 2013, I was voted in as a Collin County Fire and Arson Association president. Basically, it's an umbrella body that organizes the task force for the county, and we started a task force, Fire and Arson Task Force. I don't have a science background other than the fact that I have associates in fire science. My bachelor's is in emergency administration and disaster planning. But we started out doing this fire death course that put on the agenda 3 years ago. This will be the third year, and we're moving it to another venue. That's kind of why I'm here to ask for money. The last time I was here, you gave me a grant for $4,000 for a fire dynamics and fire patterns course that we put on. Basically, it's a trainer course where we flew in Greg Corbett, a professor from Eastern Kentucky University, one of the only universities in the country that has a Bachelor's of Science program in fire and arson investigations. And we put on a very successful training. We had about 7 or 8 attendees that were from Fort Worth, Dallas, and a lot of the smaller cities. We had about 5 attendees, 6 attendees that were from the private sector, International Association of Arson Investigators, former president of the International Association of Arson Investigators, and we had a good representation. In all, about 17 students and about 26 total with staff and people that helped the commission. I have it on my thumb drive. I would love to show you guys a little bit of it if you had time, just to show you that the gap that you helped us fill by giving us that $4,000 was very well used and served us well, because without it, we wouldn't have been able to put on the course.
There's, if for those of you who were here during the Willingham and Willis investigation, one of the major recommendations from the commission was to try to find a way to fund training, good quality training at the local level. The State Fire Marshal's Office has done an amazing job of making training available to folks all around the state. But the efforts of Steve and his group really reached down into some of the smaller communities in North Texas. And that is a wonderful way to fulfill that recommendation. And I think they've worked very hard on it. So Dr. Pirwani, did you attend one of their events, I seem to remember?
I did, yes.
Okay. So they invite commissioners to participate. And so overall, I think it's definitely something worth supporting.
If I may too, the planning process on this particular course that I'm here for to request funding is also been integral with the State Fire Marshal staff and both Kelly Kisner.
What kind of research are you planning to do now? I mean, how much money are you asking the commission?
Well, due to the logistics, we're changing the venue from Collin County to a National Guard base. We want to get a little more security, so that will free us up to do the security a little more different types of fire and research with the STEP program. So I don't know if that answers your question, Dr. Pirwani.
How much?
How much?
Due to the logistics, it's gonna run up our price and asking between $9,000 and $10,000 for this particular program. We have matching. We have a $6,000 right now that we can match with that we intend to spend. I understand that it's a unique request.
You have given us a breakdown, and it's in our budget?
So in the budget, we have a category called Other Development,
Yes.
$15,075. So if you were to approve his request, it would be taken from that line item.
Have you received any details about the breakdown of the?
Of the cost? We did for the last one, but I'm not sure if we have the budget breakdown for this one.
No, I can tell you right now with the logistics alone, we're going to have to basically put everything together in our area and truck it to the area where we plan on doing the course, because we're going to use the same type of burn cells and some of the same type of training props that we used for the fire dynamics and fire patterns for building cells, along with using cars. So there's a whole logistical thing there involved.
So just out of curiosity, how much do you really need to put this on? Collecting that you have $6,000 for matching, how much is the total that you're going to request?
Well, just the shipping container alone that we need to go ahead and start staging our materials for logistics is going to be $3,000. That's not including moving that shipping container once we build all of our props to our site. Then also that's going to include a hotel for some of the instructors. Dr. Dahan is going to be our lead instructor. Professor Gorbett has agreed to come back down. We are going to pay for that. The state is going to cover Dr. Dahan. Also, Dr. Icove we've reached out to Dr. Icove to be a participant as far as one of the instructors in this course. So there's a lot of logistical concerns. Like, I didn't really, on the course before, I knew it was around $7,000 for my 3 burn cells. That's how much the burn cells.
I think it's really a wonderful thing, and Dr. Dahan and Dr. Iko are wonderful scientists, and I think it'd be a worthwhile project that I would want to support, but I need to see a proposal and budget.
What would be the maximum amount you need?
Well, let me say, first of all, are there any other commitments to this fund?
So everything else that we have in the works for forensic development is already accounted for in this budget breakdown. So for forensic development, we have $76,000.
Right.
The things that we have, that we're either voting on today, or things that we have in the works in terms of online training are all accounted for here, so that $15,000 is left for requests during this fiscal year that come in, such as what Steve has asked.
Others,
Well,
yeah.
yeah, well, you know, obviously, by the track record, this is a good project to finance. I think we have to get a breakdown, but what we might award contingents on
the budget breakdown.
On the budget breakdown. So we probably could accept it conditionally.
I think, Dr. DeMaio, in the policies and procedures, you're allowed in between meetings to make approvals of expenditures. So what I would suggest is that the commission vote on the amount here, and then you review that budget breakdown. And we can circulate it to all of the commissioners, so if people have any questions about the different categories, they can pose those questions.
Did you get a copy of the written proposal, what they're trying to investigate, and details of anything they're trying to research?
As I said, I've communicated extensively with the State Fire Marshal's office, Kelly Kisner and his
So we
staff.
don't have the proposal yet?
No, we don't, but I've vetted it and we've gone through it and we've agreed on, this is the direction we want to go.
What's the date?
June 1st to the 5th.
Oh, okay.
So
Well,
so how can we approve a budget and approve a project without even having a proposal in?
well, what you can do is
Contingent.
review it in April at our next meeting.
Yeah, I suggest we do that at the April meeting.
Is that cutting it too close for you?
I'll accept the challenge. You know, I'm used to it. That's one of the things I enjoy about it is the logistical portion of it. I want to put this on because this is something that I should have been doing. I should have participated in when I started my career. So that's what I'm trying to do for us.
Is the location still North Texas, or is this open to a broader group
Our
of people?
target is going to be the Metroplex and our past students because we are changing the format a bit. But we do have a 2-year plan in place right now for the facility once we get ultimate approvals. And we're going to market it nationally. We're going to take the same curriculum that we're using this year and go for a national audience through IAAI, such as that. I think we can do it with the type of staff that's agreed to come in and help us.
How many
attendees
did you say you had?
Pardon me?
How many attendees did you say you had?
Overall, in my 2 previous fire death courses, I've had over 80 attendees. And I'm going to reach out to that pool essentially for this one.
Lynn, refresh my memory, what's the end of our fiscal year?
August 31st.
Okay, so basically, and we've learned earlier, you got to use the money or lose it, right?
That's
Right.
Okay.
I think as long as you're comfortable with getting the money in April, then we can defer the vote until April, or alternatively, if you all want to vote for it contingent on Dr. DeMaio's review of the budget or the commission's review.
Right. I think I would make it contingent, so it doesn't make it real tight. If you know, contingent on receiving acceptable proposal and budget. Just
How will we decide it's acceptable? I guess we'll have to come back to you and tell you yes or no, right?
Well, it would be Dr. DeMaio who would look at it, and we could have you look at it, Dr. Pirwani, since you've had experience with this particular area and you're in the Science Advisory Work Group, and if you feel comfortable with it, then we can allocate the funds. If you want to have it brought back to the commission, then we just don't pay out the grant until you are okay with it.
That's why I said contingent upon acceptable.
I feel comfortable spending up to at least 50% of the budget. I'm not very comfortable spending all of it, so what I'll do is I'll make a motion that we approve $7,000 for this, subject to proper budget being presented and approved by the chairman or by someone.
Oh, okay, so an initial 7,000.
Yeah, I don't think we ought to spend more than 50% of what we have in there on just one project.
But would that be contingent on the curriculum being submitted and reviewed by Dr. DeMaio and Dr. Pirwani?
Well, let's make it 7,500, that's 50%.
Okay. 7250.
I'm sorry to belabor this, but if it's a great proposal and the budget is sound, I think we should fund everything. We have $15,000, as Dr. Kessler just remarked. The money is going to roll back into the state's coffers if we don't spend it. So what are we hoarding the money for?
And there's no foreseeable.
We just want to see what your proposal is, because we don't know what it is all about. We are funding something. I have no idea what you're trying to achieve. So give us a proposal in writing. We can review that.
I have a 40-page plan that I submitted to
Give
the
it to
National
us.
Guard
We'll
over
review
there.
it.
It would be no problem to
Absolutely,
create,
we'd be very happy to.
extract
And I
all
think we
the-
should fund the whole thing if it's worthwhile. Why should we nickel and dime your project?
Our long-term goal Our long-term goal by the marketing and doing the 2-year plan is for this thing to fund itself. There's a program in California, San Luis Obispo, a SlowFist program that's very similar to what we're trying to accomplish here. It's the only one in the world, basically, and it costs $1,000 per student, and they just raised it to $1,200. I'm fortunate enough I was able to go. I'm budgeting for my staff to go every year, but you know, that program is like none other in the world. Some of my classmates in June were from Canada, you know, the Royal Mounted Police. I mean, it was an amazing course, but this is what we're trying to create here.
But I see there are two things. One is the amount of money, and two is how we're going to make it contingent or just go. Now, I think 10,000 is acceptable. I mean, I think most of the people say, look, we've got 15,000. We have nothing forecast in the future. So commit the 10. But then I would make it contingent. Dr. Pirwani could review it with me too.
Why should we make it contingent? He said April is great. He's already agreed to do that.
But you know how so let's just talk
April,
about the way
really
that the
hard to
processing
organise,
works.
not knowing what
Is
Okay, I mean, if everybody wants to vote on it.
April would be the approval, and then, you know how our process works, so the check gets generated, I don't know, 45 days after that? Maybe, if you're lucky.
Yeah, that's just too tight.
If that's okay, we can do that.
No, because part of the...
Come on, tell the truth. It's too tight.
It is too tight because part of the whole plan is that we do this on our own time. That's it's
Your start date is what, June 1?
June 1 through 5. That's Monday.
So forget about June.
Well, give us a proposal in writing and we can review it, and then we can give feedback to Lynn, and then she can disseminate our concerns or
Can we
support.
author, I mean, I'm just wondering, is there a way that we can have a motion to vote on this so that after whatever's been submitted has been approved, we can make the money available earlier than April? I mean,
There's a motion on the table.
We can't vote, we have to meet. If we're going to vote, we have to meet. You're going to have to just trust me, okay?
So it is true that if you want to vote on it, you have to do it at an open meeting. And so you either have to make a decision today or make a decision in April. I don't think there's any problem, judging by what our policies and procedures say, to make a decision today. But that giving Dr. Pirwani and Dr. DeMaio the authority to review the budget and make any comments, suggestions to the person who's receiving the funds to make sure that if there are any concerns, those are addressed in the planning process.
So can we follow and put the decision for some of the fund now, but when they get the proposal, maybe his proposal, SIF proposal be $12,000, and Dr. Pirwani and Dr. DeMaio and everybody thinks that is perfect, we should do it. So that time, in April, we go for the rest of the fund and then go for...
You could do that if you want.
Yeah. Just so he has some right now in his hand that he can start to his work, and the remaining to be on April after we get the more proposal.
Well, there's a motion on the table that could be modified if that was what it was, but it's got to be addressed. It hasn't been seconded yet, but it's been put out.
I can amend my motion to up to 10. That the number, and notwithstanding, not what you're doing or notwithstanding the quality of the program, but I'm just concerned about numbers and budgets, because last year it was 4, this year if we give you 10, next year it gets 20. It just kind of goes on and on. We don't know that, but I'm not picking on you, but I'm just trying to be financially frugal here. So, but I can amend it to 10,000 subject to them. I don't have a problem.
Well, is the June 1 date an absolute solid date? Why can't you delay that date and give us more time? And I think in future we should allow ourselves more time and not to be run like this. I mean, you know, we are taking a vote and doing all those things because he set the agenda in his time schedule. He should give us more time. or anybody who wants money from the commission should give us more time for consideration. We need a written proposal, we need the budget in writing, so we can consider it in a meeting like this and we can discuss it. You're going to rely on me and just Dr. DeMaio, and the rest of the commissioners are not going to be part of the discussion. So in future, we would strongly recommend that you give yourself more time. When your June 1 date absolutely solid, why can't you delay it?
Understood on the more time. This, by involving the State Fire Marshal's office and by changing the location to a secure facility, has required me to kind of throttle my request, not knowing everybody's willingness to participate. Now, I'm in the throes of the approvals through the National Guard right now, but as I said, the state has looked through, vetted, and dedicated resources to this program for those dates right now, and that's why the delay. I was adamant about doing a 2-year plan. I already have my second year planned out. Again, the goal is to get it to fund itself more so through the program as opposed through external source. The last time we've done it, the last 2 times we've done it, we've taken a basically a dilapidated structure, a home that has been scheduled for demolition through their code enforcement program in Collin County, and we've done the program there. The lack of security and everything has kept us at a certain level, whereas if we make this leap to go on to the secure facility, we can do things that we wouldn't be able to do in the circumstances of a dilapidated home in Collin County with the lack of security.
So my understanding, the fact that you're trying to use the secure facility makes the flexibility about changing the date more difficult?
Yes, sir.
Okay.
They do bomb runs and everything on this facility, and we've got a week right now that has been dedicated to us because of that.
Okay. Next time.
Yeah. I mean,
Yes, sir.
Next
Absolutely.
time. We need more
time.
More lead time.
Next slide.
I mean,
Absolutely.
I can appreciate having to organise a big event that you need obviously to plan, and you need to know what you're getting in advance. However, do we know what the amount of money total is for the project to be able to go ahead, and what proportion of that would need to come from the Commission to enable that to actually go ahead?
He said he's also got over 10,000.
So, but yeah, so
We
is
have
that
6
all we
right
need?
now. We have 6, and we're doing a fundraiser in April. I expect at least equivalent to last year, maybe a little bit more than our fundraiser from last year, which was about $1,500 to $2,000. So I think that I could say right now, we'll have $8,000 to match against that. And then on top of that, we're going to have to charge a minimal amount to students to come in order to meet the gap that we're going to have for like lodging for some of our folks. We don't want to make them pay for lodging, and I don't think that would be right. We're going to have to fly in Professor Gorbett. As I said, the state has already allocated Dr. DeHaan as our lead instructor, and they're covering that. So there's a lot of give and take going on right now. But as I did the fire dynamics course, never been done before, there was things I didn't realize, and I did a budget, and one of the factors I couldn't, and when I reached out to Lynn for, one of the factors I couldn't predict was how many people were going to come and pay. So that was why I asked to fill that gap, because at a certain point in time, I would have had to say, can't do the course if I don't have X number of people paying money.
Let's take a contingent vote.
So, what do we have to take care of? Can he withdraw his motion? Or
Sure, I withdraw the motion.
okay. Someone will make a motion
You want to make a new motion?
that, what?
I don't know what it is.
Possibly
I had my motion.
a motion
To fund
that we
contingent.
agree to fund $10,000, that this is contingent upon us receiving a copy of the
Written proposal.
proposal
Projected expenses.
And the budget.
for the budget. So we'll fund it now, but it's contingent on receiving it, and then I and Dr. Pirwani could go over it and agree whether to go with it.
That was the motion I had.
Okay, that's great.
Yeah.
The amount was different.
Yeah.
I second that.
Okay. Aye?
Aye.
Nay? Unanimous, okay? Lynn,
Yes?
you're sleeping now.
No, I'm not.
Okay.
I'm really not, I promise you.
Does that make,
Okay.
is it
that
all
a-
right with you now?
Just get us the material as soon as you can, and I'll get it to Dr.
Yeah, the
McDonald.
sooner you get it to us, the sooner you get your money.
I'll get you something this weekend or by Monday.
Don't worry, the weekend.
Don't worry
You can
about
take
it.
the weekend
Don't worry
off.
Well, the association stuff is something that we end up doing on our own time.
Yeah.
A lot of it's our own time, so the weekend is when I have the time to do it. I'll be happy to get that to you by Monday.
Thank you.
Thank you.
Next is the hair microscopy panel.
Lee, can you put that? So the hair microscopy team met on November 21st at DPS, which is where we do all of our meetings in Austin. We have members of the team here with us today, Deborah Lind and Nick Vilvas. I should mention that Melissa Valadez, who's on the team, just got a major promotion at DPS, and she is the head of the entire crime laboratory for Austin.
Wow.
Which is great. Melissa's not here, is she? Okay. So the main thing is that we, the members of the review team wanted to bring an issue back to the commission for revision. And that issue, Lee's about to put up the flow chart, which you have in your materials. If you recall, originally, the flow chart for case review included a step where the Innocence Project of Texas would make a decision on the significance of the hair microscopy analysis to the outcome of the case. And what we found in reviewing the first few transcripts that we have is that this is a difficult, if not impossible, task in hair microscopy cases. And what the prosecutors on the review team asked, and I think the rest of the members felt like we should honor the request, is that those decisions be left to the lawyers and the court system. So what the review team is asking is that the commission approve this flow chart, which is streamlined to remove the question about significance of the evidence to the outcome. The other reason for removing it is that the commission decided to do a subsampling approach of looking at cases. The purpose of doing a subsampling approach is to assess whether or not there are common themes that pop up in cases, so that the commission knows whether or not there are areas that need to be followed further. If a particular examiner is using terminology that exceeds the scope of what hair microscopy science allows, then you want to be able to follow up in that area. You start to see common patterns emerge, both in the reports and in the testimony. If you use the significance analysis and you remove a bunch of cases based on that, then you don't get to see the pattern. And the reason to do subsampling is to look for commonalities and patterns and so forth. What was happening was we would all look at the transcript. The team members would look at Nick and say, okay, yes or no. And I think as we went through that a few times, it became apparent that that was just too much to put at his feet. Not that he didn't want to do it or wasn't doing it in a comprehensive, thoughtful, and fair manner, but I think the prosecutors expressed a real, and the other counsel there too, expressed a real preference to allow those determinations to be made by the lawyers in the court system. So, does anyone have questions about that? We have members of the team. Do y'all want to give a report?
Well, I mean, we can cover this issue first, and we can talk about what we found on the initial look through. But as far as we're concerned, this makes more sense. We kept the group as a whole, it has always started with the prosecutors and the body, but we would all agree when this point came back up that, what is the scope of this review? What is the Forensic Science Commission? What is the interest? And it's the science. It's not whether or not the science itself is material in an outcome. That's way far down the line. So to us, it makes sense. Pull that out of there. Let's look at the science, and if there's issues with it, that can be taken up at a later date. This makes sense, and it keeps the focus of the review much more on point, and we're totally on board with it.
Makes sense.
Now, in terms of the work product, the teams have gone through all of the material received from the crime labs and identified positive probative associations in about 250 cases. And what's interesting about that is it's evenly split between DPS laboratories and all other non-DPS laboratories that have done hair microscopy work. It's about that, right? 250?
Yes. And that, give or take, we still have Jefferson County to look at, and I think, was it Tarrant County we still haven't done?
No, Tarrant's done. Fort Worth PD.
Fort Worth that we still need to do. So, we'll add to it a little bit, but it's a manageable number. And I think once we get through figuring out how many actual convictions are out of those positive probative associations, I think the number will be even smaller. So we're not going to be swamped with transcript review, I don't think. And I still have a firm in Houston who wants to assist in that process of summarizing the transcripts, so it's a little easier for us to come back and look at the testimony. So I think we're going to have a workable number of cases to start with.
Then I was just going to say that of the cases that we have reviewed, both, I know for us, we looked at EPS lab reports. One thing that we were going to look at was the language in the report overstated, and really we saw very, very small numbers, single digit, overall. How many reports did you have? 400?
Yeah, several hundred.
Yeah, several hundred. And of course, I think the same is true for that looked at the other team looked at other municipalities. So overall, in those single-digit reports were only in the 1980s. Very few. It says if everyone chose one season to use a certain language, and then they all shied away from it. So it was not overstated that much. So we feel very good about the reports we read, and we have a good working relationship in the committee, and we'll press on.
So do we need a motion that we allow the change in the flow chart?
Does anyone want to discuss?
I'm fine.
I think it's practical, makes sense. It just seems like it's going to create arguments on the group about something that really shouldn't be decided by the group. I mean, the parties have the case are best suited, so.
Was there any negatives to the changing of the flow chart? No?
Not that I foresee. I think, like I said, it allows us, number one, to focus on the science itself, not worry about whether or not the ultimate outcome of a case was correct or not. We're just finding the convictions, looking at the testimony, let's see if there's an issue, let's see if there's patterns. And if there are cases that come out of it, then that can be taken up later. If we see cases that we can reach out to every case at the end that there was an issue on and just ask them a question. Would you like us to take a look at your case, yes or no? If anybody does, well, then we can size it up and go from there. But as far as this is concerned, this is what makes sense. And it takes out any questions about whether or not the body itself is doing the proper review and the transparency issue. And it takes the question out whether or not we have a vested interest in finding errors. We're just focusing on the science itself, so straight lines.
How many cases do you think it's going to?
Oh, I can't make a prediction on this one. No, we had an idea with the arson cases because we had taken a look at them, but on this, I think it's too early to make a prediction. It'll be one of those things where I think we may find patterns. I think it will vary from examiner to examiner and county to county. Because really, like she said, what we've seen in the reports is no major issues. The real question is, how does that report get translated to testimony in the courtroom? And that's where I think most of the issues show up.
The main The main issue of concern with removing that step is we had told the laboratories that we weren't looking for errors for the sake of looking for errors. And if there was overwhelming other evidence in the case, that we weren't going to look at it. And I think the lawyer's point was, well, if there's overwhelming evidence in the other case, otherwise in the case, that will be dealt with. It just shouldn't be dealt with by this group.
Well, the group has no, even if the group, under the current flow chart, the group's decision that it was overwhelming is not binding. It doesn't have any legal impact, and the parties would still be free to do what the new flow chart would. So I just think it makes more sense, and I understand the expectations, but I still don't think they're looking for just the sake of doing it. The purpose is to enhance the credibility of the science in general. That's the goal of the group, as I see it. So. Again, I think the change is worthwhile, and I'm ready to move that we adopt the change.
Yeah,
I move that we adopt the flow chart.
Second.
Aye?
Aye.
Nay? Okay, unanimous. Okay.
Oh, thanks. We need to talk about the members of the investigative panel on hair microscopy because it was chaired by Dr. Kerrigan. So now we have a vacancy, and the suggestion I would make to the group is that you consider who you want to chair it, but Dr. Eisenberg would be a great choice because his laboratory is the only one in the state of Texas that does mitochondrial DNA analysis, and we may need his services at some point to look at the mito.
I make a motion, Dr. Eisenberg, with the new chair.
Second.
All in favor, quick.
No discussion.
Not giving him a chance to vote.
I saw him nod his head.
You could have voted nay.
No, we get some funds from the state, we're more than happy to do it.
Are you more than happy to do that?
That's what I have technical leadership.
Right.
I know, Art, you don't have much work to do, so.
No. Give you something to do.
That's okay. I've been loafing off lately, saving myself for this appointment. Although we do need a vice chair at some point. Okay?
He's not looking up.
We need to do 8 chairs.
What are you looking at?
It wasn't me that you have to worry about, it was
You know what I'm
Lynn.
saying?
She's the one that's dumping you.
Okay, next one is the update on the DPS Houston Regional Crime Lab self-disclosure.
Not much of an update, but
Agreed, it's not much of an update. Of the analyst in question involved in the investigation, approximately 14% of the cases he touched in his career have been reworked, either self-initiated by DPS or by customer request. 675 cases have been reworked out of 4,944 total. And out of the 675, there have been 11 anomalies.
but none since the last reporting. So they report on these every single quarter, and there's nothing new
Correct.
since the last time we heard from them. Those 11 anomalies are carryover from the very initial retesting. I asked Keith Gibson,
Yes.
I asked Keith whether he thought they were done, because these are Salvador cases, what we refer to as the Salvador cases. And he said no, that they still get requests, they will still be doing retesting, and when he gets a feeling that they're close to wrapping up, he'll let us know, but he doesn't think it's going to be any time, at least in the near term. So we were going to do an addendum to that report once we had the full retesting results back. I just don't know when we're going to be able to do that addendum, because it may take still another year or maybe even more. So we can just continue to get reports from DPS on that item and sort of every time ask Brady or Alice or Keith or whoever comes before us from DPS, how close do you think you are to being done based on the volume and based on the evidence that's still available to retest, because as we know, a lot of that evidence was destroyed, and the Court of Criminal Appeals has weighed in on how to treat these cases. So they're working their way through the court system. So do you want to just keep receiving reports as we have been? Is that the best?
Just an update.
Yeah, I think that's.
Thank you.
Thank you. Okay, we're gonna just do 10, 11, 12 because they're really quick. And then go back to 10 and 11 essentially both involve the firearm tool mark examinations. 10 is out of Dr. Bernard's lab.
Dr. Bernard will be recusing himself on that
Right.
agenda.
I do not personally own that laboratory.
And let's see.
I can tell you what the status of these two are.
Yeah, well,
So we hired an expert, John Murdoch, as you all know. You reviewed his CV and his fee schedule and approved it. And right now, for both of these cases, Mr. Murdoch has everything he needs to conduct his review of the cases and to issue a report to the commission on his findings. He has the original evidence from Grimes County in the Swifts case, which he is going to be looking at under a microscope, as well as all the complete case file, including bench notes from the analyst who did the original examination. So that is what he will be doing, and he's been communicating with the laboratory. In the IFL analysis, as you recall, that was about an erroneous initial exclusion. So he is talking with the laboratory and looking at the process that the examiner went through in, number one, deciding what the class characteristic was, whether it was appropriate to use to do an initial exclusion. Those were Bunner marks, as you recall, Bunner markings. Yeah. So he's looking at that. He's looking at why or whether the technical review process should have picked it up, and whether it's appropriate or not, or whether he has recommendations about how to do an audit of an examiner's work in a small laboratory, because the audit was performed by an examiner who had done the original technical review and missed the issue. And also, in a small laboratory, what do you do? So he's looking at all of those issues. It's a lot of material. He's been extremely communicative and very responsive. And from what we understand, having talked with firearms examiners at the Texas Association of Firearm and Toolmark Examiner meeting at DPS that happened a few months ago, he is very well respected. A lot of examiners have trained under him. He was at ATF, I believe. He has a high leadership role in AFTI, writes a lot of research papers, and I think we're going to get a good work product back. The chairs of those groups will take a look at whatever we get, and then, of course, it'll all be distributed to the commission. I think the goal is to get something back from him on both cases by the April meeting. I imagine if there's any delay in that process, that he will let us know, but the goal is to have something for y'all to review on both cases by the next meeting. And then you would review that, ask questions, we'll invite him to attend. The laboratory will be given a chance to look at it and weigh in. And then from there, you'll instruct about how you want a draft report to be done, unless there's additional work, and then we would do that work as well. Does that make sense?
His report will specifically address the questions that are outlined
in the scope of work that we gave him. Yes.
Okay, great.
So I guess that was just informational.
So it's in progress, both of those cases.
So the next one is 12, Dr. Bernard.
In this case, this was the digital forensics, where there were two experts who came up with different heights for an individual who was charged and ultimately convicted and we just got the video and the material sent to the experts. So that's just kind of early examination by the expert. So it's too early to have any opinion at this point.
I think he'll try to get us his report as well by the next meeting, is what I understand.
Yeah. The other issue was the budget on what that was going to be. We wanted an estimate of what that would cost because we really didn't know. His fees are fairly expensive. He's well respected, but we also wanted an estimate to make sure that this didn't become extremely burdensome.
Yeah, this case is also important because it's going to start to set the standards in the state, I think.
Well, it certainly may come up with some results which will give some guidance, and we don't know it yet whether both would be considered having been incorrect or one correct, one incorrect, so it's very early. But we also wanted to get an idea of what the cost would be because we don't know how much work's entailed.
And also, really, even more than the results, it's about the methodology that was used. Because as you remember, the methodology was very, very different used by the two examiners.
Well, I think
so if one of them gets it right, but it's by chance, he got lucky, and he's not using nationally recognized standards like SWIG-D and the other standards that are out there being worked through the OSAC process, then we need to talk about that because prosecutors are relying on these experts. Defense or defendants are spending their money to get these experts to testify. So it's an interesting area and one that is emerging as a huge part of forensic science.
Yeah, I think that's part of, maybe in a way, the most important aspect of these two cases that we'll get some input on.
I thought in the initial discussion, what we were really interested in were the strengths and the weaknesses of each methodology to try to determine best practices. Is that not the case?
Yes, but also to determine whether either one of these is valid or not valid.
Right, sure.
And so...
Did we give him some set of questions, like what we did with the firearm? Did we?
We're still working on that because he wanted to take a look at, he doesn't even know yet whether the videos are in the appropriate format for him to analyze. If they don't have the right format, then he can't render any sort of a decision or opinion on the height of the robber.
And if he can't, then they can't.
If he can't, then they can't, and then the scope of his work is different. If what he gets from Grimes County, which was just sent a couple days ago by FedEx, if that has the appropriate format in it, I'm sorry, Bell County, then if what he gets from Bell County has the right formatted evidence, then he can both perform the height analysis and issue recommendations and findings about the reliability of the methodology that was used. So as soon as he tells us, I have what I need, then we're going to do a scope of work with Dr. Bernard so that we know exactly what it is he's doing. So far he's said that the component of it that requires him to take a look at that and to do the methodology evaluation will not be over $5,000, but we want to check back with him once he has had a chance to look at that video. The original video we sent him was not in an appropriate format for him to do any type of analysis, and he pointed out to us that no one who received it in that format should do analysis on that video. So one of the things is, you know, how did you, because if you just upload it, it changes apparently the imagery so that you really need the original version of it that is pulled down off of the 7-Eleven or Valero. We think we have that, based on what the Bell County investigator told us, but he needs to verify.
So you've already budgeted $4,999.99.
That's right. If we need more, we'll have to come back and ask for it, but we may not need more before the end of the fiscal year. It just depends.
Oh, but, that's sort of, what Dr. DeMaio had indicated, why to cut it off at $10,000 for the previous ask just makes sense. We're not 100% sure what the final price will be on this one. It's coming out of the same pocket.
Is it coming out of the same pocket?
Well, in your budget, it's not, but our allocation is all in one account. So it's not, you know, it really is all the same money, no matter which way you look at it. I will say that in terms of investigative budgeting, we have a lot of money set aside. If you look and projected, we have $50,000, and right now our experts are anticipating $10,000. So we actually have, in case we take on additional investigations and hire more experts, we want to make sure we have funds there to do that. So if Mr. Fredericks comes back and says, the second phase of my project is going to be $10,000, we have $40,000 in that set aside for that. Does that make sense, Dr. Eisenberg? Do you see the projected column is
Yes.
the third one in?
Uh-huh.
And it's $50,000 for experts.
Yes.
And so far, we've only spent $10,000.
Yes.
But we have to get them both here to present before the commission. That costs money.
Right.
You know, they charge for their time. So we didn't want to, we wanted to leave enough of a buffer. And if you want to hire anybody else in the next couple meetings, we need money there.
Makes sense.
Okay.
Anything else?
I think now we'll move on to number 9.
Can we take a short recess?
Can we take a little break?
Well, okay,
Biology?
take a, I guess you'd call it a biological break.
When do you want them back? At
10 minutes.
At
10
11?
minutes. What time, well, what time is it?
10:45?
Like at 11. Okay, I think we'll resume now. We're going to dispose of some minor, no insult to the people involved, topics, so that, because we need time for another, for a major one. I think what we're going to do now is go to number 13, update from the Forensic Development Committee.
Okay, so there's been a lot of activity in forensic development, we're pleased to say. The first thing is the status of Blackboard-based forensic training in collaboration with the New York Office of Forensic Services. And as you might recall, the Blackboard program is something that's hosted by Sam Houston that allows laboratories to sign in and get what we're hoping to be high-quality forensic training online. So a laboratory director can decide, oh, there's a training on blood spatter analysis, and I've got a new examiner, and so I'm going to set that training up for the examiner. Or there's training on there on ethics and integrity in the crime laboratory, and we're going to have each of our sections do that training. So we're trying to put really high quality work product there. I will tell you that when we originally started, it was the office in New York, our counterparts up there, who were uploading most of the content. And the philosophy they had was, let's get as much content up as quickly as we possibly can. And because of that, they were doing sort of standard PowerPoint presentations, recording them. And what we noticed, in particular, what I should say, what Dr. Kerrigan noticed, is that the quality of those programs were not as good as we had hoped they would be before we rolled them out to Texas examiners. And so we've been in a process of working with Sam Houston, the people in the Delta Center, to make those presentations into really high quality interactive PowerPoints that keep people engaged, using videos, using different design techniques that they have, using something called branching, where you can pick different avenues to take depending on what your interest is. So that is being worked on now. Larry Carino, who's very well known in the forensic world and did the overview of forensic science course, he had his PowerPoint reworked by Sam Houston and was really pleased with the results, and I think, you know, may want to use it in his future training. So it's worth putting the time and energy in to make the PowerPoint and the online training as high quality as possible. We're hoping to roll that out very soon. That's the status of that training. I do think, just to let you all know, that a big part of our forensic development budget goes to paying the people in the Delta Center to do that work. It's very time intensive. So when they revise a course, they have to go in slide by slide and really rework it. What I'm hoping is that at our next meeting, we'll have some examples to show you. This agenda was a little too packed to do it, but what I'd like to be able to do is show you, you know, this is what we had and this is what we have now, and what a good quality work product it is. We may need more funding for course design, but that probably won't happen until the next budgeting cycle. I think what we have in the budget right now is appropriate for the course design that we have in the works. And we'll get into some of the details of that in the next items here. So that's the overall status. One of the courses that we in Texas created from scratch is a course called Integrity and Ethics in the Crime Laboratory, a scenario-based discussion. And we had worked with 2 people from the Tarrant County Medical Examiner's Crime Laboratory to develop that training from the bottom up, starting with a meeting that we had in our office to develop a case scenario that we thought would be helpful. And they've made tremendous progress on that. Do you want to, Ron and Chris, do you want to talk to the commission about how that's gone and what the status is?
We put together, as Lynn said, a PowerPoint presentation at this point that is a scenario-based exercise in ethics and integrity in the laboratory. We have put it on twice. We first did a very rough run for our staff at the medical examiner's office, and then yesterday we put the course on based on feedback that we had gotten from the ME's office and some tweaking that we did to the program. We put it on yesterday after the Texas Crime Lab Directors meeting here at DPS in Austin, and it was very well received. I got a lot of positive feedback on it, and in fact, we had an offer to take it on the road, so it's obviously got some benefit to it. We are now going to go back and work on the voiceovers. The way the process works, and I guess Lynn can get into this if, in more detail if necessary, but the way the process works is we now have the basic PowerPoint. We have to go in and now voice over the slides. Then it will go to Sam Houston, where it'll be integrated with video that they took yesterday, so that it becomes not just this slide up on the screen that you have to kind of stare at. There'll be some live action and a few other things, and we will at the same time tweak as we go through the voiceover, because what I'm discovering, and I imagine Chris is discovering the same thing, is that when you stand up and you give a presentation in front of an audience, you know, it's kind of free form. When you do a voiceover, and I've had some experience with this when we put up the CSI, the Experience exhibit for the Fort Worth Museum, when you do a voiceover, it becomes a whole different thing. So you sit there and you do this voiceover, and then you listen to it, and it sounds absolutely horrible, so you have to go back and try to do it again. That's where we are with this, and we're hoping that we can move forward and then get it all together.
And then it'll be released to all the laboratories. In the interim, individual laboratories, from what I understand, have been approaching Ron and Chris and asking, or at least one has, can you come down and do this for us? And so I think that, assuming that Ron and Chris feel like willing to do that and use their time to do that, and assuming you all are okay with it, that the commission could pay the expenses associated with going down. So not an additional allocation of payment, but rather just covering the costs of that, the travel, basically. So it's looking really good, and we're happy with the product that's come out so far. what was great about yesterday afternoon is that it wasn't just examiners from DPS who were very happy to have there, but they may be less likely to say to Ron, hey, you really need to fix the first 20 minutes. But the crime lab directors who were at the TACLID would tell them that, I think without hesitation. So they gave some feedback, which was great to have a mix of bench analysts, directors from different laboratories so that they can revise what they're doing based on that feedback. Y'all, some of you had watched it. Linda, you did. Did you want to add anything? Or?
It was very appropriate, very interesting. The scenario-based format was very intriguing. It's going to get the thought process of the scientists going in the right direction. And I thought it was very good.
So I have a question. Is the ultimate goal to have something that is strictly a passive viewing, or is the idea that the local places would have someone who would moderate and take questions during gaps in the program?
That's exactly the way we're developing it, so that it would be facilitated. You bring the thing up on the web or however you want to project it, and then you'll be able to stop it and facilitate discussion, because the only way you can really get this kind of a program, get any benefit out of it, is through interaction with the people who are actually sitting there.
So does the module contain suggested conversation starters?
Yes.
Okay.
Yes, it does.
What is the duration of your presentation?
We aim for a target of 3 hours. And depending on the input that we get from the audience, it has run between 2.5, and our first run actually went over a little bit, about 3 hours and 10 minutes. So the target that we're aiming for is 3 hours.
And eventually it will be web-based.
And it would be web-based, and then again, the web-based portion of it probably will be, let's see, hour and 45, no, well, about 2 hours, 2 hours to 2 hours and 15 minutes. The rest of that would be the input that you would get from the staff. And it could run as long as the facilitator wanted it to.
So you record your initial presentation of the PowerPoint, and then you have to go back and do the voiceover after?
Well, yes, we put together the PowerPoint, and then Sam Houston sent us some super duper special space microphones to use to do the voiceover, and that's what we're in the process of doing now.
So you don't actually ever do the presentation to an audience from the PowerPoint?
Yes.
You do?
That's what we did, yes.
Are you aware that you can record that with the audio
It was in fact recorded. We have 2 issues with that. One issue is that the video is fine, but you never know what kind of a response you're going to get from an audience and what kind of comments you're going to get from an audience. The second thing is that there's a hesitation on the part of the participants who are sitting in a course like this to have their comments immortalized. And so what we assured them on several occasions over the course of the 3 hours yesterday was that none of that audio would be used. That we were shooting essentially B-roll, to integrate into the thing, and that I think facilitated a much better discussion.
There actually are some programs available where you're recording a PowerPoint presentation with audio, where you can pause the recording so that you wouldn't have to necessarily go back and do the voiceover. So that might be something that you might want to think about. It'll save you an additional step in that process.
They have 2 programs one's called Articulate and the other one is Narrate. And they could pull the audio straight from the recording yesterday. But from what we've been told in course development, the more professional approach is to do both the voiceover and a live recording where they can pull video snippets that the facilitators can use when they're presenting the information.
Oh, I see.
I hope that makes sense. Because there's what we've been told by the developers of the course designers is fatigue sets in. And so they want you to do a fresh recording, and they suggest they have all sorts of tips and tricks about how to do that and how to make sure that they don't sort of fall victim to fatigue, because in prior courses, they found that toward the end, the quality gets, you know, just people get tired. It's human nature. You must use this at
Yeah,
SAM.
we do for online courses, and we do it exactly that way for the two-step process. And the overall, the quality is a lot crisper and tighter. It's a better way
So
to
we figure after we get the voiceover done and the thing gets produced, Chris and I will apply for save cards and, join the guild and become a marketable entity.
Now, what is so great about putting all of this effort into the first version of this is that next year they can sub out slides. So they can sub out the piece of the presentation that uses the scenario and put a new scenario in without having to redo the whole thing from scratch. So that's what we're thinking, is that annually we introduce a different scenario, we update it, and these guys have told me.
We're already talking about next year.
Yeah, they're already thinking about what to do for the next scenario.
What about copyright violations? If you use illustrations from...
We have 2 short videos that we use in the presentation, and Chris had gotten permission from the originators of those videos to use them. We can pull stuff off of YouTube also, that as long as it's up is common use, but anything else we get permission before we introduce.
And additionally, going to what Lynn was talking about, there's several concepts within the presentation that can be expanded upon for future training scenarios, things like bias and going into detail on conflicts of interest and things like that. Those subjects that are present in the original video can be expanded upon for future training.
I attended the presentation yesterday, whole of them, and I really enjoyed it very much. I thought that was very good set. The scenario that they had, it definitely different laboratory going to answer it differently, and that was good. It wasn't one way right or one way wrong at all. The explanation that they brought him in the first and last of them, it was very appropriate. It needed to be later, as you said, to be explained a little more, because each of them you can write a book for them. So he just had, one little and one paragraph. You could really expand it and just say more about each part of it, which was very...
And ultimately, you could potentially have a series running with the different concepts broken out that a laboratory could use over a series of several years.
And I think that's the vision, is that we just continue to develop a catalog of options and resources for laboratories to use, free of charge. And as we move forward, and it's quite a costly initial investment, but as we move forward, it gets less expensive because you have a work product that you're basing revisions from.
And that one that they had it's, I think very easily the lawyers can watch it and they learn something about that, because then law enforcement, I mean, that was something, because that's the scenario that is happening and that's how they have to do it. I thought that was, you could show it to judges or anybody. It's not really only the lab anybody could use that.
Thank you.
Thank you.
So the next item is development of Michael Morton Act and Brady training. So what we're hoping to do is, using the same approach, is doing training that's specific to what the requirements are of Brady versus Maryland and other case law on disclosure by prosecutors of potentially exculpatory or impeachment evidence, and focus not only on the federal case law, but also on the Michael Morton Act, or what is known as the Michael Morton Act. That is something that we're doing in collaboration with Judge Hervey of the Criminal Justice Integrity Unit. She has already done that type of training for law enforcement, but obviously they didn't use the same type of technology that we're hoping to use through the Delta Center at SAM. I think we're going to try to develop that within the next few months, as soon as that is next priority project for sure. Pat Johnson, who's here with us, had developed some case scenarios from a laboratory's perspective that may raise disclosure issues, whether they're Michael Morton Act, Brady, all of the law that applies to that. So we already have some material to use, and we're going to be developing that and talking to you more about it. We may ask Pat, who has come out of retirement, which you'll hear about in a few minutes, but we may ask him to assist with that project. We'll see. But we're excited about that. And part of the reason we're so excited about it is because at the national level, both at the National Commission and at the OSAC, the Organization of Scientific Area Committees that's been developed by NIST, which is a huge undertaking, which we'll talk more about later, they want to do really high quality training in what they call Brady and Giglio disclosures. And we think we're going to develop the first one, and then maybe other states would like what they see and we can offer to help. But we have lots of optimism about how this is going to work out. So. And we will talk with, of course, prosecutors and the defense bar so that they can take a look at what we're producing. We are going to encourage, in the same way that we encourage laboratory directors to do the guided discussion for the ethics and integrity training that Ron was just talking about, we're going to encourage local prosecutors to be there for the training on these issues, because it's their, fundamentally, it is their obligation. And things that are not disclosed at any part of the state, in any part of the state's case, that knowledge is imputed to them. So they really need to be part of that discussion. Do you have any thoughts on that?
I agree.
Okay. So that's our next project under
I presume when we
forensic
get that done, that will, the idea will be to make it CLE eligible so that you can get CLE credit for it.
Yeah, and any other type of credit that we can think about that applies. Okay. So another item that's in the forensic development budget is root cause analysis training. We're going to talk, this is one of the recommendations that's in the report that we'll discuss later, but I think it would be really great to get some good high quality root cause analysis training to the laboratories. I don't know that it necessarily is an intuitive thing for a lot of folks in the labs, and there really is a process to it, and so there are some resources nationally available that could help us develop that training. I wanted to mention it because it's in the budget, but we hadn't specifically discussed this. So do people agree that that's something that laboratories could use, that it's helpful? Or?
I think it's very important.
It is definitely helpful to us, because they know what they do.
Right. I think the TAC felt like it would be helpful too, root cause analysis. So we're going to add that one to the list. In terms of forensic support for Texas laboratories, the commission, as you recall, approved funding some money for interns to do foresight work. And Foresight is a program out of West Virginia University that we've heard about before, which gathers data from the laboratories, allows them to sort of look at their own internal data to determine areas where maybe they could be more efficient, and also to compare data points with other laboratories who are in the Foresight program. Max Haug had talked to us about that at one of the leadership academies that we did here in Austin. And then we had Paul Speaker come to a TACLID meeting and also talk about it. The laboratories, I think, who have invested the time to get themselves into the Foresight program, I think are pretty pleased with how it's going. We may have additional requests for intern support. We don't have any on the table right now, but if I get any more, I will bring them to the commission so you all can discuss it. Dr. Howe, would you mind talking just a little bit about your experience there?
Sure. We had an intern that was funded by the commission, which we greatly appreciate. That intern has gone through about 12,000 case files for us. our LIMS system is not configured such that we can draw the statistics that we need for the foresight reporting from the LIMS. So we actually have to go into individual case files to pull that data out. So that's a pretty significant undertaking for us. We have completed the statistical data collection on our casework for 2013. We'll finish 2014 probably in another week to 10 days. The financial information has been included with the spreadsheet for 2013, and we'll need to go back after we finish our 2014 statistical data collection and add the business component for 2014 as well. At that point, we will submit all of our data to Dr. Speaker and then wait to get a report at that point.
Anyone else, Houston, you want to talk about foresight?
We also used an intern. We were a little more fortunate than Sue because a lot of our stuff's in LIMS. So we were able to already submit 4 years of information to Foresight. We got a report back about 2 weeks ago, but we're in the process of getting ready for our assessment. So I hadn't really had a lot of time to sit down and really look at it. I've had several conversations with Dr. Speaker on the phone trying to understand the report so that we can really get a feel for what it says. I'm looking forward to being able to sit down with the labs in Texas once we all get our information back and kind of, help each other decipher and see where we can do better in those areas. But yeah, the support of the intern was critical to us getting our information in.
And we're hoping that other laboratories, having heard from the ones that have gone through the intern process of data collection, that it is possible and they can do it, that they will approach the commission for support in that area. Or if they can fund it internally themselves, that's great too. I think DPS, they never asked for intern support, but they're doing it anyway. Do you have any exposure to I'm sorry to put Alice on the spot because she just moved to Austin from El Paso, but it's in process. I think originally they were doing a DPS in Austin, and now I think they've decided they're going to expand it to the regional laboratories, which is a bigger challenge because of just, it's not necessarily consistent in terms of how the information is kept from regional lab to regional lab. So that's Foresight. Academy meeting in Orlando. So we had submitted an abstract on the hair microscopy review, which was rejected by the jurisprudence section. I don't know what to say. No, they don't tell you why, but they don't like hair microscopy or something. I don't know.
Do you have any idea, Ron, why?
You should have talked to me. I have some, I'm not without any influence.
Well, but I didn't expect it to be rejected, so by the time it got rejected, it's probably too late. I didn't think I needed to grease any wheels. I thought it was sort of,
Are you going to the meeting?
I'm going, but I'm going to be bad the whole time. No.
I can certainly try to find out what the issue was.
Let's find out what the issue is.
Maybe they were afraid you were going to mess up their civil suits.
It might also be worthy of submission to the criminalistic section.
That's what I was told, but I think it's probably too late, right?
Well, it is.
Yeah.
But they could
Across the deadline, yeah.
They could do themselves to just send them to criminalists without rejection.
Yeah.
I mean, that's supposed to do. And they didn't do that. I mean, they did it with one of my students too. So without any explanation, they just rejected.
Yeah, I guess it
One
wasn't
of
of
the
interest to the lawyers.
Surprising.
Anyway.
It's the way you title
It was so plain vanilla.
What
that
is the title?
Maybe that was the problem.
If you had titled it, hair microscopy, how to get people off, or...
And file civil suits, yeah.
You might have gotten the lawyers and some people referring interest. I don't know, all of that.
No, it was something like, how to conduct a hair microscopy review without pulling your hair out one state's view, or something like that. And I guess they just didn't.
They didn't get the joke.
They didn't like the joke. They didn't get the joke.
Well, you could resubmit it, though.
Yeah.
Well, yeah, and that's
Yeah.
what I would suggest, is that we resubmit it for next year. We'll have more data, we'll certainly have more data at that point anyway, and I think it ought to be submitted for the listeners.
And actually, maybe it's more, for AskLad Lab is good too.
So I did
I know, I
submit
saw
an
that
abstract
one.
for, after being
I
rejected by
know.
the Academy, I submitted one to AskCloud Lab. I don't know what they're
No,
gonna
you
say.
you got accepted.
Oh, thank you.
You will know.
This
will
is the
get-
first news I have. But our abstract went into to AskCloud Lab for the symposium in April, and apparently we will be speaking there, so. Anyway,
Speaking of AskLab,
there's a meeting in Washington at which we will be presenting in April. And what we'll be presenting about is actually broader than hair microscopy. It's generally how state-based forensic science commissions can work collaboratively to help advance forensic science. And we're going to use some examples of things that the commission here has done. And I guess they liked that. So we'll be there. So the next item is electing a new Forensic Development Committee member and a committee chair. So Dr. Kerrigan chaired Forensic Development. And so we have a vacant spot.
I'd like to be a member, but not the chair, obviously.
Okay. So do you want to, is everybody okay with adding Dr. Hugh Stan to Forensic Development?
Yes.
Yes?
Yeah, that's a great idea.
Oh, thank you.
Would someone like to?
someone's got to make a motion.
I move.
Second?
Second.
Aye.
Aye.
Unanimous.
And then
You got it.
that group probably can decide who the chair is going to be the next time we speak. And the members of that group are Dr. Eisenberg, Dr. Hugh Stam, and Dr. DeMaio. Okay, the next one is really exciting, and that is a request, and this is all in your budget, for hair and fiber training. So hair analysis and fiber analysis training, which is something, of course, of interest to the commission because we're doing a whole hair microscopy review. There is an expert who's world-renowned, the best there is from everyone I've talked to. His name is Skip Palahniuk, and he can do 2 weeks of training. He would come to Texas, probably to Tarrant County, though we're not sure exactly where yet. He can train 18 hair examiners in 1 week and 15 fiber examiners in the following week, or at least that's who's expressed interest so far. The entire price tag for that is $20,000. There's information, materials in here that you all have seen. Mr. Palahniuk would, I think, be able to source some scopes from Lyco, who has said that they would support him in getting the instrumentation, because I'm not sure that any one crime lab would have enough scopes to train the whole group.
Likely not.
I believe, and Dr. Howe has really done a lot of the legwork on getting the proposal for Mr. Palahniuk and asking for this support from the commission. But I believe that it's 7 laboratories that have expressed interest, and that totals your 18 hair examiners and 15 fiber examiners. Do you want to say anything else, or did I cover?
No, you covered it very well. This started really because we were interested in having Skip come out, and we had some conversations with another laboratory in the area. It was certainly going to be cost prohibitive for us to bring him out ourselves or even split that cost with another laboratory. And so we have a new education committee through TACLAD, and through that education committee we canvassed queries concerning interest from other labs. We do have the 7 labs that are interested. 3 of them are in the North Texas area, so we considered hosting it at Tarrant County. Skip has been very gracious in all of our interactions with him. He has indicated that to the extent that his training lends itself to recording or archiving, he would certainly be willing to do that so that we could share those portions with other individuals that may be interested as well. So we appreciate your consideration.
Anyone have questions about it? This would definitely require a vote from the membership of the commission.
I think this is an excellent idea.
This is an excellent idea. I was just wondering, can we have it, some of the lectures to be video so somebody else can use it, or, students, or what, to be used for
We'll
that.
do the same thing with the lecture portion.
Yeah.
As we're doing with the other course offerings, so that it will all be recorded and then put up on the blackboard. I don't know, a lot of what he does is actually training with the scope. So obviously that piece we can't, but the lecture portion we can. And he has said that he's willing to do that, which is great because it'll take some effort on his part.
I'll make a motion that that the commission support this. Thanks. Great.
Second.
Aye.
Aye.
Nay. Okay. Yes.
The final thing is that we will continue to look for more training opportunities that are broadly applicable to examiners in Texas. If any of you have ideas, let the Forensic Development Committee know. One area that was brought up to me at the OSAC meetings in Oklahoma at the beginning of the week is that NIJ has really great training on the law, legal concepts for forensic examiners, and that we might talk to them about trying to get some of that material put on the blackboard for people to access, or at least a link to what NIJ has on that. So there are a bunch of different ideas floating out there, a lot of it coming from national efforts in the same arena. So we'll just keep trying to expand our offerings.
14 and 15 have to do with legislation, proposed legislation, which is going to be radical. Would that be a good way of saying it?
I guess radical is heavy. Well, 15 is really quick, which is that there has been some discussion about either creating an office of forensic writs, so appellate lawyers who deal with forensic issues in particular, or expanding the existing office of capital writs to include a forensic division. I haven't seen a bill on that yet, but I know that there's some proposals floating out there. It doesn't affect the commission directly, except that I think the bill would require the commission to send all of its reports over to that office so that they can determine whether defendants need to be notified and work with the prosecutors to make sure that happens, and have themselves available to represent people where that's needed. If there's a bill on that, it most certainly will come out between now and our next meeting, and probably go through committee between now and our next meeting. So if I get anything, I'll forward it to folks so you can take a look at it. If they ask for commissioners to testify on it, I will let you all know, and then whoever's available, if you want to come and get in front of the Senate Criminal Justice Committee or a House committee, now's your chance. Number 14 is a lot. This is a big one.
Yeah, this is what I was referring to, really.
So if you see under item 14, there's actually a draft bill. That draft bill, and we've been talking about this for a while, but this draft bill requires licensure of forensic analysts in Texas. I am going to distribute right now some suggested revisions to some of the definitions in here. If you look at the bill, the definition of forensic analyst, as it was originally proposed, is quite broad. It would cover defense counsel, which we think is probably not tenable at this point, even though desired by many. I think the defense bar would say, well, who am I supposed to hire if you require licensure of all experts? I'm not going to be able to bring anybody to testify in Texas courts because they often have to hire people from out of state to come in and testify. So the definition of forensic analyst under this bill would be a person who, on behalf of a crime laboratory accredited by the Department of Public Safety under section 411.0205 of the Government Code, technically reviews or performs a forensic analysis or draws conclusions from or interprets a forensic analysis for a court or crime laboratory. Those are the people that would be impacted by this requirement. The requirement is that you can't testify. It's very similar to accreditation. You can't testify in court unless you've got a license. The licensing is, the requirements for that are to be developed by the Forensic Science Commission. The entire program will be run by the Forensic Science Commission. That program will be run by the commission with support and advice from an advisory board that consists of members nominated by the TACLID and one representative from TCDLA and one from TDCAA. And very similar in structure to the way that we have the commission appointments. So what would happen is that group would make recommendations to the commission about what the requirements for the license would be. Those requirements can take into consideration existing certification programs that are available nationally. So if you are accredited by AFTI, for example, then the commission could decide, with the advice of the advisory board, that that is pretty much what you need to be licensed. It can't be exclusively that, but it would supplant any other examination requirement. So the initial piece of this bill is sort of the planning process, the planning years. The requirement itself, just so people aren't too scared, won't take effect until January 1st of 2019. In the interim, the commission will be required to tell the legislature whether they believe that any grandfathering is appropriate. So, in other words, if the advisory board works on it and says, look, we just need to grandfather a whole bunch of people in and then start with new examiners, that's something that can be discussed. To what extent is that appropriate? So, to what extent does this bill need to be revised before the requirement kicks in January of 2019? So there are opportunities to communicate to the legislature any revisions. It's a huge undertaking, but I think the Texas Association of Crime Lab Directors has been discussing this for a while. There was a lot of discussion about what was the right place to put this bill. In other words, what agency should be in charge. And the options were essentially DPS, which runs the accreditation program, the Department of Licensing and Regulation, which does occupational licensing for a very diverse group of people, from electricians, architects, barbers, all kinds of people. And ultimately, Senator Hinojosa made the call that he wanted it to be with the Forensic Science Commission. Obviously, this would require an expanded budget, maybe not right away, but certainly by the time that the next session comes, it will. And the other really important piece of this, and this is something that I think people need to really think about and talk about, is that the commission right now is administratively attached to Sam Houston State University. We're a special item in a higher education budget, which is not a good place to be. Special items in higher education are designed to be temporary projects, startup funds, and then the university is supposed to decide whether to bring that project into its overall general budget. That's what these things are for. How the commission ended up a special item in Sam Houston's budget, I don't know the history of that. I wasn't here when that happened. But there is real concern that if the commission's authority is to expand to include licensure of professionals, that it is not appropriate for it to continue as a special item in higher ed. And every time the budget comes through the legislature, Lee and I sit there waiting for the vetoes, because every single session there's a whole bunch of special items vetoed out of existence, and it's literally done like that. because the governor has said, at least Governor Perry, and I don't think that our new governor will take a different position on this, but that there are too many items, projects that get put in as a special item and never leave. In other words, there is never any assessment done as to whether they should be brought into the general budget or whatever. In light of all of that, what Senator Hinojosa is suggesting is that the commission's administrative attachment be moved to the Department of Public Safety. Now, that the downside to that, I think, is obvious, which is perception.
Most of the labs are run by DPS.
And DPS has all these regional labs, and we have regulatory authority over DPS. The way that it's envisioned and working is that there's no reporting structure at all. So in other words, it's not like we report to the director of DPS or to the commission that runs DPS, but rather that it's just a whole independent entity on the side, and that we would be put there for essentially budget security and administrative security, and because I'm not sure I don't know where else the commission would go. And I think Senator Hinojosa's not sure what the other options are. But he's not, besides standalone. So the ultimate goal is to get the commission out from under everybody and to be a standalone entity. If the commission becomes a standalone entity, we would have to have an office manager who's familiar with all of the state auditing rules. We'd have to have our own accounts. We'd have to have our own purchasing process. There's a lot that goes into that because there are rules that you have to follow. And we'd have to have somebody that processes payroll and all sorts of things. That is something that is possible. There are certainly people out there that the commission could hire to help us fulfill that function. So another option would be to put some sort of time restriction on the parking at DPS until such time as the commission's ready to go out on its own. The ultimate goal is freestanding agency. But with the current budget, it would be hard to get there right quickly now. So those are all the things I can think of that are in.
Lynn, I had a question about the definition here. Coming back to forensic analyst, if you look at the language, which is original language, which says that a forensic analysis or draws a conclusion from or interprets a forensic analysis. So will the DPS make a rule that will exempt medical examiners because we frequently draw conclusions and interpret forensic analysis?
So we talked about that, and part of the reason why we added this language that says a person who on behalf of a crime laboratory accredited by the Department of Public Safety technically reviews, performs, or draws conclusions from or interprets. The thought was that that would not include medical examiners because medical examiners draw conclusions from and interpret on their own authority.
Not from the crime lab.
Not on behalf of a crime lab.
Say you are testifying in a court, it says for a court.
Well, we have a license. You have a license to practice medicine.
Right.
And they may say that license will then qualify
Correct,
for what
but
they're
then
talking about.
would somebody interpret and say, then you have to be a forensic analyst and be licensed?
That'd be more specific.
I think it's a gray area.
The way it's being interpreted by most attorneys is that these people have to be employees
of a crime lab.
of a crime lab, and
Which
medical
examiners
are
are
not
not.
employees. of a
That's,
crime lab.
I think that's an interpretation, but the language is not clear. So why not clear it up?
So if you say, so you can add a sentence that says this does not apply to.
I think so.
Because medical examiners, well, a lot of time you take the toxicology and you interpret it in the court completely. So
every day.
So every day that was you do. So that's somehow you have
So
to
that
be-
was an issue that's been raised, and I think the TACLID group that worked on it thought that by adding on behalf of a crime laboratory, you would not bring the medical examiners in, but if that is not clear enough.
I think it needs
Just
further
put a sentence.
clarification.
Yeah, you make a specific sentence and then
doesn't
that
apply to
addresses it
medical
directly, and then you don't have to worry about someone then arguing later in
Right.
court that this didn't exclude the medical
Correct.
examiners.
So certification of medical examiners is a separate
Where's that?
issue. That's not in here.
Oh, okay.
But that is something that has been discussed, and I think the TACLID's concern, as expressed yesterday, was that if you include a requirement that medical examiners be certified, it'll tank the bill because there's controversy around that.
Well,
I would support that, but in the
okay.
past, that has not been successful on behalf of the medical examiners.
the ones who tanked it the last time are gone.
Well, but you know, the
But
Council of
you-
Urban Counties may have someone they refer to, and they carry a lot of
Okay.
votes.
I have talked to in past years on this, and the Council on Urban Counties asked me, well, you know, this is going to be expensive. I said, you don't understand. The medical examiners pay for their own certification. As soon as I said that, he said, oh, that's fine, no problem, then. And he walked away.
I think the issue is not about paying for certification. The issue is, do we have certified forensic pathologists in the country
What?
to meet our needs? Maybe we can say that who cares
Okay.
about the
Well, how
country,
many-
we only care about Texas.
How many non-certified forensic pathologists are working in Texas?
I have no idea, but I think we need to
Well,
investigate that.
When you exclude out the training year, which you have to get through
No,
that.
that's included, that would
Right.
be included.
I don't know, there may be, well, there's 5 or less probably.
If even that?
If even that,
there's a
I'm just
provision-
giving a very liberal,
There would be a provision to grandfather.
well, then that would change,
Yeah.
that would take those objections by the
Right,
labs.
so
that have-
it grandfathers.
There is no existing bill on medical examiners. The question is, what should be done about the medical examiners? And that's tricky because, just
think if
because
you-
it is. I
I
mean,
think if you took the proposed addition to this law, okay, and you submitted it as a separate bill, it will pass. The counties are, the county associations want to know how much money it will cost them, and it won't cost them anything. Because I've talked to them, and as soon as you tell them no cost, they say, oh, that's number one. Number two, if you grandfather, that should take anyone, but I only know of one person.
You know, we have 5 medical examiners, and all of us are board certified in forensic pathology, so I'm not speaking for my office or on my behalf. I really foresee that this is an area that should be addressed in 49.25, and let 49.25 tackle that issue.
I think there's a valid concern that it could bog it down with a different topic. I think it's a valid topic to discuss, but when there were amendments proposed to 4925 in the past, it got killed. But it's applicable to 4925. I would agree that it should be addressed. I don't know, it needs to be addressed in this, other than excluding medical examiners.
We do need to clean up 49.25. I think 49.25, for example, talks about people who are unattended with long medical history. Physicians don't take care of those deaths, and all those issues have to be addressed, which we have failed to address. But I think we should address that.
I agree with that, but that's
It's a different venue.
That's a whole different topic
But I
than
think
this.
if the senator wants to propose, it's up to him, a separate addition to that law, just put that in. And the way I saw that he had proposed, it should not, it will grandfather the people who aren't. And so that shouldn't be.
well, I think they're likely to come back asking questions, and there'll be a hearing on it. And so there'll be lots of opportunity for discussion about what the appropriate thing is for the medical examiners.
Okay.
This bill really impacts the Forensic Science Commission, though. The licensure of forensic analysts. Let's say that we're able to take care of the medical examiners separately, or nothing happens with the medical examiners and they're exempt. We still have this bill, right? And so part of the point of this bill is to give some ability when you have misconduct by an individual examiner, their license can be revoked. I mean, there are things, actual.
They're governed by the board. I mean,
Right.
we have a system and a due process in existence. So I don't think we should really tackle it
So
at our
but
level.
everyone has to realize this isn't going to expand our duties.
Right.
So,
You have to define what appropriate training is, you have to define what a certifying examination
Yeah, but
that's acceptable
the
is.
But there'd be a
Right.
subcommission on that.
So there's an advisory board that I described, that's entire job it is to figure all that out.
So who makes up the advisory board?
It's, I just want to make sure I get it, the number right. So it's
was nine.
9 members, 1 prosecutor, 1 defense lawyer, and 7 members who are either forensic scientists, crime lab directors, or crime lab quality managers selected by the commission from a list of 20 names submitted by TACLID.
So if a person, if this bill was passed, since apparently it only affects states' witnesses, and there's someone who loses their license, the next day they can go to work for Bobby. They can be a defense expert because they're not covered by the act anymore. So what's the point of this bill? I mean, it's not going to keep bad science out of the courtroom, it's just going to make it the exclusive province of the defense side to be able to use that bad science.
So the point is to raise the standards and to start the process, and then bring the defense experts in at a later point. I think the thought was, and I'll let the TACLID membership talk about this because they had extensive conversations about it,
Yeah.
that ideally everyone would be covered, but
What
that
about out-of-state experts?
out-of-state experts who work for a DPS-accredited crime laboratory and come to testify in Texas will require a license. But it's starting off with accredited forensic disciplines and DPS, employees of DPS accredited labs. Now, one example of a DPS accredited lab that performs analysis for courts in Texas but is not physically located in Texas is NMS. That's probably the biggest example. So they would have to be licensed by the Texas Forensic Science Commission.
I don't think they'd have any problem.
We'll
Well,
find out.
you know, one issue you brought up, if someone loses their license and they go tomorrow and they're a defense expert, is on the cross-examination, is the whole issue can be brought.
Yes.
And their credibility would be at least discussed as to why they're no longer certified. I mean, so there is one means already for that, but it wouldn't keep them out of being able to physically appear in the courtroom.
Right.
At least currently the way this is.
But I mean, that same thing can be said, I mean, you can accomplish the same thing now with the laboratories.
Yes.
And it
Yes.
happens on a regular basis. So again, I mean, I guess my concern is, what is the anticipated goal of this that is not already available in the court? I mean, the only difference I see is that you can cut off the ability completely of someone testifying for the state in those situations, and you can't do likewise for the defense experts.
Well, I would,
There's no standards
Well,
for
it
defense
has a whole-
experts.
But would the defense want to call an
It-
expert that has their license has been revoked?
They do it all the time.
Probably a lot cheaper there.
It is a lot cheaper. I mean, it's harder to call, I mean, I'm not trying to bash what the defense experts in general, but there are instances where, I mean, what passes for science there's very little control over it. There's a
But-
gatekeeping judge and that's it.
Yep.
But the way it is right now, like if this is, I'm not sure if I can interpret it or not, but just something like this. So if you are not working in accredited laboratory, you cannot come to the state of Texas and work for the prosecutor and interpret the result for them, which I do it routinely very
For
much.
this-
And Sarah and everybody does it quite routinely. So we cannot do it anymore. That's right.
you would have to be licensed, that's all.
But we cannot be because we are not working under crime laboratory. We are not behalf of crime laboratory coming
No,
to
but,
do that.
but only people who are
Working for the lab.
working for the lab
Are required.
are required to be licensed
You're not required to be.
right
Because you're not
now.
working for the laboratory.
So that, but still can do it, but just the
You
court,
can
I
as
mean,
it, you
that's
can
a-
as it
because
currently
I don't- I mean,
stands.
I
Do you
don't-
stay with the
not-
license, I think is what you, if you just retire, you stay with the license.
No, I don't think you can stay with your license.
So
You
there's
can
also
take
going to be a sort of a voluntary licensing component, so you can maintain your license, and then when you get into court, you can say, yes, I am licensed, I've maintained my license, I don't work for a DPS accredited laboratory anymore, but I still have it.
Well, from that standpoint, it works with like the medical license. If you're willing to pay for it, they're willing to take your money and keep your license. I mean, it'll become a revenue generating
I
event.
think that's,
So, Dr. Mosiani, the way it's written right now, if you are not currently employed by a DPS accredited crime laboratory, this licensing requirement does not apply to you.
but why doesn't? That's that's
Because-
why we cannot do it, that everybody can come and just, if they are presenting to the court or they want to come to the court, somebody evaluate them to be sure they are licensed
I think
in
the
Texas.
perception is that it would be, you have to start somewhere, and that taking that on would be such a huge undertaking that there would be no licensing program ever, because it's just too much. I mean, you guys want to talk about this?
It's a big body. You know, if you
Yeah.
take in everything,
No, I agree with that.
it's gonna be it'll never go anywhere. What we looked at doing is let's look at what the accreditation covers. Let's start there. We didn't even take in all the scientists. I mean, the latents is a whole nother issue. But because the commission doesn't oversee latents, we felt like that was too big of a bite to take the first time. We can see it developing and taking over those functions.
Bill, I oversee, actually, just from my experience, I see the people that are testifying, and they are not, the people from crime lab are not the problem that much. The people that they come and testify, they are really, you want them to be sure somebody check them when they come to the court.
And I agree,
So,
but I
and
think
that's not
our
here.
reasoning is we have to start somewhere, and we gotta get it instituted somehow. And for us to start with our own people and say, look,
It's
we're
easier to
governing
do
our
that,
people, now we
and then you can
expand.
add on later on.
The problem is if you do this, and for people who aren't employed by the state crime lab, and I was a judge, I'd throw it out. Because the defense attorney would say, well, what they're doing is they passed a law, so I can't hire any private
That's right.
people.
That's
And
right.
therefore, you're violating my client's constitutional right. And you know what? Is the judge going to throw it out? Probably.
I think that's a huge piece of it, is defense access to experts, right? What they would say, and Bobby, let me know what you think, but if you required everybody to be licensed immediately, then you would lose a huge, I mean, who do you hire?
That's right. You can't do it.
Now, I think, you guys correct me if I'm wrong, but I think the Taclic's thought was, let's stand up together and say, our people first, and then we'll talk about everybody else.
Can I just jump to something, the National Commission? They're going to probably push a recommendation also that everyone in crime labs be not licensed, they would say, certified, certified.
Are the crime labs all unanimously supporting this, Dr. Howe?
Well, I can tell you that we had 3 independent position statements that TACLAB voted on. One was a statement regarding monitoring of developments on a national level, kind of taking a wait-and-see approach to see what developed federally concerning mandatory certification and what trickled down nationally. Number 2 was a mandatory state-run certification program. Number 3 was this licensing program that you see in front of you. We actually voted twice. We had a runoff vote between 2 of the positions that were very close in the voting. One of the positions concerned monitoring at a national level. The second position was the licensing position. We had 13 voting members of TACLAB who actually voted. 7 members voted in favor of the licensing position. 6 members voted in favor of monitoring on a national level.
So it's a close vote.
This is not a unanimous support by the
I
crime
have
labs
a-
in Texas.
Neither
Well-
was there for standards in forensic pathology. It passed by just a hair.
Do we have any experience to draw on from other states?
So there are very few that have gone in this direction yet, and I think North Carolina is one of them, but they only have their state crime lab to contend with, so it's easier.
Easier.
It's sort of like if DPS was the only one, and then
Yeah.
they run it internally, so it's not really, I can't think of any state, and I haven't heard of any state, and you all would be in a better position to know, that has as diverse a group as Texas has in terms of laboratories that has initiated something like this. Do you all know of any?
I just have a question. So if the person is in the medical examiner, like for the Austin, Travis County, the medical examiner, and there is a lab, toxicology lab,
Yeah.
they don't need to be licensed?
Oh,
Because-
they're accredited.
But no, but just doesn't say that, are they going under forensic analyst? Do they go with that? Because they are not working in the crime lab. They're working in medical examiner lab, so I know.
Yeah, but that portion is accredited. And if it wasn't accredited, the medical examiner would not be able to testify.
But that person yesterday from that lab was not one of the members that could vote or not vote in that one. So it's not a member. So it was just yesterday, I mean, I saw that I was looking for somebody and he wasn't there. And apparently he's not the member because he's the chief toxicologist, not the, and they don't have, I mean, you know what I mean? Still, I think some.
The chief toxicologist working for the Travis County Medical Examiner's Crime Lab would have to be licensed under this program.
Correct.
The medical examiner,
No,
the
that's
theory, the thought is would not be.
Okay, so.
Actually, interpretation of forensic toxicology in deaths is not part of the job of a toxicologist.
Also, I think maybe that the crime laboratory should be changed to forensic laboratory, and that makes it a little better, maybe.
Well, but the qualifier is that it's accredited by the Department of Public Safety under section 411.0205 of the Government Code.
Doesn't matter what you call
So really,
It's accredited.
I mean.
Well, we have a forensic odontology lab and forensic anthropology lab in my office, and that's not covered by that. So I think the crime lab is appropriate name, and as you say, it's already been defined.
it. Right.
So we shouldn't leave them as a, not forensic laboratory, just be
No,
crime
crime
laboratory?
lab,
Because
yes.
forensic laboratory.
Because there are other
I mean,
labs that are forensic labs.
They have different names, that's it.
Yeah.
And the definition
crime
of
is
forensic
just kind of
analysis in this bill is only the accredited disciplines. So if forensic anthropology is exempt from accreditation right now, it
It's
also
going
will be exempt from the
From that.
licensure scheme, at least initially. That applies to latents, it applies to digital evidence, it applies to all those that are either exempt by statute or by DPS rule. Is that clear?
Yes.
You guys have any?
Do you foresee any opposition coming from crime labs in Texas when the bill comes to the committee hearings? Because you need a couple of people to create a lot of problems, and you need a senior senator to kill it. Hold the whole thing in a committee meeting, and then the sunset comes and the bill dies a natural death.
There's crime labs out there that do not participate in TACWID. They may come fight it. We don't know that. I know that as TACWID as a group, we're not unanimous on this, but we know we need to do something, and so the best way we can do that is to take a vote and move forward with something.
I mean, you are half and half, literally, and it's not even unanimous. I mean, you're far from
I
unanimous.
understand we're not unanimous, and I'm not saying that somebody may not step up and say they don't agree with it. I think where we've bridged a little bit of that gap is by having everybody involved in the process so that people really understand what we're trying to do and what we're pushing. I think that's helped quite a bit. I'm not saying that everybody's turned towards favoring it, but I think really open, very spirited communication about the subject. And, you know, but I can't sit here and tell you that, you know, a lab director is not going to show up and fight it if it goes to the House.
And it could be that that happens. It could be that the bill dies for any number of reasons. Often bills don't pass on the first go-around. That's happened in many areas of forensic science or forensic regulation. The bill clarifying the commission's jurisdiction didn't pass on the first go-around. It wouldn't surprise me at all if this took two bites at the apple, so to speak, and if in the interim the National Commission
Generally
comes
what
down.
helps is that everybody is on board.
It's coming down.
And it doesn't look like the crime lab itself is everybody's on the board, half and half, literally, 7 against 6.
Well, I mean, I was at the TACLID meeting yesterday, and there were a lot of members there, both on the phone and physically present, and they went over this whole bill. And, I mean, I didn't hear anybody say they were going to come and testify against it. Or...
The bill has already been, that motion has already been passed by the group, and so yesterday really wasn't representative of the initial discussions that went on. And, you know, I'm still trying to figure out what it is that we, meaning the community, is trying to accomplish with this. We know that there's going to be federal legislation, and even though Senator Cornyn's office has assured us that this is not going to conflict in any way, it doesn't, there's no assurance that we're not going to have an additional burden when the federal legislation comes down and says we all have to be certified or whatever, and that's going to be 2 things that we're going to have to do in Texas, and one thing that if you cross the border to Oklahoma, you only have one thing to do. So, you know, there is some discussion about this. And
we have been told by...
May I say something? The commission is probably going to come forth. I'm not dealing with that. So with certification of, they're going to say there should be universal accreditation of crime labs, which Texas already has. And they're going to come forward with certification. The problem is, and I hate to tell you this, is they have no power over medical examiners. They have a lot of power over crime labs. Do you know why? You get federal funds. Medical examiners don't. But crime labs get federal funds. And what they're going to put in the bill, I don't know, I mean, I'm assuming this because these people want it. What they're going to put in the bill is you're not going to get any money. It's as simple as that. So if you set up something here ahead of time, you're going to be ahead of the game. They're not going to tell you probably how to certify, but they're going to require certification. And usually the certification they're thinking of is what you have here, where you have it, you know, you don't yourself give the test, but you accept the credentials from other organizations.
So my understanding on Cornyn's bill is that his office has said that what Texas is contemplating will satisfy what they have put in that bill, period.
That's what I'm saying too.
So you know, it may just be that it may be that the Cornyn bill never passes and that Texas's requirement kicks in 2019 and Texas is one of the only states that has any requirement. It may be that Cornyn's bill kicks in and we're all just doing what we would have been doing anyway. It's hard, I don't know, we'll see. But I don't think that anything that Senator Cornyn is planning, and the bill now is going to be just Cornyn. So it's a Texas senator, and I don't think from conversations with that office and what I've heard about conversations with that office that they plan to impose anything additional than what the state legislature in Texas would impose. And they're very big on states' rights. I mean, that's a huge fundamental piece of his whole philosophy. So
yeah, I think these standards, from, you know, being on the board, National Commission, they would look at that as great.
But again, I mean, it's entirely possible that some lab directors could come in to the legislature and say, we're not ready for this. We want to wait, and then the bill may die.
Is there any attempt to gain support from district attorneys and police association, the sheriff's association in Texas for this bill?
If that happens, it'll happen by Hinojosa's office, and he'll have to talk to whomever he thinks needs to come in and support it. I mean, we are in the question answering position. They come to us, they ask questions about the bill, they ask about implications of the bill, we respond. But I don't think that it's appropriate for the commission to go around to other organizations.
We can't do that. Which committee is going to debate this bill, and who is the chairman of that committee?
So we don't know yet. Those are going to be announced by the end of January. If it's the same as it has been, it would be Senate Criminal Justice. That's traditionally been chaired by Whitmire for many, 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 many years. Whether that stays the same or not, I have no idea. It may change.
Yeah.
On the House side, they're looking at consolidating committees, I think, in both the Senate and the House. So we don't know even what committees will exist. If it's the same as last time, it'll be that. And on the House side, it would be criminal jurisprudence or public safety and homeland security. And those chairs will be announced next week.
Okay. I'll keep a lookout for it.
I think we just need to keep monitoring, and we need to, every time I hear anything in terms of updates, I'll talk to the legislative group and see what they want to do. If we get requests for testimony, I'll put it, the same thing, it happens the same way every time. We send out emails. We say, can you come and testify? Who wants to come and testify? Sometimes they want a scientist, or they want the chair, or they'll say, and sometimes they call you like 3 p.m. and say, we need somebody at 10 a.m. tomorrow. So it's getting into the legislative session is really tricky because things happen so quickly the way it's all set up. But anyone on the commission who wants to come testify or speak about potential implications, answer questions, you're welcome to come. Last session we played a little trick on poor Richard where we told him he had to be down in an hour or 2 hours from Fort Worth. We'll try not to repeat any of that. But sometimes it really is that tight.
Or the medical examiners who already know my opinion of accreditation and standards. A number of years ago, I warned you what was coming down the line, and I was right. And I'm going to tell you right now, accreditation and certification of crime labs is coming down the line. And if you don't get ahead of it, you're going to be run over. And even Bill Oliver admitted that I was right, which is a miracle.
Well, what you don't want is you don't want someone who is not in that area making rules that then make no sense.
That's what the problem is, and that's why you have to do it yourself. So the crime lab people should do it themselves. Otherwise, somebody else is going to do it. And I've seen some of these examples. And boy, have you got problems if those other people get their way.
Yep. And some of the people are concerned about the federal law coming down. If Florida's law gets passed, we're working on these rules for 2 years. So if it does get passed in a period of time where we're working on the rules, then we adjust our rules to take into account anything extra that the federal guidelines.
Right. But
the requirement doesn't kick in until January 1st of 2019.
gives you plenty of time.
So everything up until then is planning. So at least that's one advantage of structuring it the way they did.
Will it mandate that everyone has their licensure by 2019, or that's when they start having to address what the requirements are to become?
So the requirements will start to be established as soon as this bill passes?
January, but I think it's
that answers what
January 1st,
assuming it does?
2016.
At all. And in the interim session, the commission would have to report back to the legislature about two things. Should anyone be grandfathered? Because one approach is to grandfather everybody and just start fresh with new examiners. Number two is, should any revisions be made to the bill that they passed? So that set of recommendations could take into account, hey, this now, Cornyn's bill passed, and so let's tweak it this way or that way to account for that if that needs to happen, or they've done something at the National Commission, let's change it. So there's opportunity for changing it or grandfathering if that's what the commission and the advisory body decides is appropriate.
The Federal Commission, what they're envisioning is giving people 5 years to get certified, with the knowledge that they will have to extend it, but the law will say 5 years, and probably they will then extend it because they don't think that everyone will get it in 5 years. But they said they don't like to put anything in law more than 5 years.
Well, that was the other thing is, when the legislative directors came back with this draft and said January 1st, 2019, and the response was, well, is that as late as you can go? And the answer was yes, but we'll put in a report to the legislature in the interim, so if you need to extend it, if you need to change the bill, if you need to grandfather, you can. But they weren't comfortable. They literally said this is the last day that we can give you and have this thing pass muster. Because we can't extend, we just can't give you a date so far in the future because I guess it...
That's 5 years, isn't it?
I guess it makes less incentive for...
Okay.
Getting things done.
I think that covers everything up to this point.
I think we should do 16. Or do you want to eat lunch? What time?
Can we have a working lunch, please?
Working lunch?
Yeah.
Working lunch.
We probably should.
Do you want to do 10 minutes to get our lunch?
Okay, 10 minutes. We're going to break for 10 minutes and get to lunch.
Guidance for judges and lawyers on forensic discovery issues in collaboration with Judge Hervey. This was something that came up. A lot of laboratories struggle with answering very broad discovery requests. And I know this has been an issue in Tarrant County and in some other counties. And so the suggestion was made to ask Pat Johnson to do a study for the commission on what types of discovery orders are out there and to offer an opinion from a scientific basis or the lab's perspective of what are key items that should be given as a matter of course, and then to rank some of the other items that are found in discovery orders according to two areas. One is what information they may or may not reveal, so that's on a sliding scale, sorry. And then the second one is what the burden is on the laboratory to produce the information, with the idea being that it would be a guide that would be developed and Judge Hervey would give it to judges as part of their training so that they can understand when they're looking at a discovery order what the key issues are, what should be given, what are really things that are being requested that will add to the overall burden of the criminal justice system in terms of adding to backlogs, because in a lot of laboratories, if you don't have a dedicated person whose entire job it is to answer the discovery requests, you're pulling people off the bench to do that work. Now, this document here that we distributed is a draft version of what Pat did for us in terms of an analysis. This will be looked at by Judge Hervey, and so we've already talked about some suggested revisions. For example, I think we need to add an introduction from the Commission's perspective about you know, why we assemble this information. It's designed to help assist judges in understanding, for example, key terms. We have a glossary of terms commonly found in discovery orders. I think there's a perception that sometimes the reason that judges just say, yeah, give them everything, is because they don't understand what's even in the order. They don't know what that means. They don't know what a pipette is. They don't know a lot of things related to science. This by no means is intended to suggest that defense counsel shouldn't, in some cases where appropriate, get everything that they're asking for. And this is by no means, we're not under any illusion that there aren't going to be judges who say, I don't care about your guidance, give them everything, and there'll be no limitations. And it's going to vary depending on the philosophy of particular judges, the facts and circumstances of the case. But the idea being that judges be given some information in order to make decisions about what discovery items are appropriate, what really informs a criminal case, what doesn't, what it takes a lab to pull these things together. I think what Pat would probably tell you is that, and he actually says it in the study to us, is that it's not like one item is necessarily problematic. It's the accumulation of 26 different items, half of which are not going to reveal any information in any conceivable situation, or very little information. But when you add all that together, the burden is significant. The other thing is that judges like to receive information like this in training that they do themselves. They don't attend trainings that the rest of us attend. They do their own thing. They have their own judiciary college, and this information would be given to them in that context. And again, it is by no means intended to preempt defense counsel from asking for whatever they want and from articulating, hey, this guidance says X, Y, or Z, but here's why in this case, Judge, you need to give me this item. This item is appropriate, you know. So with that, I don't know if you had any other thoughts. Pat talked to a lot of labs in compiling this. Did you want to?
Well, I'd like to thank the commission for giving me the opportunity to work on this project. It's something I was interested in for several years. I know when I was with DPS, all of our labs are clearly burdened by responding to open records requests, subpoenas, and especially court orders, discovery orders. And a couple of things have happened, not just with DPS crime labs, but I think all labs in Texas. Most of these discovery orders are on DWI cases, probably 90% of them. And that's number one. And number two is the number of blood alcohol tests performed by crime labs has basically skyrocketed over the last 6 or 7 years. So not only are labs analyzing way more blood samples for alcohol, but accompanying that is all of these discovery orders. So this is a relatively new problem that's developed just in the last 2 or 3 years. And it's a problem because, as Lynn indicated, you know, you get a court order and you got a couple of days to respond, or 10 days or whatever, you pretty much drop whatever else you were doing to handle the court order, so you keep out of jail. And that's pretty much, so what has happened at DPS is we're taking chemists off the bench who typically would be analyzing these samples to spend 4 hours or a day or 2 days to respond to a court order. So that's the problem. And just to talk about the magnitude of the problem, I know I visited Bill's lab at Austin PD here about a month ago. I'm going to give you approximate numbers. They get about 2,500 blood samples a year that they've analyzed for alcohol. But they did 400. They responded to 400 court orders last year. So about 1 out of 5 samples they're having to respond to a court order. The other issue is it may only take you, all labs pretty much run their blood alcohol samples in batches. You usually run 30 or 40 samples in a batch. So it only takes you probably on average an hour to work the blood alcohol case, start to finish, including writing the report and shipping it off. So it takes about an hour to work a case. My findings in this study are that it takes anywhere from 4 hours to maybe 16 hours for a lab to respond to the discovery order. So we're spending more time responding to these orders than we are analyzing the evidence. So that's the problem that the crime lab's had. And so what Lynn asked me to do was take some court orders that labs have been receiving. I think there's about 5 of them attached to the back of this report. The most extensive order we've seen show up in Tarrant County. We've seen it in West Texas. We've seen it, or a pretty close, similar one here in Austin. And they're asking for like 35 different items. And as Lynn said, you know, responding to any one or even a half a dozen of those maybe isn't too burdensome, but by the time you address 30 or so items of information that they want, it takes you maybe up to a couple of days to respond. So what I was asked to do is, not from the legal standpoint, I'm not an attorney, but from the science standpoint, take one of these court orders that's really extensive and look at each thing that's been requested, each item that's been requested, and from the science standpoint, make some judgment of how relevant is this information. Typically, it's the defense that's getting these orders, so how relevant is this information that's being requested to the defendant? So that's what I did in this report. Lynn had given me a scale from 1 to 5. And so I was to rate those items 1 to 5 on their relevancy or their significance from the science standpoint, and then to evaluate them on how difficult is it for the lab to provide this information. And let me back up right there. I think it's safe to say crime laboratories across Texas, if not across the nation, are in this evolutionary step of basically going paperless. Some maybe are paperless today. I know the DPS labs are not. We're probably about halfway down that trail. So to be able to respond to these court orders efficiently, really the lab needs to have all of this information that's being requested stored electronically. Not only that, you've got to have it in a structure where you can find it. And that's the other problem that crime labs have. Most labs in Texas are not there yet. A lot of this stuff, we're having to feed pages into a scanner and scan them, and we do that. Once we get a court order, if this is the case that the defendant's interested in and we get a court order, we're feeding documents into a scanner to scan it to get it into electronic format, and then we can email that or put it on a floppy disk or whatever. So, again, the problem that the labs ultimately have is they need to get all of their records, at least all of the records that these court orders are requesting, and put them into an electronic format. But then, just as importantly, they've got to be organized where you can retrieve them readily. And once you do that, you know, answering even these 35 item orders can be done without a huge investment in people. So that's what this, we kind of, in the report, I first recommended about 6 items that I considered after visiting the Tarrant County Medical Examiner Lab, the Fort Worth Police Department Crime Lab, the Austin DPS Lab, the Austin Police Department Crime Lab, and then getting comments back from the Jefferson County Lab and the Harris County MD Lab. I kind of incorporated their input to address these issues in here. So it's not just my ideas, it's a compilation of all of their ideas. And again, as Lynn said, I was part of my job was to propose a kind of a model corridor. And I've done that, but I do that with a lot of humility, because the last thing I want to do is make today's situation any worse. And then as y'all have said, really this is ultimately a decision that's up to the court. But I did propose 6 items that I think a lab could readily provide on each one of these. They're listed here on page, probably about page 7. Actually, it starts on page 6. Every case that comes into a crime lab, you create a laboratory case file. So on a DWI case, we're talking about a blood sample that's submitted to the lab, and there's a DWI offense. Whatever the law enforcement agency is, they've got the case information, the name of the defendant, the county of the offense, the date of the offense, and then there's a blood sample that's been drawn usually at a hospital. So that's the evidence in the case. In the case file, you've got, the chemist takes that blood sample, runs their test for ethanol, puts all of the results of their test in a case file, and you've got your chain of custody record that's in there. So obviously, to me, the first item that you would want to provide to the defense is that case file, and it'll have the lab report, whatever submission information you got from the submitting law enforcement agency, your chain of custody on that evidence, all records of the testing, and then generally with a blood alcohol test, you're going to run the sample through a gas chromatograph or some labs do a gas chromatograph mass spectrometer. So you've got the chromatographic spectrum that's provided. That's the case file, and so that would always be requested and be provided. All of that information is pertinent to the case. Most laboratories, probably every lab in Texas, has got a laboratory information management system, the LIMS, and most of its case file information is in the LIMS. So retrieving that information, the case file information, should be relatively simple. I know at DPS we're still handwriting out worksheets, work notes, but those can be scanned in and be part of the case file in the labs. Every lab's got standard operating procedures for everything they do. You have to do that to be accredited. So providing that SOP for your alcohol analysis, everybody's got that electronic somewhere, and it's pretty easy to provide that. Again, all blood samples are tested for alcohol in a batch. I don't know anybody that doesn't do that anymore. When I was doing this 40 years ago, we did them one at a time, but now those days are over. Now you do them 30 or 40 in a batch, or 50 maybe. And so a lot of the attorneys want all of the records for that batch. And again, I speak mostly from experience at DPS. We were not keeping that whole batch of records in one location. What you end up is you get the chromatogram, the chart printed out for each sample, and you'd put that in the case file. But again, if you ran 40 of those, you'd have to go retrieve those from all 40 cases of the batch. Those days have to be changed. You're going to have to store that full batch in one location electronically, but that's a change that the DPS lab certainly can make, and maybe some of the other labs have already done that. Then there's 3 other items here that I think should be routinely. You have to calibrate your gas chromatograph. There's 2 things you do. At the very beginning, you validate your method, including whatever instrumentation you're using, and you retain all those validation records. Again, that's another accreditation requirement. Pretty much a lot of the stuff that the attorneys are asking for, all of that's been, what's the term? It's all been inspected and audited by an ASCLD or an accreditation assessor. So we're already doing a lot of these things. So anyway, you have the calibration records for your instrument you're using. That shouldn't be a problem for labs to report that. The training of the analyst, again, under the accreditation requirement, every testifying analyst has to have a CV, and it's got all of their formal education, their degrees, but then their continuing education. And so the training basically is documented in that CV. And I know at the Fort Worth ME lab, that's what they provide when they get a request for training records. They provide that curriculum vitae. And then lastly, proficiency testing. If that term, if you're not familiar with it, is defined in the glossary here, but most of these court orders, they want the analyst last 3 proficiency tests. Typically, if I'm a blood alcohol analyst, I'm required by accreditation standards to do 1 proficiency test, a minimum of 1 per year, and the lab maintains all those records. And so providing those, that is pertinent information, and providing those should not be a huge problem. I then went on with 7 through about 24 additional requests that are in one of this most extensive order, and I've evaluated again how relevant they are and what's the burden on the lab. And as Lynn said, providing any one of these is not particularly burdensome, but when you add 24 of them, you're talking spending a day or two to gather up all these records, unless you've got all of this information in a digital format and highly organized. I mentioned in here that there are software programs designed for keeping this kind of information. The Tarrant County ME lab bought one of these systems 3 years ago. It took them about a year to customize it for their uses. But now that they've got it set up, it helps them tremendously on responding to these court orders. I can tell you DPS ordered this same system just when I was leaving in August. They got it in now, but it's going to take them probably a year to set it up, design it. And then some of the other labs in Texas are, I know at Austin PD, Bill's got a similar system to set up. When I talked to their analyst, he said, I probably spend 4 hours putting all of this information into the computer, but it's there now in every case, and when they get a court order, it doesn't take him more than about an hour to respond. But he's invested a lot of time up front to put all of the information into an electronic format. Lynn, I don't know how much detail you want to go through.
I think that's a good summary. I think probably the next steps will be Judge Hervey will weigh in. I think Richard had some thoughts about some other feedback to get, perhaps from some misdemeanor trial judges in Tarrant County, because ultimately what we designed the study for was to help judges understand. And so the question is, do you think this will help you understand? Do you think this is a worthy tool? Do you want to add to it? What else would you like to see? And then we can revise it from there.
No, I think that's correct. I mean, especially with the changes with the Michael Morton Act and expanded discovery things, a lot of the stuff that typically would involve a defense attorney subpoenaing the lab, there's interpretations that say that we as prosecutors need to provide this stuff up front without a court order. And one of the things that initially before calling Lynn and getting the benefit of this report, just calling one of our local labs, ME's office, talking to the chief toxicologist and trying to find out how much of this stuff doesn't change from case to case, and trying to find ways to make it available, whether it be posting it on the lab's website so that as these standardized motions come out, if items 1 through 15 just don't change, they're the same answer, then all we'd have to do is say, in response to your request, 1 through 15, you go to the website, you can download or read this as it is, and that might reduce somewhat on the cost of printing this stuff, because unlike other types of cases, this is being asked for, I think, as just a matter of course, and if it isn't, it will soon be. So every case, and we're talking, we have 75 to 80,000 DWIs a year. You can add maybe a couple hundred other intoxicants, intoxic manslaughter cases that would involve this. And that's a huge volume. So the more of this stuff that can be put, that has no privacy interest, that can be put up there, out where they can download it, the better. But I think having read through this, it's a real good start about explaining this. One of the areas that I was hoping and we might need some more fleshing out so the judges understand it is what factors, based upon the level of technology and paperlessness or not being paperless that labs have, what is it that makes it a 1 as far as difficulty for one lab and a 12-hour task for another lab? So they understand that, so that there's some, so the judges can have the vocabulary and they can say, do you have a blank system? And the answer to that question will give them some idea about the burden of this. Because sometimes these requests come up right when the case is filed, and sometimes they're asked for 2 days before trial, which puts the labs in a crunch. And just wanting the judges to have the benefit of understanding the burden involved in this and the reasonableness of some of these requests. But again, as a starting point, I think it's useful. And I'm going to run it by some of, as Lynn said, some of my judges, just to see what their thoughts are about it. But the key is just to define the vocabulary and just make it reasonable so that as these things, because typically what happens, there's a seminar, there's a suggested discovery motion, everybody gets a copy of it, and they just send it out. Whether they understand what they're getting back or not, they've been told, you need to ask for this stuff. And so these motions that I know I provided to Lynn were just a sampling of some of the more extensive ones. But they're going to continue to come out. And again, at a certain point, I'm hoping that the courts will order some reasonableness so that a request to know what forest the tree was cut from that created the device that was used to stir the contents, it doesn't get that. And some of it's, some of it really does get to the nitty gritty. Who manufactured it, where was it manufactured, what's the quality control of the glass making company that did this. I mean, it gets really broad. So I think this would be a great help to the laboratories and will meet some of their concerns. So it's good.
Comment on Pat, when you were doing this, did you run across any instances, Mr. Alfred, you may know, there's a provision at the end of 3914 that one can go to the defense and ask for the costs for the expense of actually producing this stuff. Does that ever happen? Because I've waved that around when we got just a completely off-the-wall request for something. And I said, look, I may have to go and ask for this court order. I've never done it. No one's called my bluff. But usually they would back off. Okay, well then I'll narrow this. But I wonder, as a practical matter, is that provision ever invoked?
I can tell you from DPS, no.
Why?
I didn't. Why? Because I was ignorant about the statute that you have against reference.
That might be another area that'd be helpful to have some guidance as to what the reasonable cost of producing this is, because
it prescribes it.
It does?
It's the
552 subchapter F.
You follow that fee schedule.
Right.
But in some instances, that could be a lot, depending on what they're asking.
Could you send out that statute to members?
Sure thing.
I'm trying to get money from
39.14, and we can get it to you. It's easy.
And I think there has been, I'm aware of situations with breath testing where there have been requests for documents and the response has been, here's what we're going to charge you for the 300 hours it's going to take to get you copies of all the tests in the last 20th century, and they backed off from that request.
And you can't charge for labor.
Right.
Because it's the Public Information Act.
Yeah.
And that's a good point, and that might actually make it more reasonable, because again, the key is always the defense needs to get everything they're entitled to get and everything they need to get. But if they don't know what they're looking at and they're not going to hire someone to tell them what they're looking at, the idea that labs are spending countless hours to produce paper that just sits there and wasn't even analyzed. If there is a cost involved, then maybe there would be some toning down. And because that's what we've typically tried to do, is have a cooperation. I mean, up until the law changes, I would typically just say, have your expert call the lab, whether it be the ME's office or another one. You have your toxicologist talk to theirs, and they can, whatever they want, we'll give them. And when we do that, it's very reasonable. There's like 8 or 9 items, not 35 pages worth of it. So I think that's a good, point, and that maybe educating the labs about that and coming up with some idea of what a reasonable cost is would be good.
If I amend my report, should I
Just send
reference
it
that
to
in
us.
there?
Yeah, sure.
I know on open record requests, we do that. We tell whoever the requester is, this is going to cost you $20 or whatever, and we wait for their check before we fill the request. But I didn't know we could do that on these.
Has your lab been charging?
Indigent defendant, it will be interesting.
Right. Has your lab charged for
We
it?
have not, I've just threatened.
Okay. And what has been the result of the threat to charge?
They agreed.
They agreed to
But they
pay?
went back and said, okay, we'll take this out. They narrowed the scope.
Okay.
Which means they didn't really amend it in the first place.
Well, there ought to be a standard charge that everyone can apply rather than you're dependent on an interpretation by your local
There is,
county.
Dr. Brainerd.
Yeah.
It's in the statute. It loops in
Yeah.
another.
We've not been able to recover what we felt was our real cost when it gets to employees spending that time, so.
There should be a flat $2,000 fee.
Well,
And again, if the stuff that doesn't change is made available at no cost, it costs very little to put something up on a website for you to download it if it is accessible and there isn't any proprietary issues with it. And that would also go a long way to show that we're making a good faith effort to make it available so that the information is there.
That's one of the things we're doing at APD. We're downloading 6,000 documents right now onto our website, so that on all these 30, 40 item things, the only thing we have to furnish is the case file and the information of our scientists. Other than that, everything else is going to be found on our website. So we think we're going to drop our time down to about 30 minutes per analyst to be able to do it.
how much did it cost you to get that? I imagine it's not just a regular website. I mean, that's a lot of document
It's our
storage.
APD website, but it's got some kind of a data. I don't know much about that stuff.
Did you have to spend
It's
money?
the city website. Yeah, they've got a data portal that we loaded into.
Linda, from Jefferson County, because you have a small lab, so that must be done, I mean, it must be harder in some way.
It is very difficult because we don't have the staff to invest the time to upload all of these documents. We are in a little bit more remote location, but we do get attorneys from Harris County who give us extensive discovery orders as well. And they do normally, on the bottom, advise that, if this is going to incur a cost, let us know. We just normally have not taken advantage of that. But it is burdensome because of the time for all of the records. And anyone that's involved with the breath testing or the toxicology analysis knows it's a lot of records. And, I would love to be able to do that, but right now it's just not feasible for without some sort of additional staff.
And we're using interns. We got college interns that come in as a project.
That's not fair to them.
Gotta love the interns.
That's not fair to them. That was not a good thing to do to the interns.
Okay.
The lawyers.
So we'll keep working on this and get you a new version of it at the next meeting so you can see how it was updated. Thanks, Pat.
Thank you.
Thank you.
The synonym for intern is troll.
What's next?
Here's this, about one topic covered.
Discuss our report. Can we go back to 12?
Oh, Bill, did you have anything on Packlet? Anything else, or we are
We
discussing?
pretty much discussed everything we discussed yesterday, so I don't think we had anything else to add. Just I just want to thank the commission for the support on all the training issues. That's going to be a big help for the labs.
We can almost finish off the whole thing except the 9.
I think we can go back to 9.
Okay, let's go to 9 then. Update from the Houston Forensic Science Center, toxicology. So R number 14-13.
So the general counsel for the laboratory, we were speaking, and it might be easier for him to, instead of trying to stand here and provide comments or feedback, if he could use the corner of that table, that would be good. Get him a chair. You might have to bring your chair over because I don't think we have extra chairs.
What does that mean? You're going to go. You're going to take us through the.
I'll take you
draft.
through it. Just say we have the report.
Okay. We have a draft of the report, and we're going to go through the report.
We're going to go through page by paragraph by paragraph.
Probably move more quickly through the boilerplate.
Hold on.
So we'll start on what, page 2?
Yes.
Ms. Garcia, would it be possible for me to take about 2 minutes to just give some opening remarks, which I think then I won't have to jump in as much. Is that acceptable?
Yes.
My name is Tom Allen. I'm acting general counsel for Houston Forensic Science Center, and I'm a non-voting member of the board of directors. Present today also is Dan Garner, who is the CEO and president of the corporation and the executive director of the Forensic Science Center, and also Ramit Masni, who is the center's public information officer. In response to last October's meeting of this group, the Houston Forensic Science Center, I think it's fair to say, and I hope you'll be convinced, has responded vigorously to the concerns expressed by this group last October regarding the toxicology incident. The part of the response falls into 3 primary categories. Personnel, and to let you know that the person serving as the interim toxicology manager, that's a phrase that shows up frequently in the draft report, the person who's serving as the interim toxicology manager no longer holds that position. He now serves as the director of information technology. He is not wearing multiple hats, which was what was happening to begin with. The Forensic Science Center, as I advised Ms. Garcia recently, has hired a chief operating officer who will begin work next month. That is Peter Stout, who is a PhD in toxicology. He is the current president of the Society of Forensic Toxicologists. I have a copy of his resume, which I'm happy to distribute or make available to Ms. Garcia. So we will have a chief operating officer who is an experienced specialist in toxicology. The Forensic Science Center has also hired 2 additional PhDs in toxicology. Again, we took over control of the Houston Police Department Crime Lab last April 3rd. During that time, we have gone from 1 PhD within the center. We now have a total of 5. And 2 of those recently hired PhDs, this is not talking about Dr. Stout, are in toxicology. We also have brought in on a contract basis NMS Labs to assist with the management of the toxicology section until we have a permanent toxicology manager. And we acknowledge we have advertised, we have recruited, we have worked very hard to fill that position permanently, made a couple of offers. We have not been able to fill that position with a person we believe is qualified, but we're still working at it. NMS Labs is filling the gap for the time being. That's personnel. In terms of policies, the board gave very clear direction at its October 10th meeting that every irregularity occurring within this operation must be documented, even if the facts are very unpleasant. And I have provided to Ms. Garcia and can provide to anyone who has interest. All of our meetings are videotaped and are available on our website, and I can give you specific time references so you can hear the discussion of the board in which they were advised that there had been, in some cases, a practice of not necessarily recording negative information about the work of an analyst because it was discoverable. Setting aside, not commenting upon the wisdom of that, this board came down and was unequivocal in its instructions that that was unacceptable and that practice could not continue. The Forensic Science Center has issued, again I supplied a copy of this to Ms. Garcia, a policy regarding communications with third parties. This goes to the chilling effect about which this board expressed concern last October. This communication policy makes clear that persons employed or managed by the Forensic Science Center may communicate in confidence with any accrediting entity or any investigative entity. It makes that clear, we state it, and therefore there could never be an adverse employment action taken by the center for someone having made such a report or even engaged in communications if they are a complainant to one of those entities. That policy is in place. We have made multiple revisions to SOPs, again, growing out of last October's meeting. So personnel, policies, and in terms of practices, we are in the process of separating the processes of administrative and technical reviews of reports. I'm not a science person, far from it. My understanding is that technically, if that's the right word, there is nothing untoward about having the same person conduct an administrative or technical review of a report. Setting that aside, we are discontinuing that. That is requiring some moving people around. We haven't finished that process, but the practice and the policy of the Houston Forensic Science Center will be that those functions are performed by separate people. And we have a, I'm going to say this with understatement, much greater emphasis on the need to issue CAPAs in a timely fashion. So those are significant changes that the Forensic Science Center has made in terms of personnel, policies, and practices. We know our job is far from complete. There is more to come, but that is a start all since last October.
Can I ask a quick question about the policy on that examiners who want to make a communication to the accrediting body or a body with other regulatory authority? I think when you had sent that to me, it's pretty recent. It hadn't yet been adopted. Was that adopted on already, or is it still?
It was officially adopted, but our board, back in December actually, our board said, but we don't want you to roll this out until you have provided training, because it's complicated. It's got lots of nooks and crannies, and no one will ever know how much time was required to draft those 4 or 5 pieces of paper. But they said it is complicated. We want a flow chart. We want training. So we put all that together, and I have provided that training to probably 70% of the lab. I have not gotten the folks in CSU who work 24 odd shifts, but we will get to that. So we won't be enforcing the policy until we have everyone trained. And we've distributed the flow chart that I think I also provided to you. So technically, Ms. Garcia, it says it's effective in December, but we are simply holding back in terms of enforcement until we have everyone trained and everyone has an opportunity to ask questions.
That, just to be clear, that policy is not referenced in your draft report because it came in after the draft report was done and the exhibits were attached. So if the commission wants to reference that policy, we would have to add that during these deliberations, because I just don't have it in here because it came in fairly recently.
Okay. So Thank you. Thank you. So do we want to start going through the report?
Peter's now.
Sure.
Who wants to write?
Lee, do you want to go to the first page, please? So the way we typically do this is page by excruciating page, I guess I should say. So I'm going to review in summary fashion each section. If anyone would like to make an edit or a comment or ask a question, just stop us and we will discuss the section. So it starts out it's pretty straightforward. We have the commission's background and statutory authority. So what is the history and mission of the Forensic Science Commission? It describes the commission's authority under the statute, which is to investigate allegations of professional negligence or misconduct that would substantially affect the integrity of results of forensic analysis. It also describes the self-reporting component of the commission's statute, and talks about the guidance that the commission has released to accredited labs to try to help them determine when an action or an activity, a set of facts or events should be disclosed to the commission, which is ultimately it's a judgment call. We talk about the fact that commission has 9 members. They're all appointed by the governor. You can go to the next page. And then we get into the investigative process. So this sets forth sort of its background, what happens with complaints and disclosures when they're received by the commission, that there is a complaint and disclosure screening committee, and we saw that committee meet this morning. After discussion, the committee makes or takes a vote to make a recommendation to the full group about what action, if any, a complaint or disclosure needs. Now this is where I wanted to make the first edit. It's actually an edit that I would like to suggest. When we first talk about the Houston Forensic Science Center, what I would like to do is add the following footnote. I'm going to read it aloud. Effective April 3rd, 2014, responsibility for and control of substantially all of the forensic operations formerly managed by the Houston Police Department, including the HPD Crime Lab, were transferred to the Houston Forensic Science Center, Inc., HFSC, a local government corporation created by the City of Houston. Though many of the facts described in this report occurred before the transfer of operations, the Commission received the disclosure after the transfer. To minimize confusion, the report refers to the laboratory as HFSC consistently throughout. So this takes into account the major transfer that happened at the laboratory during 2014. In order to make an edit, I would ask that you all consider this. If there's any discussion, discuss it, and then take a vote to adopt it or reject it.
As we go one by one?
One by one.
Okay, I'll make a motion then to
Add that footnote.
I'll second.
Aye. 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 Unanimous.
Okay. So we'll insert that. The other thing that I'm going to clear up there is that when I first introduced the laboratory, I refer to it as HFSC. It should be fully spelled out, and then the parenthetical should have the abbreviation there. So I will make that edit. And at the end of this process, I will ask the Commission generally for a vote that any non-material, non-substantive revisions that Lee and I see, like typos, or changing the header from B to C, or those types of things, that you grant us the authority to do that. So the first time that the disclosure in this case was discussed was at a publicly noticed meeting of the Complaint and Disclosure Screening Committee in Fort Worth, Texas on July 31st. The Commission then discussed the disclosure again at the full Commission meeting. Ultimately, there was a 3-member investigative panel created to review the disclosure, and that consisted of Richard Alpert, Dr. Pirwani, and Dr. Kerrigan, and Mr. Alpert is the chairman. So And then we have a footnote about the changes to the commission in the interim. So once a panel is created, the commission's investigation includes document review, interviews with members of the laboratory, collaboration with the accrediting body, or other investigative agencies that may be running parallel investigations. We try to do collaborative interviews to minimize disruption at the lab. Requests for follow-up, and that there are many examples of that with the general counsel of the HFSC in this situation. Hiring of a subject matter expert if needed, and then any other steps that the commission needs to take to meet its statutory obligations. We talk about just a little administrative footnote, which is when this process began, the center was accredited by ASCLD Lab. At least the toxicology section was under the ISO standard at the time. And since then, the accreditation has been moved to ANSI ASQ, which is also commonly known as FQS. But just to let folks know. So when we did the initial interviews, Patty Williams was at those meetings. So that's what this says here. And then we try to explain that even though the two entities are doing interviews together, they're looking at it from a different lens. The accrediting body from accreditation standards, which is very different from conducting a review for the purposes of determining negligence or misconduct. And we have not seen any report out of ASCLD Lab, so if they have issued a report, we don't have it. I don't know if they did, but they would have issued it to the laboratory. We don't have that. Does anyone, yeah.
So that I don't wear out my welcome completely, I guess I need to say that if we remain silent, if I remain silent today, that's not necessarily an agreement with what's here, but it's my judgment call that even if we have a disagreement, it is not of such importance and needs to be brought to your attention. On the other hand, sort of for the people who not part of this group, who may come in from the outside and say, but Alan, you remained silent and said nothing, so you must have agreed. That is not the case. I'm just trying to not waste all of your time.
Okay. Well, if there are factual inaccuracies, then I would appreciate hearing them, because
yes.
We don't, if the, you know, if the toxicology section wasn't accredited under 17025, I'd like to know that.
I understand.
Thank you. Does anyone have any comments about the introductory remarks, suggested changes to this point outside of the footnote that we discussed?
On page 5, right before the end of that subheading B, it states, in early October 2014, the chairman of our board informed the commission that the Office of Inspector General of the City of Houston would be assessing this matter pursuant to her authority. Chairman Hogberg asked me to mention specifically that that investigation came about at the board's request. It was not initiated by OIG. The board went to OIG and said, we want you to investigate this.
So we hadn't got quite to there yet.
Okay,
but
I
we
didn't,
can add
you
that.
said the section, so I was afraid you were leaving that.
So up until where it starts on September 8th to 9th, 2014, does anyone have, so up until the last paragraph on page 4, does anyone have comments, suggestions, questions, factual inaccuracies, or anything they'd like revised?
Everything's fine, let's move on.
Okay. So starting, we explained the fact that 2 members of the investigative panel went to Houston and participated in interviews with Patty Williams, that it describes the individuals who were interviewed, subsequent telephone conversations, and then we get to the OIG's investigation. Does anyone object, or is it okay if we add language that says that upon the request of the board, the OIG assessed this matter? Is that okay with everybody?
I'm
Okay.
fine. So we'll have to vote on this.
Yeah.
So move.
Second.
Aye.
Aye.
Nay.
Okay. So getting into B, we talk about what a commission investigation of a DPS accredited lab must have in terms of components. and what it may have, and everyone knows the statute. So any questions about that section? B? No? Okay. C, limitations on the commission's authority. We talk about the fact that DPS accredited labs are required to cooperate with the commission, and what the statutory limitations are. We don't determine guilt or innocence. We don't have authority to issue fines or administrative penalties. We describe the fact that information gathered is basically up to the goodwill of the people who are involved, and it's not been subject to standards for admission of evidence in a courtroom. No one testified under oath. They weren't limited by rules of evidence, etc. Any problems with that?
No.
Okay. Documents obtained have not been subject to independent validation. In other words, we don't have a forensic digital evidence expert validating what we receive. And we rely on the parties to give us the information that informs the report. Not every section of the laboratory is impacted. So we interviewed folks in toxicology. That doesn't mean that people in other sections of the laboratory face the same challenges or opportunities for improvement. Any questions about anything in section C? Questions, edits, comments?
No.
Okay. Section D describes the commission's investigative role and concerns around human resource issues. And the description herein is intended to address the difficult line between commentary on human resource decisions that are fundamentally within the purview of management and acknowledging the fact that the commission has a limited time to assess the situation and that management is in a much better position to make personnel-related decisions. However, even decisions or issues that are labeled under the human resource umbrella can impact the laboratory's transparency. So to the extent that there are issues involving those concerns, the commission will look into them, such as root cause analysis, which we get into, such as decisions that the general counsel referred to earlier about whether or not to document certain issues that may come up with examiners. Does anyone have any questions, edits, or comments about this description under C?
D.
I'm sorry, D.
No.
I'd like to, I guess, state on the record that in the paragraph beginning with however at the bottom of page 8, the statements that are made there, I can't see how anyone would disagree with. The Forensic Science Center is troubled by the implication of it. And that, of course, these are statements, and all of these statements are true. These dynamics can have a chilling effect, but it does seem, we believe, in terms like inequitably attributes in terms of how an analysis is done, the tone of that. I don't know how to change it. We would just like to lodge an objection to it. We think that it will lead to incorrect inferences, but literally the black and white words on the page are all correct.
So we move on.
Okay, we're on page 10, summary of key facts and disclosure timeline. Under letter A, we have the summary of allegations. So this is very fact intensive. On June 4th, disclosing analyst submitted a self-disclosure to the commission regarding a blood alcohol report issued with the wrong defendant's name, which the analyst discovered and reported to her supervisors on April 15th, 2014. The analyst, in summary, the analyst alleged that the lab failed to amend the report, notify the Harris County DA's office regarding the error, and issue a corrective and preventative action as required by lab policy and associated accreditation standards. The analyst also alleged that the interim manager removed the analyst from casework on April 16th because of the error without a coherent explanation for why she was being removed or a plan for returning her to casework. So that's a summary of the allegations as contained in the complaint for disclosure form. Any questions about A?
How far are you going? Are you going to the end of?
Just A.
Okay. How far is it?
Page 32.
Page-
Oh, I'm sorry, I apologize. Okay.
So under B, facts underlying the blood alcohol reporting error. On October 5th of 2013, an HPD officer turned in a submission form to the HFSC for a defendant, who we refer to as Defendant R, corresponded to the wrong blood alcohol evidence. The blood evidence actually belonged to another defendant referred to herein as Defendant H. The submitting officer should not have turned in a blood evidence submission form for Defendant R, as he had administered a breath test to Defendant R and not a blood test. Shortly after the submitting officer turned in the incorrect form, the accessioning analyst noted the discrepancy between the name on the blood tubes and the name on the submission forms. On October 15, 2013, the accessioning analyst sent an email to the submitting officer indicating the name on the submission form did not match the envelope and the blood tubes. And that analyst, the accessioning analyst, asked the submitting officer to resolve the issue by submitting a corrected form. The officer acknowledged he wrote the wrong case information on the form and told the accessioning analyst he would provide a corrected form. Any issues with those facts?
No.
On October 31st of 2013, the accessioning analyst sent another email to the officer requesting a corrected submission form. On November 5th, the officer apologized to the analyst, saying he had forgotten all about it, but that he had dropped it off and stapled a note on it with the accessioning analyst's name. Then on December 5th, the analyst sent yet another email to the officer stating she still had not received the corrected form and that it must have been lost in transit. She requested that the officer fax the form to the lab. Any questions, issues with that?
No.
On December 9th of 2013, the disclosing analyst examined the blood evidence with permission of the toxicology section manager. The lab's practice was to analyze evidence with discrepancies in submission information, but to set the evidence aside and not release a report until the information could be clarified by the officer who submitted the evidence. In conformance with the practice, the analyst examined the blood evidence, set the case aside without signing the report until the discrepancy could be resolved by the submitting officer. The disclosing analyst also made a notation on the batch tech review for December 9th to indicate that the blood evidence belonged to Defendant H and not Defendant R. The toxicology section manager conducted a tech review of the batch data on December 10th. That should be 2013.
Do you need our permission to make that correction?
No, I think that's along, that's more.
You've got permission
Yeah,
already.
okay. The toxicology section manager who originally supervised the analyst departed from the lab at the end of December of 2013. This was a planned departure. While searching for a permanent manager, the HFSC appointed the interim manager to run the toxicology section while he was simultaneously tasked with managing the IT section, and that was addressed by the general counsel. Yes?
Ms. Garcia, this is the one place where I think it is important to distinguish the police department from HFSC. It was the Houston Police Department who made the appointment of the interim manager to run the toxicology section.
Okay. I can make that edit. Anyone,
Yes.
is that okay? Anyone
That's a
object to
factual
that?
point. Nope.
Okay. On January 2nd of 2014, the Harris County DA responsible for Defendant H's case sent an email to the laboratory requesting the results associated with the blood alcohol evidence for the defendant, H. The ADA stated that he had checked in LIMS and it wasn't pulling up the case, and LIMS is the lab's electronic case management system. The employee who received the ADA's inquiry forwarded it to the interim manager. The interim manager responded to the ADA on January 3rd of 2014, confirming he was also unable to find defendant's case in the LIMS or the property room system and requesting the name of the officer who submitted the evidence. On January 7th, the ADA responded with the submitting officer's name. On the same day, the interim manager sent an email to the submitting officer inquiring about the blood evidence for Defendant H, which at the time appeared to be missing since it was in the LIMS under the wrong defendant's name. On January 10th of 2014, the disclosing analyst mistakenly signed off on the blood alcohol report for Defendant R, which she had originally set aside to wait for clarification from the submitting officer. The disclosing analyst was not copied on the correspondence with the ADA or the submitting officer that was described in the previous paragraphs. By signing the report, the analyst released it for admin and tech review with the wrong name still assigned to the blood alcohol results for Defendant H. On the same day, the interim manager technically and administratively reviewed the case. He also did not pick up on the name discrepancy noted in the case folder or make a connection between the ADA's inquiries about the missing evidence for defendant H and the information noted in the case folder. In addition, the fact that the case was from an earlier December batch tech review for which defendant R's name had been crossed out and defendant H's name was handwritten as a correction did not appear to raise any red flags. After technical and administrative review was complete, the report was released in the LIMS. Does anyone have any questions, edits?
No.
On January 15th of 2014, the submitting officer responded via email to the interim manager's January 7th, 2014 email regarding defendant H, explaining the case was mixed up with another case due to an error on my part on the submission form. The disclosing analyst was not copied on this email either. The email from the submitting officer referencing the case being mixed up with another case did not trigger any follow-up or investigation in LIMS by the interim manager or the accessioning analyst. When asked, the accessioning analyst explained it was her understanding that the interim manager was taking over any necessary follow-up on the case. On March 26, 2014, the Harris County DA's office dismissed the aggravated DWI charge against defendant H. According to the DA's office, they dismissed the charges for no other reason than they were unable to find the blood alcohol evidence.
Ms. Garcia?
Mm-hmm.
I need to comment on that. Our review of these records is that, in fact, it was not an aggravated DWI charge, this is in 4904D of the Penal Code, which requires a blood alcohol level higher than the blood alcohol level that actually showed up. According to the DA's website, we checked this recently, we do not believe that there was ever an aggravated that, of course, the word aggravated doesn't show up in the statute, but it is an enhanced penalty because the blood alcohol level is higher. And we think that this would be very upsetting to people. There was a case that was dismissed, but I believe the DA's own website will back us up to say that it was not an aggravated DWI charge.
Richard?
I thought it wasn't. I thought the information we had showed it was above 0.15. You're saying that your investigation shows that the level, the blood, excuse me, was below 0.15?
0.08. And this was checked this week.
Okay.
So I'm putting that out as a fact issue that I feel.
So this says here, item 1 was found to contain 0.168 grams of ethanol per 100 milliliters of blood.
Correct. I think what you're confusing is that I think sometimes offices distinguish cases with the result as being 0.08 or above cases as opposed to refusal cases. The result we have on this case is 0.165. That's above 0.15. So that makes it, and we do, the term of art is aggravated. You're right, it's not in the statute. It enhances it from a Class B to a Class A misdemeanor. So I think our report's accurate on that point.
If I can, and this may happen later, I'd just like to lodge the concern, or if you will, the objection, and I expect you to move on. I would also point out in a related fact that according to the OIG's report on page 4, even though those charges were dismissed, charges were refiled against the same defendant on a lesser charge. That's in the OIG's report, which was, I didn't know about.
They were refiled on a charge
on a lesser charge against the same
but not
defendant.
Related to the alcohol.
It wasn't related to intoxication. It wasn't a DWI charge.
Well, in the sense that if the public is concerned, this is somebody who absolutely went free, I think that would be misleading.
I'll check with the DA's office and make sure this is crystal clear.
Thank you.
Is that okay with everyone? So on March 27th, the interim manager sent an email to the HBD captain in charge of the submitting officer stating the lab still had not received the corrected submission form. On the same day, the captain instructed the submitting officer to take care of it ASAP. And the following day, the submitting officer explained in an email to the interim manager that he believed the laboratory had received the fax version of the corrected submission form he sent to the accessioning analyst on December 5th because he hadn't heard anything to the contrary. On April 15th of 2014, the disclosing analyst was working in one of the evidence coolers when she noticed some blood evidence had been set aside with a note on it with her handwriting. She went into the LIMS to research the case number for the evidence and realized the report had been released with the wrong defendant's name. She immediately notified the interim manager, the lab director, and the quality director. The interim manager researched the case in LIMS and determined that no one outside the laboratory had accessed the report. He then recalled the report from the LIMS, preventing anyone outside the laboratory from being able to access it. The following day, the interim manager informed the disclosing analyst she was being removed from casework. The interim manager instructed the disclosing analyst to write a memo about the case and everything she did related to the case, as well as to include all relevant correspondence regarding the case in the case folder. In attempting to fulfill that request, the disclosing analyst discovered the email correspondence referenced above between the accessioning analyst and the submitting officer, the interim manager and the ADA, and the interim manager and the submitting officer, which had not previously been documented in the case folder. According to the disclosing analyst in the email correspondence, it took her no more than a few days after April 16th to prepare the memo requested by the manager and complete the case file with correspondence. She believed she was being taken off casework temporarily to draft the memo and ensure the case documentation was in the folder. However, the interim manager informed her she would remain off casework until further notice. During the period from April 16th, when she was removed, until she was returned to casework in July, late July, the disclosing analyst sent various email communications to the interim manager, the lab director, the quality manager, the human resource director, and the president and CEO of the lab, expressing concerns about the lab's need to issue an amended report, inquiring about a plan for her return to casework. Those emails are attached in Exhibit N.
Ms. Garcia? Because that sentence just ends, that she sent these emails and they are in fact attached as Exhibit N, but then the sentence simply ends, which certainly implies a lack of responsiveness by the Forensic Science Center to those emails. I would direct you to the OIG report at page 9, and that investigation found that there were meetings with the HR director, the interim tox manager, and the disclosing analyst on June 24th, 14. There was, in fact, a response, and this was not a fact that she was simply sending emails that were ignored by management. So I believe that the sentence, the paragraph, is misleading because it simply ends without telling the entire story. Unless the OIG's report is being disregarded, which I don't think is the case.
They met. There was a meeting.
Do we have? They said to her on whatever June, was it June 4th? You said.
So we can add that there was a meeting on. Yes, we know there was a meeting. There's no question. So we can add that.
So
there may be. We'll have to go through. There may be a reference, but we could state it to make it abundantly clear right here.
Yes.
So is everyone okay if I add that?
I think we should.
But it's undisputed, there was no response to her and her concerns. She was never made aware of any actions being taken. Which,
I think it's
the
not.
OIG found she was present for the meeting. She was at that.
Wait, let's do one thing at a time. First thing.
I don't think it's undisputed. I think it's very much disputed. I think they felt that meeting was an attempt to address her concerns.
Okay, we'll put in that there was a meeting. What did you put in?
I haven't added language, but what I will add is that there was a meeting between the disclosing analyst, the interim manager, and the human resource director on June 24th, 2014, during which, what do you want me to say?
During which a discussion was held.
Regarding?
This matter.
No, that's so broad.
Okay, we have to vote on
We weren't
If I may,
there.
I appreciate that much, Dr. Mild. That's at least acknowledging, because as it's written now, it's like we're utterly unresponsive, which I think is unfair.
But I think qualifying, I think this go as far as say a discussion is enough, but to say the matter implies there was a discussion that addressed all these concerns, and that's not our understanding.
We didn't put all this address.
So just a discussion, period.
Well, that's all we did.
Yeah, it says, on June
And
20.
that, I would refer you to the, to.
Well, let's see what you wrote.
Okay, all right.
On June 24th, 2014, a meeting was held between the interim manager, the disclosing analyst, and the human resources director, during which a discussion was had regarding this matter. I mean, we weren't there. I don't know what to say. Whether, I mean, yes, there was a meeting. There's a lot of dispute about what happened at that meeting, so.
I think we should stop there.
Yeah.
May I be heard, please? The OIG gave some detail. This is on page 9 of the OIG's report, describes what happened at the June 24th meeting. They agreed to go through the draft of the tax manager's write-up word for word. They agreed on the final version of the facts. I mean, there's a lot of detail that's under that entry. Now, I agree, it's in dispute.
So
I'm not quite sure how that's handled, but this was a finding of the
OIG has facts in her report based on her interviews with the parties. We also interviewed the parties, and so I think they have very different perspectives about what was or wasn't accomplished during that meeting. Is that fair, Richard?
I think that is, and I think we need to limit our report to our understanding of those facts. We're not adopting the OIG's findings in OIG's report. This is an accurate reflection as written as to what we understood by talking to the same parties. I think the fact that there's a difference of interpretation has been pointed out, but I don't see a need to change the report for this.
So we'll note that the meeting was held.
Okay, then let's go on and see what else.
Shall we take a motion to adopt that?
Oh,
Yes,
yeah.
please.
Second?
All
Aye.
Aye.
Nay.
Okay, so the commission held its quarterly meeting in Fort Worth on August 1st, 2014, and discussed the case in detail as previously described. On the same day, the laboratory issued a first amended report for defendant R. On August 4th, the laboratory issued a second amended report for defendant R. On August 4th, the laboratory released CAPA's 2014-11 and 2014-16. On August 15th, the laboratory issued a third amended report for defendant R. And on the 15th, the laboratory issued an amended report for defendant H. The 4 amended reports corrected the original erroneous results and stated that defendant R had been given a breath alcohol test while the blood alcohol results belonged to defendant H. Is everyone okay up to here? We're getting into interpretive conclusions.
No dispute.
Okay. Roman numeral number 4, conclusions regarding negligence and misconduct. We go over what exactly is defined as professional negligence and misconduct in the Commission's policies and procedures, and state that the Commission did not identify any evidence of professional misconduct in this case as the term is identified. Then we talk about the negligence finding that was adopted at the last meeting. The Commission finds the interim manager was professionally negligent in failing to issue timely amended reports once the mistake in the report names was identified. And the Commission finds the interim manager and the quality manager negligent in failing to issue timely CAPA that accurately and completely described the root cause of the nonconformance. The management should have used the laboratory's existing quality system to address the errors promptly when they were discovered. Issuance of the amended reports and related CAPA were essential components of ensuring the records for the analyses were accurate and complete, and for ensuring the integrity of the forensic analysis performed in the lab.
That's correct.
I support that.
Well, I think we have somebody who wants to say something.
This is not my most fun afternoon, but the implication there is that the forensic science management is doing nothing to address the errors until much later. I would note that implication is inconsistent with the OIG's finding on page 12 of her report that the Forensic Science Center was responding, albeit clumsily. But page 12 talks about efforts, sort of fumbled, but efforts nonetheless, that they are responding to these circumstances. And again, the implication of this paragraph is that there's no response from management, and we believe that's absolutely correct.
I think it's accurate as written.
I think we should stick to it.
Accredited crime laboratories are engaged in an ongoing process of continual improvement. Though every effort is made to safeguard against errors in the lab, they are an inevitable part of any human endeavor, and this includes forensic disciplines with a high volume of cases, including many components, some of which are outside the lab's control. For this reason, accredited labs have standard operating procedures in place to address errors promptly when they occur. Action steps include amending reports, issuing CAPAs, corrective and preventative actions that include root cause analysis. And corrective action should be of an appropriate degree and magnitude to correct the problem and reduce risk of recurrence. So analysis of the facts underlying the negligence finding. The disclosing analyst alerted management regarding the error in the blood alcohol report on April 15th. It took the laboratory almost 4 months until August 2014 to amend the affected reports and issue CAPAs. While the Commission's investigative panel asked the interim manager why it took so long to issue the amended reports, he explained that once he determined no customer had accessed the erroneous information in the LIMS, the need to issue the reports took on less urgency. The explanation is inadequate. The integrity of the lab system depends, or quality system depends on all members of the laboratory following the process and ensuring appropriate and timely notification of errors in the form of established documentary methods. In fact, customers depend on the quality system to ensure they are able to fulfill their broader obligations to the criminal justice system, including the dismissing or refiling of charges where appropriate and providing notice to defense counsel and the court system where necessary.
Go on. Go.
Because the issuance of amended reports and appropriate corrective actions where needed is standard, generally accepted practice among accredited laboratories, and because HFSC management in charge of the toxicology section of the quality process failed to meet this standard, the Commission issues a finding of professional negligence for these omissions. In addition, and of significant concern to the Commission, the original CAPA issued by the laboratory on August 4, 2014 did not accurately or equitably describe the root cause of the nonconformance. An accurate root cause analysis would include, but is not limited to, the following contributing factors. Number one, the laboratory's practice in December of 2013 was to analyze evidence with inconsistencies or discrepancies from the submitting officer, but to set the cases aside. That practice has been changed so that such cases are no longer analyzed until the inconsistencies or discrepancies are resolved, and that is contained in a document that we received from the lab. This greatly reduces the risk of a report being released with incorrect information. And the issue that we had with the original CAPA is that it stated the disclosing analysts worked the evidence in December 2013 independently, which implies their actions were outside the scope of lab practice and management direction at the time. This is not true. The second point, on October 16, 2013, well before the evidence was analyzed, the accessioning analyst received an email from the submitting officer stating the breath alcohol case belonged to defendant R and the blood alcohol case belonged to defendant H. The email wasn't placed in the case folder until the disclosing analyst identified the mistake in April. The point of this number 2 is that if the case emails had been included in the record, there's a much greater likelihood that both the disclosing analyst who issued the wrong report and the manager who did the tech and admin review would have seen the emails and picked up on the discrepancy. And this is reflected in the quality management section entitled, the quality manual section referencing case records that emails should be included in the case folder. On January 10th of 2013, the blood alcohol report with the wrong defendant's name was released in LIMS because both the disclosing analyst and the interim manager failed to review and or act upon the note in the case folder regarding the submitting officer's name discrepancy. The disclosing analyst made this error when she signed off on the case, and the interim manager made the same error during admin review, the purpose of which is to identify exactly these types of errors. In addition, the fact that the case was from an earlier December 10th batch tech review for which defendant R's name was crossed out and defendant H's name was handwritten does not appear to have triggered any red flags. And this was something that was raised at the meetings by Patty Williams, that would be a trigger. All contributing causes should be accurately described in the CAPA. On January 15th of 2014, the interim manager received an email from the submitting officer on which the accessioning analyst was copied. This was in response to the interim manager's request regarding defendant H's blood evidence as a follow-up to the ADA's inquiries during the first 2 weeks of January. If the interim manager and the accessioning analyst had communicated with each other and followed up on the officer's reference to defendant H's cases having been mixed up with another case, they would have identified the issue at that point.
Is, on number 3, is that supposed to be January 10th, 2014?
I'm sorry, yes.
Okay.
Thank you. So this is just the point that it would have allowed amended reports to be issued in both cases 5 days after the report was originally released, and then the charge would not have been dropped. And whatever edit we make in discussion with the DA's office on the word aggravated will carry over here, if anything. Point number 5 is that on March 27th of 2014, 1 day after the ADA dropped the charges, the interim manager sent an email to the officer's captain acknowledging the evidence for defendant H appeared to have been submitted under defendant R's name, yet neither the interim manager nor the accessioning analyst checked in the limbs to figure out whether a report had been issued in defendant R's name. They would have seen the report. On March 28th of 2014, the submitting officer again stated via email that the case against defendant R was a breath case and the case against defendant H was a blood case. The email did not prompt either the accessioning analyst or the interim manager to research the defendant's names in the limbs, which would have uncovered the mix-up in the erroneous report. On April 15th of 2014, the disclosing analyst ultimately discovered the problem when she noticed the blood evidence set aside in one of the coolers and researched the status in the limbs. The analyst then brought the mistake to the attention of lab management. The action steps in the original CAPA omitted the disclosure, which is a critical component of the case from a quality control and laboratory integrity perspective. Self-disclosure should be encouraged for all analysts in the laboratory whenever they identify mistakes. This is a positive aspect of what happened, and it should have been in the CAPA. Okay. Anything on those points?
I would ask the Commission to note 2 objections that we have to this section B at the bottom of page 18. This concept of an inequitable CAPA, which appears at several points, has troubled us. At some point, I understood that CAPA was inequitable because it referred to the disclosing analyst by name, but not by any supervisor by name. I can see the point. Beyond that, I cannot imagine what an inequitable CAPA looks like. And we object to the inference it's trying to make that through our documents we were attempting to be inequitable or unfair. On page 19, along the same lines, after paragraph 1, the note, the way that this draft report has inferred is the meaning of independently was not at all how the OIG had interpreted the disclosing analyst's use of that term, and it's not the way that management has interpreted. So we simply, we disagree as to the significance of independently.
Okay. On Roman 5, additional observations. The Commission has significant concerns regarding some of the decisions made after the disclosing analyst identified and reported the mistake in the blood alcohol report. The concerns are described here. So number 1 is, or letter A on page 21, inconsistent explanations regarding removal from casework. So removing an analyst from casework for an extended period is a significant decision for most accredited crime laboratories because it has the potential to impact both workflow for the section as well as the individual analyst's career. The disclosing analyst expressed concern regarding her removal from casework as well as a perceived lack of communication from HFSC management regarding the reason for her removal and a plan to reinstate her to casework. During its July 31st and August 1st, 2014 meetings, the Commission asked the lab director why the disclosing analyst was removed from casework. The lab director stated the reason for her removal was independent from the error in the blood alcohol case described above and subsequent disclosure. The lab director explained the reason the disclosing analyst was removed from casework was due to concerns about her ability to testify in court. The only document provided to the Commission explicitly addressing the reasons the disclosing analyst was removed from casework is an August 4th, 2014 memorandum from the interim manager to the disclosing analyst authorizing her to return to casework. The explanation includes the following. Number one, during a March 4th, 2014 conversation in which the disclosing analyst sought the interim manager's feedback on a PowerPoint presentation requested by a prosecutor, the disclosing analyst was unable to answer basic questions and convey her understanding of the concepts associated with the function and operation of headspace gas chromatography using the Perkin-Elmer instrument. Number two, the disclosing analyst erred in generating a report for evidence submitted under incorrect case information. And number three, the interim manager had concerns regarding the disclosing analyst's April 30th, 2014 testimony in court, which were documented in a memorandum dated June 26, 2014. The memorandum contradicts representations made by the lab director at the Commission's July 31st and August 1st meetings that the error in the blood alcohol case was independent from the other reasons the disclosing analyst was removed from casework. The disclosing analyst was removed from casework the day after she notified management of the erroneous report on April 16, 2014. However, she did not testify for the first time in court until April 29, 2014. That testimony carried over until April 30th, 2014. The disclosing analyst testified again on May 6, 2014. She testified a third time on June 5th, 2014, and on subsequent occasions as well. The disclosing analyst did not receive a written evaluation of her April 29th to 30th testimony from the interim manager until June 26th of 2014. And we have that attached as an exhibit. The interim manager's testimony evaluation was generally positive, though it listed many areas for improvement. And I've put the introductory, conclusory comments of the manager there, which you can see in the exhibit. Then we talk about the interim manager offered a series of detailed observations regarding improvements the disclosing analyst could make in future court appearances. The lab director's representation that the disclosing analyst was removed from casework for concerns regarding courtroom testimony independent from the case with the name error do not comport with the timeline of facts. And this recognizes that perhaps the disclosing analyst was not allowed to return to casework because of concerns regarding her testimony, but it is difficult to understand how she could have been removed from casework as early as April 16th because of concerns regarding her courtroom testimony when she did not testify for the first time until April 29th of 2014. This was something that was discussed extensively at the meetings in Fort Worth.
May I address it, please? I believe there is a fundamental misunderstanding about this, and the concern was not the testimony she had given, because, as you pointed out, she hadn't given any testimony yet. The concern was on her ability to testify. The Forensic Science Center is not purely reactive. We don't wait until there's bad testimony. When we can see that someone is not prepared to testify, we act before there is a disaster in the courtroom. Now, you notice back on page 21, it had been back in March 2014 that there were concerns about the disclosing analyst's understanding about how the Perkins-Elmer instrument worked. And there was grave concern that she was going to go to court and she would testify poorly, not in a credible way. And so several pages of the report make much of the fact that she was taken off casework, taken away from testimony before she testified. But she was not taken away from testimony because of the testimony she had given, but the testimony we were afraid she would give because she did not understand the instrument sufficiently. This is a fundamental misunderstanding, and it really goes to the integrity of the lab manager and the implication that's being made that she was being deceptive when she talked to the commission. And I don't know the words that our lab manager spoke, but I think there's some serious miscommunication about why the disclosing analyst was taken away from testimony.
I think it's accurate. I think that either if she wasn't misstating things to the commission, she was poorly informed, which is the responsibility of the lab she works for. If she didn't know the correct answer, she should have told us, I don't know how to answer that question. I'm unable to answer that question. I think the report accurately reflects what she states, and there's nothing consistent with what you've interpreted as with the fact she testified multiple times in court and was only watched one of those times. If there were grave concerns, I would have expected much greater action to be taken. And I would have expected those actions to involve conversations with the DA's office. I've seen no documentation that the DA's office was told in any way we have grave concerns about this analyst's testimony. So whether it was artfully done or whatever, I think that the description and our concerns about the way this was laid out are accurately reflected here.
In addition, we asked the lab director point blank at the meeting, and I would commend you to the recordings of those meetings in Fort Worth, whether this was related to concerns about mock testimony or anything that had happened before the testimony, and the answer was no. So I would just suggest that you go back and look at those meetings.
It may be, may I respond? It may be that the lab director was not informed, and Mr. Alpert, if that's the case, then your criticism is justified. I mean, this is clearly a time of some disorganization within the crime lab. That is not to be disputed. But the fact is, there was not a deliberate misstatement, and again, this goes to the honesty of the lab director and what she told this commission. And I believe that not even to acknowledge that there may be more than one way to have interpreted this, or acknowledge that perhaps she was poorly informed, is treating her reputation in a cavalier fashion, and that concerns me.
Go on.
During the investigative panel's site visit, the interim manager described another reason for removing the analyst from casework. On March 13th, this should say 2014, I apologize. The disclosing analyst approached the interim manager for feedback regarding a PowerPoint she was preparing for use in court based on a request from a Harris County assistant DA. During the discussion, the interim manager became concerned about the disclosing analyst's understanding of the function and operation of headspace gas chromatography using the PerkinElmer instrument. In his memorandum, dated August 4th of 2014, the interim manager explained that he questioned the disclosing analyst's overall knowledge base as a result of the discussion. He further stated he and the disclosing analyst, quote, went to the laboratory and reviewed the function and operation of the headspace gas chromatography using the PerkinElmer instrument. This included a review of the parts and functions of the headspace and gas chromatograph. The interim manager also gave the disclosing analyst a case study to assist her understanding further, which she reviewed in compliance with his instructions. And then we talk about the quality manual, which discusses the possibility of providing additional training as a component of corrective action. It states that if the error rests with the analyst, it will be determined if the error was the result of inadequate or inappropriate training, or is an isolated incident and not likely to recur. If the original training is found to be faulty, appropriate additional training, evaluation, and revision will be devised. Though the interim manager's training on the PerkinElmer instrument resulted from the PowerPoint discussion and not a corrective action, which is what that section of the quality manual was discussing, the interim manager took appropriate training steps as described in the quality manual. During interviews, analysts in the toxicology section, as well as the former manager of the toxicology section, conveyed their understanding that toxicology examiners first learn how to perform the forensic analysis in question and then learn more about the parts and function of the instrumentation as they progress through their careers. This type of issue would commonly be addressed through in-house training, as it was in this case. The interim manager did not offer any additional reasons for concern regarding the disclosing analyst's competency in conducting blood and alcohol analyses. In fact, in a memo from the interim manager to the disclosing analyst dated August 4th of 2014, the interim manager stated, I had the opportunity to review some of your analytic work after January 1st of 2014 when I assumed the position of acting toxicology manager. The technical reviews I had conducted during that time frame had not caused me any particular concern. When asked, the disclosing analyst colleagues, including those who had assisted with her training, and the previous manager described her as hardworking, dedicated, and technically competent. And that's what we found in interviews. Okay. In capital B, keeping things informal to avoid discovery by defense counsel.
Ms. Garcia, may I just note the objection footnote 4 at the bottom of 24, the Forensic Science Center supports the interpretation of the OIG as opposed to the interpretation of those facts by the Commission.
Keeping things informal to avoid discovery by defense counsel. During interviews, the Human Resource Director and the interim manager described the interim manager's motivation for not documenting the disclosing analyst's removal from casework. The interim manager wanted to keep things informal to protect her career. This rationale is discussed in detail in the City of Houston Inspector General's report. While interim manager may have benefited as well from a lack of documentation, he sincerely felt the disclosing analyst would suffer both in testimony and in cross-examination. Interim manager told the disclosing analyst he planned to handle it informally so as to not damage her career. The Inspector General concluded the interim manager knew the following facts. The error came to light April 15, 2014, and the disclosing analyst was scheduled to testify in her first case less than 10 days later. The disclosing analyst's cross-examination would be difficult at best if it started with documentation that she reported a blood analysis indicating a legal violation to the wrong individual. The Inspector General further concluded that the interim manager attempted to shield the disclosing analyst from the consequences of her error by removing her from casework and retraining rather than formal documentation. Negative personnel reports are discoverable by defense counsel and can do great damage to an analyst's credibility. The interim manager's attempt to shield her from that damage does not support a finding that his decision to remove her from casework chilled her from coming forward with her own errors. In fact, the reverse. In interviews with the Human Resource Director, she explained the interim manager's desire to keep things informal seemed unusual to her based on prior experience in an industry unrelated to forensic science. As a result of this, she asked the president and CEO of the HFSC about it, and he responded that things are done differently in a forensic lab. When the investigative panel spoke with the president and CEO during the site visit, he did not have a recollection or familiarity with the case and indicated he would wait until the commission released a report in writing before commenting. The commission finds this position troubling in light of the Human Resource Director's discussion, as well as the fact that the disclosing analyst sent an email on May 29th of 2014 describing her concerns, to which he did not reply. While the commission understands that a CEO and president would not necessarily have intimate knowledge of daily casework in the laboratory, both the conversation with the HR director regarding the decision to keep things informal and the May 29th, 2014 email should have raised red flags significant enough to merit further follow-up.
This is really the same problem as we have back on page 17. When the phrase should have raised red flags, of course that presumes that the red flags were not raised. It presumes that no action was taken. This is, as I said, the same problem as back on page 17 of this draft report. We would refer the commission to the OIG report at page 12, which discusses the actions being taken by management during this very time period. And yet the implication of the paragraph you just finished reading was that there was no response from management, and that is not true.
It's true as it relates to our giving them an opportunity to respond to us at our site visit, where they failed to tell us anything about what you just described. So I think it accurately describes our investigation, and I think we go forward.
Potential chilling effect on transparency of inaccurate root cause analysis and keeping things informal. The commission is concerned about the interim manager's post hoc explanation of the decision to remove the disclosing analyst from casework based on the timeline of facts. We assume for purposes of the discussion in this section that the interim manager's concerns regarding the disclosing analyst's performance were legitimate. In other words, we assume for purposes of the discussion that the disclosing analyst's performance and understanding of analytical concepts were so concerning to the interim manager that he decided she should be removed from casework for over 3 months. His decision not to document the reasons regarding her removal from casework is more troubling than any other aspect of the investigation. The legal system imposes on prosecutors a constitutional obligation to disclose information that is favorable to the defense, and there's a cite to Brady. Prosecutors are responsible for what they know or have in their files. The Brady disclosure responsibility extends out to the team that works with the prosecutor or law enforcement agencies in helping investigate the case. The Supreme Court has held The individual prosecutor has a duty to learn of any favorable evidence known to the others acting on the government's behalf in the case, including the police. But whether the prosecutor succeeds or fails in meeting this obligation, whether, that is, a failure to disclose is in good faith or bad faith, the prosecution's responsibility for failing to disclose known favorable evidence rising to a material level of importance is inescapable. Cite to Kiles. During the 83rd legislative session, the Texas legislature amended Article 39.14 of the Texas Code of Criminal Procedure to include the following provision, and it cites the requirement that exculpatory, impeachment, or mitigating document, item, or information, the possession and custody or control of the state that tends to negate the guilt of the defendant or would tend to reduce the punishment for the offense charged be disclosed. By not documenting the reasons for removing the disclosing analyst from casework and not sharing that information with the Harris County DA's office, the interim manager, number one, deprived the prosecutor of the opportunity to determine whether any action was required by Brady or the Michael Morton Act regarding disclosure of impeachment information. Number two, may have deprived the defense of impeachment information to which it was entitled. Number three, created greater long-term adverse impact on the disclosing analyst and the laboratory than if the lab had just addressed the errors and related corrective actions up front, as the disclosing analyst rightly expected would be done in accordance with the quality manual and related accreditation standards. Number four, sent the message to a member of the toxicology section that it is acceptable to not document issues that arise in the laboratory for fear of a tough cross-examination from the other side. And number five, undermined the HFSC board's long-term goal of providing service to both law enforcement and defense counsel. When the commission describes concerns regarding a potential chilling effect, it refers to a laboratory culture in which fear of potential adverse consequences discourages information from being communicated, either to management internally or to stakeholders outside the laboratory. In this case, the inequitable root cause analysis could certainly have a chilling effect on the inclination of analysts to self-disclose in the future. In fact, every analyst we interviewed, current and former, with knowledge of the case, expressed the opinion that the disclosing analyst was unfairly blamed for the reporting error. This commonly shared perception was of great concern to the commission, as was the interim manager's decision to, quote, keep things informal, end quote, for the reasons discussed above.
May I address that, or did I wait till the end of the section?
End of the section, please.
Yeah.
Notwithstanding these observations, the commission noted during its site visit that the analysts in the toxicology section, including the disclosing analysts, appear to be hardworking, dedicated, and honest people. Many of the analysts are early in their career with tremendous potential for future growth. The commission is optimistic that with the appropriate leadership, the staff will flourish and counteract any potential chilling concerns described above.
Okay. With regard to chilling effect, this is on page 28, I would remind the commission that the last time I spoke to the commission, which was very extemporaneous, I noted that what gave me the greatest heartburn in your discussion was the potential for a chilling effect, that is, persons employed or managed by the Forensic Science Center would feel like they were not able to report irregularities. And that is a very, very serious problem, and we have acted with policies and board directives to try to counteract this, because a chilling effect doesn't have to be intentional. It can be there if it's only perceived. And it is the job of management to be sure that no chilling effect is even perceived, and we want the commission to understand how important we think this is. With regard to people that the panel interviewed about the opinion that the disclosing analyst was unfairly blamed for the reporting error, all I can tell you is that we've talked to the same people, and they're telling different things to the commission than they are to management. And I guess the default is they must be telling the commission the truth, and they must be lying to management.
And do you find that surprising?
With the chilling effect, I think you've explained.
I think you're arguing against yourself.
Yeah, I think the chilling effect speaks for why there's a difference between what they told us and what they told management, and it's my hope that the changes that have been described, which I think are admirable and I hope will have the intended effect, will result in any future investigations having consistent explanations between the commission investigations and the management. At least that's my hope.
With regard to Dr. DeMaio's observation of arguing against myself, it's one of the overall themes of this is we look to this report for guidance. We're already responding to it for guidance. Let there be no mistake about that.
I'm not commenting on the report. I'm commenting on your argument about talking to them and never mind, it's not important.
But I note at the end of the day, I look at this and say, what is the commission's position? That the interim manager was unfairly negative to the disclosing analyst?
I think there were a couple of other
or
things.
unfairly positive in failing to report the shortcomings and document them. So we sort of meet ourselves coming and going about what exactly should we be telling the interim manager to do.
I think some of the changes you've already described answer your question again. That the fact that that there's a very clear message that there'll be no hiding or failing to document any problems kind of speaks to the importance of that particular issue. And we are not speaking to what I don't think the report is attributing any malice or ill intent. There's lots of explanations, including ill-equipped for the position, having too much work to do, the impossibility of wearing two hats. There's a number of things that could explain the conduct other than purposeful. We don't know what the answer is. And the purpose of the report, as I'm seeing it and as this commission wants it to be, is it just sets out the facts. We have no control over how it's interpreted. It's to give the lab guidance as to changes to make, and I think, again, some of the changes described speak to the fact that the concerns addressed, steps have been taken to make sure they don't happen in the future.
Would some of the changes that you've begun to implicate have been made if we did not issue this report?
An excellent point that I cannot say with confidence that they would have been made. I can say with confidence not all of them would have been made.
Thank
you. 6.
Lessons learned and recommendations. So corrective actions taken by HFSC management. I think we're going to need to add some things in these sections. So CAPA's 2014-11 and 2014-16 outline certain corrective actions taken by the laboratory as a result of this case. First, the lab's toxicology section suspended analyses where evidence may be associated with an incorrect case. The laboratory now includes in its reports any information related to identified inconsistencies in the analysis. At the time any inconsistency is detected, analysts may issue a report stating the issue has been identified and subsequent analysis will not be performed until the issue is resolved. In addition, the Quality Division reviewed 142 of 544 case records that had been previously technically and administratively reviewed by the interim manager. The purpose of the case record review was to evaluate the interim manager's case record review process to determine whether the fact that the interim manager missed the name error on tech and admin review was an isolated event. The Quality Division did not identify any major administrative issues nor suspect name and/or incident discrepancies in the reviewed case records. Minor administrative findings were noted and are described in Exhibit W to the report. The Harris County DA also requested photos be taken of the evidence upon receipt by the laboratory. The toxicology section is working to identify practical avenues to make the photos available at the time reviews are conducted. The lab will also have multiple employees conduct tech and admin review on particular case as opposed to a single reviewer per case. The laboratory also addressed the failure to track and resolve the submission form discrepancy through the appropriate CAPA process. At the time the CAPA in this case should have been resolved, the interim manager was in charge of both the toxicology section and the information technology for the entire laboratory. The Quality Division had one manager and one quality assurance criminalist. The laboratory has now hired additional staff in the toxicology and quality assurance units. A total of 5 additional quality assurance specialists were added to the lab's budget this year to implement various quality control measures throughout the laboratory. In addition, on November 26, 2014, the laboratory issued a progressive corrective action policy. Its purpose is to establish procedures for addressing the need for improvement in behavior and/or performance of employees of and civilians managed by the HFSC. This policy is distinct from the lab's CAPA policy in that it addresses the conduct of people working for the HFSC, whereas the CAPA process focuses on procedures those same people are expected to follow. In some circumstances, the substance of the two documents may overlap, as the quality manual acknowledges. While it is not the purpose or intent of this policy to single out an individual or section, it may occur as a byproduct of the process. The new policy emphasizes the need for equitable corrective action, which should address the concerns outlined in this report as the laboratory moves forward. Letter B, additional policy improvements made by the HFSC board. So, do we have any additions to this section in terms of actions taken by management, or is the new policy a board action, the one we discussed earlier on, the one that still, folks are still being trained on? Is that a board action or a management?
It was actually a policy that we initiated, management, but it was approved by the board. We don't take every policy to the board, but that one was so important that we asked them to look at it. Ms. Garcia, I would say that under, on page 29, under subheading A, all of that is true. If it would be, I guess, makes sense if the report were to acknowledge that this is not an exhaustive list. There are other things we've done, as I discussed at the beginning of this session.
I got a question. When the district attorney is asking for photos be taken, is this only in blood alcohol cases or in any case that is received in toxicology?
I have no idea.
Okay. I'm just curious about that. I mean, I understand they only care about what goes to a trial, but I was curious how broad this request was. I would like to know the answer. It's regardless of what we're doing here, but I'm just curious from a policy standpoint.
Or an expense standpoint.
Yes. Well, you know, cost of a digital photograph's not that great. You've got to enter it into the LIMS system, but I'm just curious whether what that really entails.
I'm sorry, I don't know.
I have no problem adding some language to the effect that these are examples of actions.
Select. Yes, use the word
that it's
select.
not an exhaustive list. Okay.
Do we need a motion for that?
Yeah, I think we need.
So moved.
Second. Aye. Aye. Nay.
Okay, so policy improvements made by the board. The HFSC board directed management to make several changes that have since been adopted by the laboratory. They include the following. On September 12th of 2014, the board approved a recommendation that a contract be executed with NMS Labs for technical and managerial support for the toxicology section. NMS personnel are now working on site. I do think we should add that they've hired a COO who's a PhD in toxicology. That's important. That goes to leadership.
Yes.
Okay.
So moved.
Put that in.
Added. Second.
Okay. Aye.
Aye. Aye.
Nay.
Okay.
Is there any need to discuss the qualification of that individual? No. Plus, I know the person, it's pretty impressive that they were able to get it.
Well,
You said PhD in toxicology?
PhD.
I mean,
Kind of speaks for itself.
I mean, maybe they hired someone great, but that's,
President of SOFT.
I can put that in there.
I mean, that just hasn't been good for you, but in terms of, you know, if it's a PhD in toxicology, it covers the field that they're going to oversee.
The board also directed that a process be developed to officially notify Houston Police Department management of any irregularities in evidence submission forms like the one subject of this complaint. The board directed a process be developed to notify the appropriate DA's office of any evidence irregularities as they are discovered. The HFSC president and CEO is working with the Harris County DA's office to develop this process. And I think we need to add here the new policy that's in the process of being trained that allows people to disclose to the accrediting body and whatever the regulatory authorities are without fear of recrimination or whatever it is that it
Policy regarding
says.
communications with third parties.
I'll add.
I have a copy, you have a copy of it, I have one with me.
Now, if that has not been rolled out yet, can we attach it as an exhibit?
It is in effect, it is rolled out, we just haven't gotten to the people who work nights.
Okay.
But
So
we've gotten
it is
most
Hasn't
of
been
it.
circulated.
So it is the rule, but
It is the rule.
but it has not been shared to the full extent that it's going to be
And
shared.
therefore, to be equitable, we wouldn't enforce it against someone who's never had
Okay.
the presentation.
Gotcha.
Ready to make a motion?
I move that we add that language to the draft.
Second? Aye.
Aye.
Nay.
Okay, are there any other things that need to be added to the board section of this?
Pretty much covers it.
And I can make the same qualifying statement that the following are examples of, in case there are other things that we left off.
All right.
Okay, additional recommendations. The commission makes the following recommendations in addition to the items initiated by the HFSC and its board. Number one, the quality director should revise the original CAPA to accurately reflect the root cause of the erroneous blood alcohol report discussed herein. While the disclosing analyst's contribution to the error should not be minimized, it should be represented appropriately within the context of the other facts in the case. Number two, the quality director has the authority to provide oversight in the development and issuance of CAPAs throughout the laboratory. She should be able to exercise that authority independently. This includes ensuring individuals with responsibility for errors not be afforded excessive discretion in drafting the CAPA, determining the root cause, and implementing related personnel consequences. In situations with potential conflicts of interest, the quality director should be especially vigilant in ensuring a fair and accurate root cause analysis. 3, it is essential for members of the toxicology section to have strong scientific leadership. The optimal solution would be to find a qualified permanent manager for the toxicology section who can effectively lead the section and nurture the development of junior analysts over time. If the only viable option is to fill the need through outsourcing to NMS, then NMS management must be continually present in the laboratory to provide oversight, guidance, and training as needed. Number 4, in the future, managers should not be simultaneously tasked with 2 major responsibilities, such as directing the toxicology section and managing information technology for the entire HFSC. The dynamic leaves the manager in an impossible position and is unfair to analysts who need regular direction. 5, all forensic analysts and managers at the HFSC and other laboratories statewide should receive quality training on the disclosure obligations set forth in Brady v. Maryland and related case law, as well as in Article 39.14 of the Texas Code of Criminal Procedure, referred to as the Michael Morton Act. This training should be conducted in collaboration with the Harris County District Attorney's Office and other customers so that expectations are shared. In addition, the Commission is developing a web-based training program in collaboration with the Texas Criminal Justice Integrity Unit and will make it available to all laboratories in Texas as soon as practicable. Number 6, HFSC personnel with any role in root cause analysis should receive quality training on the appropriate way to conduct such analysis. It is a challenging topic that may not come naturally to many laboratory personnel. The Commission will work to develop a quality training program on root cause analysis and make it available to laboratories statewide as soon as practicable. And then, I don't know if you all have other recommendations?
I don't think so. It's pretty exhaustive.
No.
No.
Any other comments?
I just want to say I think you've done a tremendous job, you've all done, and hopefully this will go a long way towards correcting any problems that may exist.
I think it'd be easiest if we just have one final vote adopting the report with the changes that we talked about.
Yeah, one final vote with all the changes.
Yeah, I do want to make one request of the laboratory. If you want objections to be included in a written format with the report itself, then I would ask that you submit those to me in writing so that I can include them. Because otherwise I'm just taking notes and I don't want to misinterpret anything that has been said.
Okay, I will consult with management and see how they want to proceed. It's so strange to me to be in a proceeding, there's not a court reporter, and it's like a trial, but it's not a trial, and so I'm not sure how to make the record. But I probably will take advantage of that, or because this is now available for the public, perhaps the objections I made on the tape will be sufficient. I'll let someone else decide that.
The video footage is available on the website of the whole meeting, so if you want to leave it at that, we can, but if you want me, when Lee and I put this whole thing in a PDF and put it out there, if you want a letter included that says, that explains it, please provide that to us so we can do that.
What's the timeline?
I guess we're going to.
I don't know.
The next meeting?
No.
No, before the next meeting.
We can approve it now? What, stipulating to the changes?
I'm just asking what the time, I think we need to vote on the report and the author to have something in writing. I think we need to have a short timeline on that. I mean, we can't leave that open, so.
If I'm going to get something to you, it will be within a week from today.
Okay. That's fair.
So
with that qualification, I move that the report.
Okay, well, we need someone to make a thing to approve this, incorporating the changes that we have made and correction of any grammatical errors.
So that's the first motion?
Second.
Second.
Aye.
Aye.
Yay.
We have, that means we're moving on to number
Is it 18?
18.
Thank you.
Thank you.
You didn't have to let me do this, and I appreciate it.
Okay.
18.
Yeah. We need a new vice head. Not vice head.
Vice
I'm sorry.
chair.
Vice chair. I think this has been going on too long. Vice chair. I nominate Dr. Bernard.
Second.
Second.
Aye.
Aye.
I abstain.
Discussion now that you've been voted in?
Now he's head of vice? Is that all right?
He runs the meeting when you can't make it, so that's the main job.
Yeah, so don't be gone that often.
So what about 19? I think they're...
Okay, so we do have some issues if you go back to tab 19.
Okay.
The only one we have left is the Blazer.
Right, so there is one investigative panel that has an open seat. It's a firearm tool mark case. It's the case involving the Swifts lab, so I don't know if no firearm. Well, it would give you good experience on an investigative panel. You don't have to have subject matter expertise.
Okay.
Y'all have none.
Put her on firearms? Okay.
Yeah.
I have none on anything that I've worked on so far, so that excuse is not going to stand you.
And he's not been hindered on having opinions on it either.
Which no science classes in college.
Microscopy.
We fixed that during the meeting. Dr. Eisenberg is chairing
Oh, okay.
that, so he's added to that panel. So that's good.
That's it.
Did you vote to add?
Yes.
Okay.
Oh, okay.
Oh, we need to, I so moved.
Make a motion, second.
Second.
Aye.
Aye.
Okay. We have 6.
Number 20 is the National Commission on Forensic Science. Do you want to say anything about that?
Yeah. Meets next week. They're finally going to begin to turn out some of the policy statements that up to this time they've been going back and forth and arguing definitions and such. One of them that's being considered has to do with the recommendation that all medical examiner's offices and coroner's offices be accredited, and that all investigators employed on a full-time basis and not police officers be certified, including coroners, which is going to be interesting. because of some of them, there are no investigators except one person in these coroner's offices. They did not touch medical examiners at this point, but we'll see.
I think is there a vote on report writing and testimony, a policy on that this upcoming week? I thought.
For what, autopsy reports?
For everything.
Oh.
I think you have a
Guidance
copy in here
on-
of what they're
yeah.
supposed to be considered.
I think we should include any adopted policies by the
Well,
National
they haven't,
Commission.
yeah, they haven't adopted anything yet.
Right.
It's going to begin
This next-
Thursday, Friday.
yeah.
No,
So
that'll be
whatever they
interesting.
vote on, we should,
That'll be an interesting
we
discussion.
will distribute it, and that way you can see what it
Okay.
is.
Let's see. Any, well, okay. Agenda items, what the National Commission adopts, I think that's the only thing.
We should put them in the binder for the next time so
Right.
people can look
If
at
they
them.
do.
And
Where
then-
we're going to meet.
Well, I just want to say something really quick about the meetings in Norman, Oklahoma of the Organization of Scientific Area Committees. It's like almost 600 people that were called together, and what they're trying to do is issue standards and guidelines in different areas of forensic science. I think about the only area that won't be necessarily be affected unless they want to be is the medical examiners, but everyone else is going to start having to follow the standards and guidelines because they will be incorporated into the supplemental standards that the accrediting bodies use when they audit laboratories. So that's the enforcement mechanism. Between that and federal grants is how they're going to roll it out. It's a very impressive undertaking.
Now, who's this?
The NIST OSAC.
Oh, the other side.
And what they're doing is not like they're coming up with standards and guidelines out of the air. They're taking existing SWIG material, looking at those standards and trying to figure out which ones are appropriate for adoption through the OSAC process. It is a very extensive process. You can't get a standard approved unless you've gone through like the ASTM process, which is an actual standard development organization. These are consensus standards, which means you have to get like 90% of anybody who cares about this area to agree before you can even move it forward. It's going to be a really interesting process. It's a huge undertaking that NIST has begun, and it could really change forensic science. Certainly starting with the accredited labs, but it is a very impressive undertaking. We'll just see where they go with it. I mean, to see the people gathered there, they're from all over the country, tons of people from Texas, all the labs. I mean, every committee that I'm involved with has somebody, except for drug chemistry, which I found odd, but everybody else, there's people from SWIFT, there are people from Harris County, from DPS. It's really a good thing.
The National Association, in regards to this, the National Association of Medical Examiners, at its last meeting, passed a resolution that that essentially that name will determine what the standards are. And they will not accept standards from any outside organization, which is essentially aimed at this.
Well, maybe the medical examiners won't get on board, but everybody else, it seems like, will. So we'll see
Well, it all
what
depends
happens.
on if the feds step in, then it doesn't really matter.
The feds can't, okay.
No.
I really shouldn't say this, but, okay. No, let me tell you something that you have to understand about the National Commission. It has no power to enforce any recommendation outside federal laboratories and agencies. And, in theory, I guess it could strongly encourage it by virtue of not giving you any federal monies. But since medical examiners' offices get between $0 and $0 in federal funds, it's academic.
And that's sort of why I say that all the other labs, though, all the other disciplines have tremendous incentive to try to help.
Money.
Well, not just money, but they're going to be audited for accreditation purposes against these standards. If the accrediting bodies agree to put them in the supplemental standards, it'll be They're audited against ISO 17025, then the supplemental standards, then the SOPs of the lab. So for that group of people, which is pretty much everybody outside the medical examiners, there's tremendous incentive to make sure that the standards are a collaborative process, that they're things that people can achieve in the labs, that they take into account all sorts of considerations. So they're really trying. There's no question that they're trying really hard to get it right.
Well, I think that's, I think that's laudable. The problem with the medical examiners is you can't get them to agree on even what ought to be autopsied or not autopsied, or that you ought to do microscopics on a certain case. So,
I mean, we have our own accreditation system.
Yeah.
Which is essentially that's the only one, unless you want to have the coroners, they have an accreditation system. And
Well, I guess you guys will just be marching to your own drum, but everybody else.
No, you don't understand. Doctors are like cats. And remember the thing, herding cats? That's it. No, actually, they did adopt standards a number of years ago. And, well, okay. And they did have standards, and
It really shouldn't be as difficult as it is, because there's some things that just make good common sense, but
Right.
that hasn't been a driving force apparently
No.
in that field.
no, automobile accidents and things like that, yeah.
I think public comments.
What?
Public
Right
comments.
now, wait a minute, we have to, we still haven't met when the meeting is, that's before the.
Oh, yeah. When do you want to meet?
Most everybody's gone.
Yeah, I know.
Do we still have a quorum? 1, 2, 3, 4, yeah, 5.
We could send an email around, but we have April 3rd, 10, 17, or 24. Which one's Easter?
Yeah, that's
Probably towards the
Don't
end.
ask me. Which one's Passover?
You want to meet on April Fool's Day?
Funny.
Is it?
I think it's early in the month, yes.
It's funny.
I should know the answer to that.
What we should probably do is check with the hotel about availability, and then
Well, yeah, do it
send
that way.
a doodle around on
Yeah,
the
so we can
dates,
pick
and then
some
we'll release
dates.
them.
Yeah.
Okay.
I'm really
Okay.
limited in
Any
April.
public,
I only really have
anybody
one
from the
weekend,
public who wants
or
to
one
speak?
Friday.
No.
so-
Send them back.
Okay.
Easter's the
Take-
first,
you can-
first weekend.
Okay, so Passover corresponds to Easter this year.
Okay.
You could take a motion to
think
That's
so.
Friday, I mean.
Motion
always
to
on the
adjourn?
Friday.
So
Yeah,
moved.
yeah.
Second.
Unanimous.
Do we have public comments?
That's always on a Friday, right?
We asked for public
Does that
comments,
work for
and,
you?
I already asked, no one.
right?